Shout out to C. Matthews, Morehouse man. Shout out.
Judge, we're before this court representing Mr. Marquavius Huey on this matter. There's an intrinsic act that was listed in the state's notice to us back in November of last year concerning item 43, which is an intrinsic act that the state is alleging should be coming into this trial. Your Honor, that particular intrinsic act stems from a November 30th, 2021 alleged incident. It's a police chase, Your Honor. In that police chase, the state are presenting to the court that this intrinsic act is somehow connected to this case and should come into evidence. That's the issue before the court. The rule that I'm asking this court to apply in this particular case obviously deals with intrinsic acts and what are the requirements for them to come in. As the court is aware, and I've cited for the court Murphy versus the state, 354 Georgia App 560. It's a 2020 case, and the case stands for the proposition that in order for intrinsic evidence to come in, evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions as the charged offense. So the charged offense in our case, Your Honor, is stemming from an October 1, 2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. According to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car. When you look at the video, there's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not a nexus to any of the charges. And so the vehicle would not make it necessary to complete the story of the alleged crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase, that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted up. So no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. There's no indication that they're able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because of he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Dunaway on the indicted case and was taken into custody in court.
When
So,
was that?
that would have been in 2000, it was in December of 2021. Okay, so he shows up in the court and he has been in custody ever since. So as it relates to this intrinsic act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced
Well,
by this coming
that
in.
was an effective assistance claim. That's
Sure.
a different kind of
Let him
procedural
cook.
stance.
Let
than what
him
you're
cook
talking
now.
about.
Agreed.
Let
but
him cook.
I agree.
I
What I'm
said,
asking the court to
let
look at is,
him
if this court says, hey,
cook.
look, I think that it is intrinsic. I do
Mhm.
think that it somehow meets one of those thresholds. Then
Right.
the court will go to the next step of whether or not there should be a 403 analysis
Sure.
to determine whether it comes in. So with that being said, in Hines versus the state that I previously cited,
Mhm.
there was an intrinsic act, and one of the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant, there was a word that was used that she maltreated or injured or harmed her children, and the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in. If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct. And that would prejudice Mr. Huey immensely here, because these are things that are going to go to his character. It's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me
Let
ask you
him
this.
cook.
Sure.
Is it possible
Let
that
him
if
cook
I
now.
determine
Let him cook.
that this
I
is
said
intrinsic,
let
that video
him
could be played
cook.
without the audio?
I imagine they could potentially play it without the audio. But there, you know, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by a preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November of 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, you know, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Some of y'all put sugar on y'all grits, so you can't tell me nothing.
Good afternoon, Your Honor.
Hello.
The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle. So they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over, but
Was he driving? I mean, did they
He
see
was
him get
driving.
into the driver's seat?
he was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. And
Mhm.
so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was.
Okay, well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have, and these are text messages from November 8th of 2021. He says, just wait till after Christmas and the new year and turn yourself in, see what they talking about.
All right, what? Okay, so, and the chase is November 30th. So this is several weeks before then.
Correct.
Okay.
And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. And I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the new year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least was going to, had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from November 8th of 2021. So that's the evidence that I would have.
All right,
outside.
well, I mean, given that he says, yeah, they might lock me up, maybe they won't. I don't think that, I mean, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but it's my ruling, so.
Thank you.
All right.
Wait, did they get chastised? What? Hold on.
Hold up.
Yo, hit that light for deal, yo.
Good morning, everybody. Grace and peace. I am totally like you. I was surprised. I was like, wait, the defense actually gets a W on something? I can't believe it. But here we are. So you saw the thumbnail, you saw the title. We are now on day 116 of the YSL trial. And we have no idea where we're going. We have no idea where this is going to go. Yesterday was actually pretty sparky, I think. Shout out to C. Matthews, Huey's attorney. He argued a fantastic case, shot down a lot of the foolish arguments that they were making, and they got the W. Shout out to Leah Abbasi. She's been arguing about intrinsic acts and such of that nature. And I believe she got a W as well. Shout out to Brian Steele. He argued in front of the Georgia Supreme Court on a totally different case, but I watched it and it was fantastic. I was going to actually play that this morning. But hey, the defense has been they've got a little bit of wind in their sail, so to speak, because my goodness, in the morning, Judge Whitaker as well as the state have just been a mean team. That's all I can say. They've been a mean team, those three. But hopefully the defense is going to come in today and again secure another W. I don't know if Judge Whitaker is going to speak directly and give a true, honest response to Doug Weinstein's motion to move this case forward. But if you pay attention during trial yesterday, Doug Weinstein was giving Judge Whitaker that face. You know, that face that you should have did the right thing face. He was giving her that all day. He was making, every time she was stumbling and fumbling and trying to coach and recoach and reteach the state how to do their jobs, all you saw was Doug Weinstein looking at her like. So hopefully she'll actually address that, which I think would be great. Because I don't think she wants to, because she knows Doug Weinstein, that writing that he did on Monday, if you're not familiar, Doug Weinstein wrote a motion to ask that the trial be moved fast, and that the court, who is the judge, would set some parameters and say, hey, you got to get this thing going. Now, you saw them yesterday. They were culling the herd of witnesses because at one point they still had like 100+ witnesses left. So they were culling that herd down and really paring it down, which is fine, even though the state should have been doing that, but I digress. But I think Judge Whitaker realized just how in over their heads the state actually is. And I don't think she fully conceptualized these people really, truly do not have a clue what they're doing. But let us go. We're going to see today. Today's going to be wild. Let's just say it loud and clear. It's going to be a wild day. So I appreciate it. It's like 380 of y'all have already tapped in. Thank you so much for hanging out with me. My name is Jason, Dear Woke Christian. I do social and political commentary from a Christian male perspective. We've found ourselves on this side of LawTube, and we've just been enjoying these cases. And I live here in Atlanta, down the street and around the corner a little piece from Fulton County. So I'm very interested in these Fulton County cases and such like that, as well as cases that you all have been interested in. So there'll be some new cases going to be coming up on the docket. See what I did there? New cases are going to be coming up on the docket soon enough. So I thank y'all so much for tapping in with us. To everybody, we got folk all the way from Australia. Yeah, I can't believe this. I cannot believe this when I say it. I'm not trying to be facetious. I am overwhelmed that people tap in. I appreciate my neighbors. I appreciate my state mates. But man, when you talk about people on the other side of the world, because David said it's 10:30 over there and he's tapping in, hanging out with us. There it is right there. He said it's 10:30. Look, that means a lot. So I really do appreciate you, David, all the way in Aussie land. One day, who knows, maybe Dear Woke Christian will do a meet and greet in Aussie. We can meet y'all and y'all can introduce me to these kangaroos. Because, man, that's crazy. Australia's got some crazy animals, too. So we might have a conversation about that. Good to see you, Becky. Always good to see you. Thank you so much. Here's my sister, Q. Y'all pray for my sister, Q. Good to see you, Kiana. Thank you so much. Marie, thank you so much for stopping in. Melinda's up in here. My new favorite, Pink, is here. Thank you so much. Good to see you this morning. I see Melinda. I saw you a second ago. I see you again. There goes Texas T is here. Thank you so much. Samson is here. Lots of good folk, new people, old people, day one, first days. I love it. Thank y'all so much, Robin, for stopping through, as well as Carolyn Speaks. I appreciate you. If you're a content creator, thank you so much for taking the time to hang out with us and tap in. Let me know what you do. Let me know if there's some way I can help and support you. I would love to do that. Oh, wait, we need a beard emoji. That could happen. Hey, I'm looking at some of these other content creators and they have some of the best emojis. Good to see you, Cuzzo. They got some great emojis. So, hey, you know what? We can get a beard emoji. That could be a thing. What do you think about a bitter lily? I think we could do that, right? I agree. Discernment is in the building. Yeah, she sided with the defense yesterday. I'm like, yo, I said, we got to stop the press. But let's just be honest. Matthews was cooking yesterday. I mean, he was bringing the noise. Okay, something I noticed, and I might be really reaching. I think when people address Judge Whitaker sternly and don't play a lot of games from the podium, they tend to be more successful. I'm not saying that's right. I just think that Matthews did the right thing by getting up there right in her face sternly, address the issue that was on hand. He seems like he's thought about what he was talking about. He wasn't doing a whole lot of pausing and researching and looking, kind of like what Hilton was doing. I think that's one of the reasons why he was successful. But I also think he just had a good argument too. Shout out to you. What's up, Missy Q? Love to see you. Amethyst is here. Good morning to you. Good morning. At the current moment, court, the cameras have not gone on yet. I think they start at 9 o'clock on the dot. So we got a little bit of time. But just in case, I want to make sure that we were up. We had the cameras ready just in case they go, they try to get in there a little bit early. Give the state time to tap in. Donna, I appreciate you so much, friend. Thank you so much. Make sure you we have a poll question up there. I appreciate y'all. What else I got? I got Tracy in the building. Tracy, good morning to you. Lots of new faces, I love it. I love it. Yeah, Black Gold. I would have disagreed with you a couple weeks ago, but now I can't see it any other way. I was like, Judge Whitaker, you're not even trying. You're not even trying to pretend like you're not. Like this is not cool. Wichita, Kansas in the building. Double M79. Good to see you. All right, let's see. Good to see you, Foster Cathead. Always good to see you. Yeah, Doug was not feeling it yesterday, but I think his argument was very clear. And here, I'm fanboying it because I thought it was an excellently written argument. I thought it was excellently written. But that being the case, though, it was very clear. It was very to the point. And for Judge Whitaker to try to do the judicial two-step in Heisman, matter of fact, Brian Steele called her out and said that the defense has been getting the Heisman. And in his argument to Judge Whitaker, I heard it this morning and I was going to clip it. I didn't get a chance to. He literally says, we've been getting the Heisman. And if you're familiar with the Heisman Trophy, let me show you what it is. And I thought that was very funny that he did that. All right, here it is. This is just a picture that's very popular, if you will, of the Heisman. Okay, so, and I thought it was very appropriate that he used it because I feel like this is how they've been treating y'all. On the screen is the Heisman Trophy, and it's a wonderful statue. I forgot the gentleman's first name, but his last name was Heisman. And in the early years of football, so he was very famous for clutching the ball and stiff arming the defense, or stiff arming his opponents with his right arm. And so later on, it actually became a trophy, the Heisman Trophy, and they give it to up and coming professional players and those who demonstrated veracity. But it's also known as like, hey, you're giving somebody the stiff arm, or you're giving somebody, I got the Heisman when I went and asked for extra credit in class, or I went and talked to the young lady at the mall and she gave me the stiff arm, whatever like that. So that's what he's talking about. And I thought it was funny that Brian Steele used that in the conversation yesterday. It went totally over everybody's head. I missed it. But when I listened to it again this morning, I said, all right, this guy is calling him out saying that he stiff armed him. I thought that was funny. Okay. And that was story time with Whitaker. Good to see Tina's up in here, and Pedro as well. Always good to see you. I absolutely love Doug is really growing on me for sure. That is true. We have kangaroo court here, and then I can go to Australia and meet Dave and actually meet kangaroos. There you go. I would love to know the history of the word kangaroo court. I got to look into that. Y'all in these hand signals. So they were doing hand signals yesterday? I was not paying. There's so much. Y'all see so much. That's the thing I like about this is because we're watching this together. And we got 504 pairs of eyes all seeing this thing from various and sundry. Some are listening, some are paying close attention, some are on a big screen, some are on the phones. And y'all just pick up stuff that I never saw. I had to go back and watch. Somebody was bringing up the Glanville and the signs and stuff, throwing gang symbols. Maybe they're throwing gang signs. Maybe they're a gang. I had to go back. So I have to go back. So yesterday, they were doing hand signals. Okay, now I can go back and look at that. Y'all crack me up with that. I absolutely love it. Cleveland, Ohio in the building. Brigida, thank you. Big Lou, what's up, my brother? Good to see you. Grace and peace, friend. All right, and I'm looking right now. Court has not started as of yet. They did put their thumbnail up, and it has a 14-minute timer. So they're planning to start at 9 o'clock. It wasn't up earlier. What's up, Lauren? Good to see you. Grace and peace to you. Oh, you need some more time in the day? Let me just go ahead and dial that in for you. Let me order you some more time of the day in the day. I'm gonna order from Temu, okay? Because you shop like a billionaire over there. So you just sit on the doorstep. It'll be right there. What's going on, Peter? Good to see you, sir. Grace and peace to you this morning. Thank you so much for tapping in, everybody. Interesting. Covered Confusion says, I've been thinking that shard is hindering the motions. Okay. I'll be honest with you. The fact that there's 6 or 7 different attorneys, different defendants with different attorneys, sometimes does come across to me as if they're not really all working together. So there are instances where I can kind of see that. I'm not gonna lie. I can kind of see that. Yeah. Even though they're not really a team, they're literally 6 or 7 defendants all kind of working in tandem with one another, but not necessarily working together. So I can kind of see that. And there's been some instances where I'm like, that has nothing to do with anything because it's not for the whole group. It's really for one person. But I think that's part of the diabolicalness. Diabolical. Is that a word? I think that's part of the insidiousness of the RICO is you get all these people together and they're all literally trying to protect and save their own necks. The state is lumping them all together as a team, and they're all trying to be like, yo, I'm trying to just go home and see my kids and my family. So I think that's part of it. And I can kind of see that. I can dig that for sure. What's going on, Terry? Good to see you so much. Appreciate you stopping through. I've watched a little bit of the DNC, I have to admit, and I told y'all I was going to and I wanted to. I was actually a little bit discouraged and I didn't want to watch. Some of the things that they were celebrating to me were not things that you should be accentuating. And I will just say this, and I know this is going to get, hopefully I don't lose anybody here, to watch people lyrically do some lyrical gymnastics for the destruction of little small human beings and call it all of this litany of things that you've kind of rephrased it and repackaged it in order to justify what is truly the elimination of a human being. It just is gross to me. So I'm sorry. I just kind of lost excitement because I was going to do it. I was like, oh yeah, we're going to do the DNC because I did the whole RNC. And I was like, you know what? Y'all can go kick rocks. So I do apologize. I don't want to turn this into a political diatribe, but they can go kick all the rocks between here and Pluto. Dixie Doodles is up in the building because you know what? She said, good morning, TWC gang. Appreciate you. Okay. I didn't like the kid. And hear me. I am not excusing bad behavior. I do think that Young Thug and his people did some things and have done some things that they need to be ashamed of, for sure. I do think that using the kid was a little bit gross, but that's the state. The state has been doing anything and everything. I bet you they got some more kid pics or heartstring pulling type of things in order, because they got to try to collect this W. And at the current moment, they know they are strongly in the L category. The judges are judging each round 10-7, 10-6. They know they're well behind in points. They have to knock out the opponent. And I don't think it's coming. I don't think it's going to happen. Wow. Colombia? Yo, when I say this, I mean it from the bottom of my heart. Thank you, everybody. Again, if you're right here down the street around the corner from me, or if you all the way in Colombia, all the way in the Philippines, all the way in Australia, wherever you're from, Canada, wherever, thank you so much for tapping in with us this morning. Thank you so much for jumping in. I'm glad to see you. Glad to see you. I'm glad to see Wealthy Wisdom up in here this morning. And Texas T is a new member. Welcome to the team. Thank you so much for joining. Yeah, I think Fisher hits it right here. I agree with the disappointment in Giggle Girl. Y'all don't call her Giggle Girl. Y'all are wild. I kept thinking that she would take the defense out at the knees during court, but alas, no. Yeah, I don't. Yeah, I have an opinion. I told y'all before why I think that she's not been hammering the state, but the state is, they're unruly. I'm not trying to be funny. I'm not trying to be dismissive. They're unruly children, and they've not been held accountable for being ruling. They have not been held accountable for doing their chores or whatnot like that. And it's just like, if you've not taught your children how to clean house, how to do laundry, how to do dishes, how to be responsible with their car, and you send them to college, don't scratch your head when they ruin stuff. Don't scratch your head when they totally they go off the rails, because you haven't trained them properly. These people are unruly. They have not been trained how to properly do homework. There's a lot of that stuff that they're doing. And I'm going to say this again. You do realize that most of the evidence that they're talking about is at least 8 years old. It's been in the Fulton County DA's office, in the locker, or wherever they keep evidence. It's been there. They could have prepared. Nothing stopped them from having a well ironed out. We got 100 witnesses that are going to slam dunk this case. We got them ... No. They literally just took everything they could and they're just throwing it against the wall to see what sticks. That's what it is. And that's not the way to do research. That's not the way to try a case. That's not the way to do pretty much anything, unless you're a professional, throw up against the wall, see what sticks type of person. So Judge Whitaker, I'm just going to say this. This is her. It is on her to hold them accountable to get this stuff done. We should not be doing this. Now, they did still have a week off for whatever reason that was passed down from Glanville. But a lot of this stuff could have been done before. I'll say it again. Fulton County needs an editor. Fulton County, it is a shame that y'all don't have an editor. You don't have somebody to edit your videos. That's a shame. Now, if you tell me that you do have an editor, that's even worse. So don't tell me you have an editor. Just say, we don't have an editor. Let that just be the shame. Because if you have an editor and the stuff that y'all have been presenting still looks like that, that person needs to be looking for a different job. That's it. That's it. There's no other way around that. I mean, the fact that you're playing 9.5 hours of jail interrogations and however long of phone calls, and it hasn't been edited and pared down to the most salient points that everybody can agree upon, I'm sorry. Y'all need to be ashamed of yourselves. But that's on Judge Whitaker. Judge Whitaker needs to get that little gavel and bang that thing and say, no, y'all not bringing this in here. You're not coming in here doing your homework, doing your class project in class. I thought about this morning. What we're watching is the largest group project ever. So imagine in college or high school, wherever, and you were put in groups. You had to do a group project, and it was going to be a pretty heavy, weighty project. And you had the slackers and the ones that are really trying to get it done. That's what we're watching in 4K with adults. And the only bad thing is they're getting paid for it. But we have the slackers who are not doing their homework. They say, "Oh yeah, they'll be the ones that bring all the evidence and all the research for the whole group," and they're not doing it. That's what we're watching, the largest group project ever. Maybe not ever, but you got my point. We're watching a large group project in 4K with adults that get paid to do it. That's crazy. That's crazy because I can't imagine the defense, if it were swapped and the defense had to be the ones that bring all the evidence or the ones that had all the files, I just can't believe that they would be this half-baked. I just refuse to believe that they would be this unprepared. And I got to find that video of Glanville chastising Brian Steele about being unprepared and unprofessional. And I'm going to juxtapose it against clips of the state being unprepared and unprofessional. One of them is going to be them all missing work at on Monday when they didn't come in on time. Yo, thank you so much, Amethyst Angel, starting the morning. Good gracious. The term kangaroo court may have originated in Britain in the 1700s. British courts began to sentence people convicted to various crimes and penal transportation to Australia. That makes perfect sense. That makes perfect sense. Dopeness. Thank you so much for the very kind super chat, for dropping the knowledge, kicking your boy a little bit of knowledge this morning. Thank you so much. Court has started. Let's go. I think so. They got the camera on, so they got 5 minutes. Okay. Thank you so much for that, Amethyst Angel. Thank you so much. Make you the Heisman Trophy. Joe, yep, O.J. Simpson had one. That was when I learned about it. Yep, very good. Come on, Terry. We got to hold out hope for no corruption. We got to hold out hope. I mean, when we were home with that straight arm on the state now, bang. His name is John Heisman. Okay, thank you. Thank you so much. There you go. JC be coming in. JC is one of my Twitter gangsters, man. I don't know how you be getting that stuff out there so fast. You are amazing. Un momento, por favor. I don't know how JC does it, but JC somehow or another has clips on Twitter faster than anybody I've ever seen. I'm like, I don't know how you do it, but shout out to you. The Black Robe Gang. That's a good one. I love it. I love it. Oh, she added a little bit more. Kangaroo court is an informal pejorative term for a court that ignores recognized standards of law and justice, carries little or no official standing in the territory within which it resides. You are right on the money. Then definitely we are watching a kangaroo court, Amethyst Angel, for sure. I think you had some more there. Yeah, this is one of those instances where I don't, Nigel, this is one of those instances where I'm like, I don't understand. I don't understand like how that should work out. You know, should he been severed? Brian Steele thinks that, yeah, God, he should have been severed. Weinstein says no. I don't get it. That's just one of those instances again with Rico. I feel like it's just a little bit confusing. Okay, she says typically convened ad hoc, a kangaroo court may ignore due process and come to a predetermined conclusion. The term also is used in a court held in legitimate judicial authority. Man, then yeah, we're watching kangaroo court. He was there. Yeah, I don't know where he was yesterday, Cuzzo. Yeah, that's where YSL Ponytail Harvey was, but he was there. He showed up at the end. So I don't know where he was earlier, but it is all good, Amethyst. It is all good. There he is. Good morning, present. Not perfect. Yeah, we are watching a very large group project. Like I can't think of a movie where they had like a high school movie where they had like a group project they had to get done. But that's what this is. This is just a giant group project. I see a head moving. But it's craziness. A South Aussie girl. Yo, look, I might have to do a meetup in Australia just because. Now, granted, Australia is probably 3 times as big as Georgia, but hey, whatever. Yo, this is crazy. Shout out to Australia. Send me a boomerang. That would be fun. Good morning. The Beats. Good to see you. Good to see you. All right. I see people walking past the camera. Oh, and by the way, if anybody's wondering, I still ain't got my Rule 22. So I'm just going to assume that it's not for me to have a Rule 22. If you're wondering, I put in a request to get a media credential so that I can be officially media and be able to, I'm just looking through real quick, double check my email, be able to stream from the court and kind of like what they're doing here with Law and Crime. And I don't have it, so I didn't get it. So I'm just going to assume that they probably just didn't give it to me. So anyway, I still will go down to court because I do enjoy that. And I do kind of like meeting some of these people and giving you like behind the scenes and such like that. I'll probably do a better job of actually interviewing the people and talking to them on camera when I get an opportunity. So that is where we are with the Rule 22. Who knows? Maybe I'll get it today. Who knows? The court is all kinds of kangaroo. This court, rather. Hey, Coco. Good to see you, friend. Grace and peace to you. All right. What is Cindy saying? Cindy says a lawyer should be appointed to the little boy to protect his rights as a minor. Okay. Though I agree with you, I wasn't clear when that video happened because the little boy, he could be old, he would still probably be a minor. You're right. Because he's probably like 6 in that video. And this probably is like 8 years ago. I don't know when the video happened, but most of this, yes, I'm thinking he's probably a little bit older, but you're probably more right than wrong. So yes, I agree. Good call out. So kangaroos really are that's what I've always wondered. Are like kangaroos like deer? Like we have deer here in Georgia and they're pretty, especially in a certain part of the season, they're all over the place. And I live in a pretty wilderness, foresty area. And there's a lot of them. So kangaroos are just like deer, just all over the place. That's crazy. I'm learning. I'm sorry. I absolutely love y'all. Yeah, this is the best live chat on the planet. I don't care what anybody says. Look, there's another one. Yo, we have a whole Aussie contingency. At least they're far enough they can't get RICO charges over there. I hope not, at least. But another Aussie. Man, we might have to, I think we need to do a meetup in Australia, y'all. Dear Will Christian just wants to go to Australia. I've always thought Australia looked cool. That, and now I know about Alaska. Like, these places look super cool. The fact that they're using memes and social media for proof of RICO is crazy. Now, social media as it relates to like showing pictures and stuff like that, I do think that that's self-incrimination, that's self-snitching. But I agree with you also, the memes, like, huh? And the thing is, Judge Whitaker is allowing Adrian Love to decipher and interpret the memes and the pictures to mean whatever she wants them to mean. To me, I think that's a lap too far, because I could easily just say, somebody could easily say, see, Coco is using purple hearts. And see, purple heart, that's in the Army. In the Army, you only get a purple heart when you injure. So see, Coco is trying to injure somebody. That's why she puts the purple heart. That's how I interpret it. What the heck are you talking about? Like, that's what it's like to me. Like, she's literally interpreting this for Judge Whitaker in the way that she wants it to go. Not that some universal belief that every time you see a purple heart, it means you're trying to hurt somebody. No, she's just interpreting it as such. And she's saying, well, 3 other people use it, so therefore they must all be a gang that want to hurt people. Therefore, I don't understand how she's getting away with it, in my opinion. So back to your point, I do think that it's not a universal understanding. So therefore, I mean, memes could do it. I mean, memes they can definitely convey an idea. I love using memes. But I can't say that, well, because you use this meme, that means just this one thing. I don't think that's a lap too far. I've been given a clean slate. Okay, well, good to see you. Good morning from Seattle, Washington. Good to see you. Most certainly good to see you, Chapo. Thank you so much. Thank you again, Amethyst Angel, for the very kind morning super chat. Thank you, love. Overt acts. Slime Lord is the boss. That's the case. I'm not saying that I don't think Young Thug has done some things that are grimy. I am not saying that. All I'm saying is I don't believe the state has done. They probably would be well served to get rid of RICO and discharge these men individually, because there are some individual acts that I think they probably could get them put in jail for. But the idea of lumping them all together to try to get life or whatever the RICO charge is, to me, you're betting big and you have to hit it. But if you bet small, you can still get some level of success and you wouldn't break the bank. Because it's like she's trying to break the house. And you're not gonna beat the house. I hope I use that euphemism correctly. Good to see you, Patrice. Patrice, good to see you. Grace and peace. And this is another thing I think is going to come out of this. Somebody asked a couple of days ago, what's gonna come of this case? I think they're gonna start looking at a lot of these cases that just think how many people Adrian Love has thrown in jail using the type of methodology that she's using right now. And the only reason we don't know about it is because it wasn't streamed, it wasn't a famous rapper, and it wasn't a rich person. But Adrian Love has probably shanghaied a ton of people like this. What if Fulton County has done this to other people? No, I'm saying, what if? They probably more than likely have. So I think that's going to be something that comes out of this, is that I don't know what kind of reform, but there's going to be a look back at some of these cases, because this is some shady dealings. This is some nasty work. Oh, it cuts into the Aruba funds? Man, I would love to do that. Still would love to go. Oh yeah, whatever happened to their class? I want that class streamed. I'm sorry. The state having to take that Brady course, that needs to be streamed. I'm sorry. We need to be able to watch that. We need to look, the people want to see that class. I want to know what they're being taught. What learning is going on up in there? I want to see the lesson plans. I want to see the rubric. I want to see the scope and sequence, all the nine. If it's 8 days or 8 hours, I want to see it. I want to see the lesson plan. I want to know the credentials of whoever's teaching it. Make sure they ain't got no Brady on them. Look, the people need to see that. We need our faith in Fulton County DA to be restored. I want to know if anybody finds out about that class, let me know though, because I haven't heard anything about it. I'm sure it's not going to be streamed. I'm being silly. I know that. But you know what? Sunshine came right in here this morning. Y'all just type sunshine, SUNSHINE. Just type it in the chat. Why? Because Sunshine said this. It's a money grab. I told y'all it's money laundering. All right, let's see what they got going on. Let's go. Drop a 1 in the chat when you can hear. They have not turned their mics on yet, though. He's got to do his morning pan around. Hey, Miss Westmoreland. I see you, Shard, back there. What's up, brother? Adams, good to see you, sir. Grace and peace to you. I see you. What's up, young thug? I see you. It's time to get them dreads cleaned. Hopefully sooner than later, brother.
Move to our set of next 30 witnesses and start going through that evidence. Oh, and sorry, let me circle back. I'm looking at my notes from yesterday. Mr. Harvey, you wanted to raise something about item number 74 with Dennis. We were going to look at the CAD reports also, so we can do both of those things before we get to the next grouping of witnesses.
That's correct, Judge, and we were waiting to see the court's order. The court's order dealt with essentially the admission of lyrics. Our challenge to, it's number 26, Dennis, item number 74, right?
Did the state find that order?
We did.
Okay.
Your Honor, we sent that order last night to court and all parties. Judge Glanfield's ruling on the lyrics.
Okay. I didn't see it in my email this morning, but maybe it's there now.
But would it be a fair characterization to say that it's the admission of the lyrics, and the court ruled on the admission of the lyrics? This is a video, and it is a video essentially with one of our co-defendants as the primary singer. And I believe it has Mr. Nichols in the background. So my challenge is not to the admission of the lyrics,
Okay.
but to the admission of the video. And I think the video should be admitted against, with all due respect, Mr. Jackson, but not admitted against Mr. Nichols. It's Mr. Jackson's video and Mr. Nichols is in the background. And that would be like saying, you know, if Gladys Knight and the Pips were singing, it would be admitting the actions of the Pips against Gladys Knight and that midnight train to Georgia. Not that I remember
Who's
that
who
song.
here? Jackson is Gladys and Nichols are the Pips.
The Pips, yes. Mr. Nichols
Shout out
is
to the Pips.
Okay. Well, I mean, you know, I guess I don't know, let me look at the video, but I would think that both Mr. Nichols
Okay, that was
and the
actually kind of
Pips
funny.
are in the background voluntarily.
Before you look at the video, can I just make an observation and a comment? My client's artistic expression, I want to put this in context. My client was arrested in 2005. The state has, not until 2022, I guess, got around to trying this case.
Uh-huh.
Mr. Mr. Stillwell was rapping, and he dared to say in his rap song, "I beat a murder rap, paid my lawyer 30 for that." Because a reasonable person would believe that he had been arrested for murder and beat it because he had been released and no one had tried him. I have no idea how this has become some sort of admission saying I beat a murder rap, because he was arrested for murder and he did beat it. I have no idea the relevance of this. He's just stating I've been arrested for murder, which is clearly true. And he beat it because he was out on bond. So I have no idea why this is admissible against anyone. I have no idea why it's relevant. I agree with Mr. Harvey that the fact that Mr. Nichols is in the background shouldn't come in either, but I don't believe that this should come in against my client. I think that this whole ruling is out of left field, respectfully, and that's our stance on it. I just wanted to provide that context before you viewed the video, because that's what it is. It's years after he had been arrested for murder.
When's the video from?
I don't
2019, we believe.
2019. So it's 4 years. The state says 2019. I'm not certain, but according to the state, it's 4 years after he had been arrested. He had been released, and no one had tried him on the murder, which he's innocent of. And he was merely stating, I beat a murder rap. So I don't know why any of this is coming in, but I appreciate Mr. Harvey's point that nothing came out of his client's mouth either.
Yeah, it's not an assertion under 801 D2E. So I don't see it coming in with regard to Mr. Nichols. And I adopt everything that Mr. Shart just said as well.
Interest either, Your Honor. It's not against any interest. It's not anything that's inculpatory.
Talk into the mic because they can't hear you back there.
Good morning, Judge.
Good morning.
I'm not sure that it's against any interest. It's not anything that's inculpatory.
Well, I think that might just be a statement by a party opponent.
All
Your
right,
Honor.
but my client made no assertion.
I'm talking about as to Mr. Jackson himself.
Your Honor, I would point the court's attention as well in response to Mr. Nichols' assertion to page 8 and 9 of the order.
Okay, I still don't have the order in front of me, so
Send it to the
Your Honor, I already said it. It was sent at 4:47.
okay.
I'm starting to think that some of y'all only come here because you want to watch Matthews talk. I'm starting to feel that kind of way, Shanna. I'm starting to feel that way. It's all good though. Look at this. I'm feeling like that's the only reason y'all stop by now. Yo, shout out to Harvey for throwing the pips in the RICO. The pips, Gladys Knight and the pips are now under RICO. That was hilarious. That was well done though. Look, you got all of y'all, man, y'all are wild. Love, it's too early in the morning. Just be quiet. Just be quiet. That was a good one, though. I have to admit, I like the way he did that. And it was a little lighthearted. It was kind of fun. Okay, there we go. Thank you then, Shanna. I'll take it. That is hilarious, though. I mean,
court.
Okay, here we go. Let's see what we got.
Send it to Ms. Percival.
I got it.
Okay.
She's sent it.
hey, Mandy, good morning to you, friend.
Page 8 and 9. You're welcome.
Yeah, Brian Steele is not in the office today. I mean, he's in the office today. He's not in court.
The subsection G.
Yes, Your Honor. Specifically, the court finds that contrary
Yeah.
Oh, yes,
I
I'm
can
sorry.
read it.
Okay.
That goes to the lyrics. Yeah, that's irrelevant.
I hope not. I hope
Yes,
not.
subsection M.
M also? Okay.
I think the idea that rap or song boasting is literally like self-incriminating confession of crimes and sins, that is crazy to me. Like, wait, do you really believe? I've never thought that some of these people did
27.
All right.
some of the things they said they were doing.
And then there's a section 9, Roman numeral 9.
I just never would have thought that was. I didn't think it was good, like to talk about shooting and killing and murdering. Never would have thought it was good. I just never thought that they were like self-incriminating testimonies, like they had actually done that. I never, until now, I've never actually thought that you would actually believe that they were doing that. I just didn't think that. Man. Thank you so much, Joe.
finally,
Good morning. I'm
it's on
doing
page
quite well. Thank you.
41 as against Mr.
Hey,
Nichols.
Mandy, thank you so much. Hit that like button. Thank you for the super chat. Thank you. She got her own interpretation of everything, though. Not just the law. She interprets lyrics. She interprets your thoughts, your memes, your emojis. You know, the fact that my hat, the A, the undercolor of the bill, and my shirt all match. She's going to interpret that how she sees fit. That's weird to me. I really hope and pray they stop letting her get away with that.
Murder case that Mr. Stillwell Jackson was arrested on and then not tried on or whatever happened. Is that asserted in this?
Yes, that's who Matthews is.
Indictment as an overt act?
It's count 2. And it's one of the overt
Oh,
acts.
okay. So it's the Thomas murder.
Yes.
Okay.
I'm just here so I don't get a RICO. That's it. That's the only reason I'm tapping in. I don't know what they were.
All right. I'm familiarized myself with those parts of that ruling now. If you want me to watch the video, I will. But it appears that, is it on Zoom? Okay, let me get on Zoom. All right, go ahead.
That's Stillwell? That's him? Wow, he looks totally different.
All right, I don't see any reason to revisit the ruling.
Well, it wasn't,
With regard to the, so if we don't show the video, then I mean, the state intends for it to come in as against everybody, and there's no way for it to do that if the jury doesn't see everybody in the background.
Well, if it comes in, I don't think it should come in against Mr. Nichols. It should come in against Mr. Stillwell. And I would again ask for a 105 instruction with regard to this. It is again, Mr. Nichols is just a person in the background.
Who chose to be in the background. So y'all can argue the same thing you've argued to me, which is, okay, all this is a song. But the state can argue what it wants to argue. The ruling, I don't see, again, any reason to revisit that. And with regard to the video itself, it would be the same rulings. Okay. So how
Wow.
about the CAD calls? Or not CAD calls, CAD reports.
Wild.
So I think we found these in, what folder do we need to look to for
Wow.
these?
Witness 19, Sharon Latner's, Your Honor, in the 8 August 24, 1 through 30.
Okay, thank you. All right, do any of the defendants want to make a hearsay or other objection to any of these CAD reports or portions of CAD reports? Sure.
Group project study hall court is in session. I saw that earlier. Somebody did suggest that.
Yes.
All right, so, and I'm really what I'm doing is repeating an objection that we've made previously. Ms. Latner has testified numerous times before. She's come in regards to various 911 calls that have been made. And our objection has been and continues to be objecting to any hearsay that would be contained in.
Right, so point out for me now the hearsay so that we can make a ruling on that.
All right, so we're probably gonna have to go through them one by one. And if
That's fine.
with the court's permission, if I may retake my seat and kind of.
All right.
I think he should go up to the podium, though. I think he should go to the podium.
Under the Latner's file, the first CAD report, when you open it, it says page 4 of, I'm sorry, 1JJ CAD report at the top.
Yeah, it says that on the,
It's
yeah,
printed date is 6/22/2022. If that.
yes,
All right. And so I'm going to go to page 4
okay.
of that, page 404, where there's a statement under CAD narrative. Under remarks says number 78, shots on call, 6 to 7 vehicles shot up at location. My position is that that's going to be, I don't know who the
talk into your mic a little bit better if you can.
A little closer. Is that any better?
Yeah.
All right. So my position is going to be that that's going to be a hearsay statement. We don't know where that information comes from, the accuracy of that information, who it is that's speaking, and so we would object to that coming in and ask that be taken out from that particular CAD report.
So, Your Honor, this is 1J is a self-initiated, it's an officer initiated. There's not a 911 call for this specific 1JJ, there is for 1JJA. And so this is received at the top on page 1, it's received at 2:20:41, so 2:20 in the morning. And 2517 Donald Lee Hollowell is Club Crucial. And if you look at what Mr. Adams just annotated, that first, there's no 78, which means there's no suspect. Shots on call, 6 to 7 vehicles shot up. There was 6 or 7 vehicles parked in the parking lot of Club Crucial shot up. And that time hack is 2:20:41. So when the officer initiated this CAD, the state views this specific one as essentially a present sense impression of the officer who's trying to get help. He's literally there. This is all from radio traffic, and the computer aided dispatch CAD gets generated. So he is in real time stating there's 6 or 7 vehicles that are shot up and to get officers to come. So the state feels that that hearsay exception to this is appropriate.
All right, I'm going to overrule the hearsay objection based on 803-1. What's next?
Your Honor, the second one is 1JJA.
All right,
At the bottom in the narrative, at 2:21:28 a.m., says heard about 30 shots. I'm not
State's-
sure who the declarant is.
all right, state's response. I mean, I think everybody's probably going to concede all of this is hearsay. It's just a question of whether there is an applicable exception.
Yes, Your Honor, and this comes from the 911 call that the state would also be playing. So this CAD report, unlike the one we just addressed, came from a citizen in a neighborhood like very close to Club Crucial, and she states on that 911 call that's pretty brief, just heard, she says, heard about, she's on Woods Drive, and she says, don't come to my address, but I just heard a lot of gunshots. I don't want to give my name. And so the state feels that, for one, her calling is an excited utterance from hearing gunshots in her neighborhood. And number two, this 911 call is very brief. She is not, there's not a confrontation clause with that statement because she's not making that call to prosecute someone. She doesn't even want to give her name nor know who did these gunshots in her neighborhood. So this CAD report is in conjunction with the 911 call that generated the CAD.
All right, that would come under the 803-1 and 2 exceptions, so I'll overrule that objection.
Judge, the next one, we're going to skip because I believe the third one down.
Speaking to your mic, come on, man.
911 call.
Okay.
So if we look at the fourth one down, which is 1KK CAD report,
Okay.
when you open it, it's more than just a CAD report, it's a police report. But
Is the state intending to put the police report in?
Your Honor, that was a typographical error, and I can actually publish, when I uploaded these documents to the Dropbox, I had a version where that was just the PDF, and I removed everything to just include the single CAD. So for purposes of this, I meant to just, it's embedded in the 28-page PDF, but
Okay, you're just going to be using the CAD report part. of it.
correct. And specifically the CAD that ends in 455. But for time's sake, I don't want the court or defense to look through those 28 pages. I'm happy to
Appreciate it.
publish. Okay.
Go ahead.
I'm going to join the Zoom right now, Your Honor.
Okay.
Mr. Atkins, is that the CAD report that if I'm looking at 1KK that starts at page 14 of 38, is that right?
I don't have the original PDF I got this from, but the CAD ends in 455 and it's a single page CAD report, if that helps.
see, I see one that ends in 455. It looks like it's maybe on, it looks like it might be the last page, page 38 of 38 on what we're looking at.
I see it.
All right. And what's the objection?
All right, same here, so objection. If you look at the bottom of the CAD report, there's going to be information by a declarant indicating call advised. You heard 8 shots fired in the area. That's the last line of the CAD report. My position is that that's not the officer reporting. That's simply the officer reporting what was reported, and so that would be hearsay. We'd object to that.
Your Honor, the 911 call that corresponds, there's multiple 911 calls for this incident. The caller advises he heard 8 shots in the neighborhood, and he states he does not want to speak with an officer. He, again, wants police to come to his house. I think it's about a minute or so. It's a short call. So the state's position is it's a excited utterance from the neighbor calling after he heard 8 gunshots.
All right. That would be an exception under 803, 1 and 2. What's next?
Your Honor, 1LL.
Okay.
It's in the narrative, it says heard 9 gunshots fired near parking deck.
Okay.
At 5, and it, according to the CAD report, it's 5:52:18 a.m.
State's response.
Yes, Your Honor, that's, so we've skipped for a second because there's other CAD and 911s for, so I'm switching to 1LL. Give me 1 second. Yeah, so this 911 call, the caller, so the incident happens at 1903 Drew Drive, and the 911 call that corresponds with 587, which is 1LL, she says, I just woke up and heard about 9 gunshots. It came from the parking deck. This is an apartment. She gives her phone number, the apartment, and the gate code so officers can get in. She does not see anyone. And then she says she does not have to speak with an officer, just heard a lot of gunshots. So the state's position, again, is excited utterance and not for the purposes of prosecution in terms of confrontation clause analysis, because that, my apologies, Madam Court Reporter, the heard 9 gunshots near parking deck is the CAD report automating what the 911 caller audio, which we have, states.
All right. That would also fall under the 803, 1 and 2 exceptions. What's next?
I think we're going to have to jump down a bit to what looks to be 2LL CAD report.
Okay.
I believe that ends in incident number 588.
Yep.
It's a 3-page CAD report. On page 2 of 3, there is at 4/28/2015, 5:52, there's an annotation that caller advised she heard banging on her window. Nothing further. And then a line beneath that where it says there's actually a description. I'm unclear as to whether or not that is a description being relayed by the officer or a description that was given to the officer by a declarant that we don't know who it is, where it says 78C-BF, dark skin, head wrap, black shirt.
Okay. Mr. Atkins.
Yes, Your Honor. And with this CAD report, the state, you can get CAD reports in present time, but I don't have the 911 audio that accompanies this, so I can't state for the court. So the state can redact that specific line because
Okay.
I can't articulate
All right.
how that came about.
All right. Y'all can go ahead and redact that then. What's next?
3KK, 4/28/2015 at 4:05 a.m. There's a note, do not see CLR. I believe that might be caller.
Yeah.
Caller heard multiple gunshots in the area. That appears to be a police officer after the fact relaying that they cannot find the caller who previously had stated
Right.
that they heard multiple gunshots in the area. So that does not seem to fall under any
No.
exception.
I agree.
And Your Honor, to be clear, are we talking about 3KK?
Yes,
Three
sir.
KK, yeah.
So this actually is a 911 call, and the caller advised they heard, we have that audio. The caller advised heard 8 shots fired in the area. They say someone is firing off AKs in the neighborhood.
So
Yes, Your Honor.
this is a one-page report, right? And we're down at the bottom, under the narrative, the third line at 4:05:20, do not see CLR heard multiple gunshots in the area. Can you address that?
Give me 1 second, Your Honor.
Sure.
I may have misnumbered my 3, maybe. Let me see. Okay, my apologies. My numbers were 1 off.
It's okay.
There is a 911 call for this. It's
Mhm.
very hard to hear. The person's just, I can play it. It's only like a minute. But essentially, that 911 call that accompanies this, and it says source E911 call. He's saying that he hears shots. It's hard to make out the totality of what he states because he's just not speaking into the cell phone very clearly. But my understanding is that comes from his call.
All right, why don't we just listen to
Okay.
it?
Yes, Your Honor.
Atlanta 911, operator 209. What is the address of your emergency? Okay, do you need the police, fire, ambulance service? You need the police?
Yes, it seemed like there's a time.
Okay, can you try to speak a little louder? We have a bad connection. I can barely hear you.
Can you hear me now?
It's a little bit better.
Okay, I'm saying that it seems like there's some type of time not for something going on in my neighborhood.
Okay, and you said you're at 1469 Mims Street. Do you want to meet with the police when they come out?
No, I just send them out.
Okay, how many shots did you hear?
It was like a whole round.
Okay, all right. We'll send the police out to check the area. Do you want to leave your name and number? Okay, Mr. Moore, verify the phone number you're calling from. 404-758-3914. All right, we'll send the police out to check, okay?
Okay.
Thank you.
All right, so the caller heard multiple gunshots seems to be something that the caller reports on the call, but do not see caller. I don't know where that comes from unless it's from.
Your Honor, I see what the court is stating. At 4:05, so the call comes in at 4:03:37, and because there's multiple 911 calls, there's already officers heading that way, and so this isn't the first call, and so a minute and 20 seconds later almost is an officer radioing, I do not see the caller. Caller heard multiple gunshots in the area. So I think they're just parroting back the 911 call.
Right.
I don't have any problem redacting that. I do view it as the officer's present sense impression, but I don't know why it reparrots the caller heard multiple gunshots because obviously he didn't speak with someone because he says he can't find him. And that caller didn't want to come outside and speak. So I don't have any problem redacting that third line, Your Honor.
Okay. Thank you.
Yes, Your Honor.
What's next?
Yeah. All right. Your Honor, the next one is 4KK CAD report. It's second to the last entry. It is a 2-page CAD report. On page 2 of the CAD report, towards the bottom under a CAD narrative, there is at 4/28/2015, 4:06:28 a.m., female shot. I concede I don't know what KF08
Yeah.
means. Night commander copies female grazed by bullet. Caller stated someone shot up house. Looks like it says Supervisor Arnold and Denson, and I don't know what the rest means, but that's obviously, and it notates that there's a female caller. So this information is obviously being, not obviously, it appears to be being relayed by a female caller. We don't know who that declarant is, whether or not the caller, it's being offered for the truth of the matter asserted that someone shot up a house, and we don't actually know.
All right, maybe we just need to listen to this one.
Yes, Your Honor. And I think it is coming from the 911 call. I will play the 911 call for this one. It's a little bit longer. It's like 6 minutes.
Well, you can just get to the part of it that matters.
Yes, Your Honor.
Put that weed out. I'm calling. Atlanta 911, operator 6587. What is the address of your emergency?
Someone just turned a shot on my house and my auntie got shot.
Okay. Okay, what's the address?
1428
1428
Adair Avenue.
Adair?
30314.
Is this in a house or an apartment?
You said what, ma'am?
Is this a house or an apartment?
A house?
Okay, that's Adair Avenue Northeast? Southeast?
I thought it's southeast.
Okay.
1428 Adair Avenue, Atlanta, Georgia, 30314.
Okay, it's not coming up southeast.
And Your Honor, around 2 minutes and 31 seconds, this gets to the female being grazed, so I'm going to jump to that.
Okay.
All right, and what's your name?
Dominique.
Okay, Don, can you tell me what happened?
I was just, I woke up to gunshot. Somebody just told me they were shooting up the house.
Okay, was anyone shot?
Yes, ma'am.
Okay. Are you with the patient right now?
She's lying in the bed.
Okay. Are you with her right now?
You said what, ma'am?
Are you with her right now, Simon?
Yes, ma'am.
Okay, how old is she?
She is. The bullet didn't go through. She got straight. But she is, how you have this way?
And the reason I highlight that part, she says the bullet did not go straight, which is
Right.
how the CAD report ends up reflecting female grazed by bullet because her aunt was shot.
Okay, I mean, other than the night commander copies part of that, that's all the caller obviously relaying what just happened. So that would fall under the same exceptions as the others. Do you intend to, I mean, the night commander copies part, can you
I can redact that, Your
redact
Honor.
that out? Okay.
Yes, Your Honor.
All right, what's next? Is there anything else?
I believe that's it.
Okay. All right. The other thing I had written down from yesterday was Mr. Stillwell jail calls, if y'all are ready on that. If not, we'll just move on to the next.
I'm ready, Your Honor, just thinking about the most logical way to address these issues. They're about 14, 15-minute calls. The state has, to my knowledge, not given any clear direction on what they plan to play. So I think that maybe it makes more sense for them to propose what is admissible.
Okay.
And then I can respond.
All right, and Ms. Hilton, is this the one that you sent over that was like in a spreadsheet, or where would I go? What's the best way to go find these?
No, Your Honor, that was the co-conspirator statement.
Okay,
But in the same Dropbox, these are all in the Mike Sprinkle folder,
okay.
under Shannon Stillwell.
Okay.
Your Honor.
And Your Honor, it may do well for us to have a conversation at a break with Mr. Sharp and counsel, because there are some that we've identified that we will not use, and then there are redactions that we have.
All right, I was hoping you would have provided that information to them before now so that we could get right to what we still need to litigate.
As there were some that were excluded as late as last night, I can address them, some of
Okay,
them.
all right, why don't we
Okay.
take such a break right now then?
All right.
All right. First commercial break. What do y'all think? I'm going to leave it up just in case they jump back in sooner than later. What do y'all think in the chat? What do y'all think? Somebody ordering some redactions from Home Depot. I see that. Yeah, I don't know. Is Kayla available? I don't know. Homework break, right? They got to go sharpen the pencils. Poor Doug. Doug looks really stressed out. He's looking like, Lord have mercy. I done told these people. Same mess, different day. I agree. Homework break. What in the love is going on? Love should had this case ready for that's my argument for sure. She gets off yet again. Breaks. I like what you did there. Taxpayers' money. I'm done thinking. This case is wild. I agree. Love hurts. Okay, I see that. I see it. With prejudice, this trial that misses. I see where you did there. We're paying for this. Yeah, we're paying for the entertainment or lack thereof. All right. Yeah, I'm kind of wondering. I would love to, again, just talk to some of these lawyers, maybe when this is all over with. Well, Doug Weinstein talks about it kind of regularly, but he's not, he doesn't violate what he shouldn't talk about, but he's pretty clear of his, what he thinks about this trial. She was tossing a little bit of shade. I can see that. Yeah. Doug is stressed because he knows he's fighting an uphill battle against the FC Fulton County and the judge helping the state convict his client. I'm with you. When at first you try to deceive, case file, hiding information continuously. It's wild. FYI, there are no honest lawyers. Okay. Love doesn't do any of her homework. Which one is Doug Weinstein? Okay, let me just roll it back real quick.
To my knowledge.
All right, right here on the screen, this gentleman that has his hand, he's literally over, let me get this out of the way. Stanley Horton, this white gentleman in the middle of the screen right here, he has his hand on his head and he's sitting next to Mr. Kendricks in the dark blue suit. That's Doug Weinstein. He just looks like he's had enough of it. He's just got his hand plastered to the side of his head like, just let this stop, Lord. Let this stop. All right. So, yeah, that was it. Let me bring this back. Make sure we're ready when it comes back. All right, so all right. What we got? What we got? All right, so I got that ready queued up. Hey, no problem, Stanley. No problem at all. Mr. Steele is doing work today, Aussie girl. He is doing work. So he asked the court yesterday, it was sometime in the afternoon, could he not come in? His client, Mr. Williams, young thug, said it was okay. And he asked the court if it was okay for him to not come in today because he's got work to do for a case tomorrow or Friday. I think it is one of those days. Fill me in. I was busy chatting. What did we miss? That's unequivocal. BT Thomas, it does seem like that's part of the, in my opinion, that's yet another problem with RICO. If you can throw other things in, it just seems like once you get somebody, okay, we got some black men that are part of a group and they've committed some crimes. So now, in that community, there were some other crimes committed. And we can tie the people who committed those crimes to the original group. So they're part of a large enterprise. It just seems like you can just keep compounding, in my opinion. That's what I think is the problem with RICO and why it gets into so much, it's going to get into trouble here, is you're just literally throwing everything in there because it's kind of like when you go to a grocery store and everything that fits in this bag is a certain amount and you're just putting stuff in there until it's literally causing the bag to burst. They might not still do that. That might be old. Yeah, let me get a few more of them likes. Help a brother out. What we looking like over here? Almost 750 watching, which is amazing. So much to everybody, 708 that are watching, and a little under 400 likes. Thank you so much. I appreciate it. You think she likes him? Okay. Atkins has been super quiet, so it's probably his moment to get up and get some shine. No. Thor's paralegal. This is what we're watching. This is why we affectionately call this study hall court, because they're literally doing the homework in court. All right, let's see. What's going on, Courtaholic? Good to see you. Thank you so much for stopping through this morning. Back for a minute. What did you miss? A whole bunch of W's for the state. Fill in Kiana, please. Fill her in. They were born, therefore they're RICO. I hate to say it, but I think it's really gotten down to that level of policing. They make great arguments. I think Westmoreland, Leah, Abbasi, they've made some fantastic arguments. I think when you have good lawyers, they make good arguments. Because I think even though I don't agree with some of their cases, I think Shard makes fantastic arguments. Harvey makes great arguments. It's just, they just have good argumentation. All right. Yeah. Love is like, it's wild to watch her stumble, man. It's kind of crazy. It is wild. But what isn't wild is today. So I really do appreciate you. Thank you again. Every last one of y'all. Let me just real quick see. Okay. I'm just refreshing on my other screen to make sure I'm it has not come back. They've been doing pretty good lately. They are taking a lot of breaks. I'm going to give you that. I'm not keen on the breaks now, but I think Shard does start to waffle when he's not solid in his argument. And he's just like, let me just try this, see if it works. He's not committed. When he's not committed, it does come across very unsure, in my opinion. Thank you so much, Cammie. Remind everybody, like this video. Check it out. Oh, it was thrown out pre-trial. There we go. All right, good to see you, Gladiator Girl. Thank you so much for stopping by. Shuri, Mr. Matthews' client his last name is Huey, and I forgot his first name. I have to look it up, but he's a young, Matthews is an older black man with a white beard sitting next to a young guy in a moss green sweater today. I don't know if his other co-counsel is a younger black man with a black beard to his right. I don't think he's here today, but you know what? We ain't got anything. Let's look real quick. I don't think he's here. Let me see. I'm just scrubbing through real quick. Usually they do like a morning pan through to see who's all here.
I can't hear you back.
All right. So real quick, I'll just pull it in since we're just. All right. So that's Matthews in the brown suit, blue tie. And that's Huey. What's Huey's first name? Does anybody know? Oh, Marquavius Huey. There we go. So that's Marquavius Huey. And then there's another lawyer, usually to his right, to Marquavius's right. I don't see him today. His name is also Matthews because he is the junior to the father who is senior. Caton. I know I'm
Good morning,
mispronouncing
Judge.
his name.
Good morning.
I'm not sure that it's
Yes.
against any interest.
The other
It's
counsel's
not-
not there today. But that's him. Thank you so much. Man, thank you so much for the very kind super chat. Mel coming through the $20 super chat, just giving some love. I appreciate, man, the support. I appreciate you tapping in with us on a regular basis. I've seen your comments and I really appreciate that, man. Thank you so much. Y'all in these lyrics, man, like I would hate for them. I never would have thought that. Now, I always thought that, for example, rap lyrics in the 80s and the late 80s going into the 90s, I did think they glorified crime and they made light of crime, but I never thought that these people were actually snitching on themselves doing said crime. I'd never thought that. I always thought that they were just speaking on it and making it look cool. But again, not saying that that's a good thing. I'm just saying I never thought that, Ice Cube was saying like he literally killed somebody, or that I never would have thought that. Or Ice-T. I never thought Ice-T really was the original gangster. I never thought that. Eazy-E literally did that. I just didn't think that. Okay, so I would hate to I just never thought that, man. I just thought that was wild. And the fact that the man is in a rap song and somebody's rapping it, that's crazy that that's going to be used against them, but I guess so. If two random people get into a fight at the green store, they part of the RICO. I mean, That's how loose it's getting. I mean, it's pretty loose and wobbly, in my opinion. It's pretty loose and wobbly for sure. All right. I appreciate it though, but good conversation back and forth. I appreciate the chat. Thank y'all so much for getting in there, grinding it out, talking it out, getting it figured out. Thug mode. What is thug mode? Thug made us feel like we're slime in our heads. Okay. And this is another great point. Most rappers don't write their lyrics. I mean, so I think that one is definitely that's definitely a very contested area of using rap lyrics, especially when you consider that there are ghostwriters. Thor's paralegal, hey, look, when you find it, let us know, because we don't know either. We're looking for the Rico too. We looking. Where you at, Rico? Where you at? I don't think we have it either. So definitely looking for it, my friend. But back here, Amethyst, thank you so much for that. Thank you so much for the $2 super. Thor's paralegal. Yeah, I just think that's a slippery slope, man. Like, because how far away is it to say, well, why would you not say that an actor or actress that kills people in a movie are equally culpable because somebody wrote the script that they're doing? Somebody wrote this rap song that I'm rapping, and therefore, like, where's the cutoff? Sure, nobody was really killed in the movie. Okay, I totally agree with you. But can you prove that somebody was really, when Ice-T said 6 a.m, police at my door, fresh Adidas squeaking across the bathroom floor, out my back window to make my escape, didn't even have a chance to grab my old school tape. He was running from the police. So, right? That's what he was doing. No, he wasn't. I just think this is a very slippery slope. Oh no, Joe, you had me on mute. Y'all, this is about the 13th time I've seen Eminem up in here. All right, like Eminem locked Kim in the trunk. I mean, nobody ever thought that he really locked Kim in the trunk. So, I mean, following this logic, then Jay-Z rapping about being a crack dealer, and it's late. I mean, y'all can go ahead and go after Jay-Z for that. This is something I actually think bitter literally. RICO basically is Latin for guilt by association. I mean, I don't think there's any other way around it. Like, if you sure, you should not hang around bad dudes. I got you. But if that's all you're used to, I can't honestly expect you to be hanging out with better people. That's all you've ever known. It is what it is. The legal good. What's happening, man? Good to see you. Grace and peace, friend. This is another excellent content creator in the legal space. Man, thank you so much for stopping by the Legal Good. If you ever want to Legal Good, let me know. You are welcome. I've enjoyed your channel. You do some great work over there. And by the way, since I don't know what I'm talking about, I probably need some adult legal supervision. So you're welcome whenever. If the moderators could drop the Legal Goods channel in the chat, that would be wonderful. Thank you so much for stopping by this morning. Oh, I see what you did there. Innocent until proven guilty. That should be that's how we should handle it. Even if I don't like you, like, that's the thing. It's okay that you don't like Young Thug. I don't know anything about his music. I know nothing about his music. All I know is that he's a man, and we're watching this in 4K. We have the privilege of watching. This is happening in countless courthouses all around the United States. But we have the opportunity to watch this in Atlanta, in my town. I've literally been in this courtroom. So we have the opportunity to watch it literally from start to finish. And it gives everybody an opportunity to see, like, this is what's going on all around the world, all around the country. And sure, you don't have to like Young Thug. That's the thing. You are perfectly within your rights to say, I don't like that. I don't like the music. I ain't gonna lie. I've never listened to it. And the little bit that I've listened to is nothing for me. So it's not a matter of trying to support somebody that I like. I just don't believe that because I don't like you does not mean that you should get less justice than somebody that I like. That's all. That is all I'm saying. Because again, like the legal good, because I like the legal good, he shouldn't get more justice wherever the legal good is. I just saw him a second ago. Are my eyes going bad? Y'all pray for your boy. All right. Well, because I like, you know what? I like Shauna. Well, because I like Shauna, that doesn't mean that she should get more justice than somebody that I don't like, which everybody I like in here right now. Oh, there's legal good. Because I like the legal good, or let's say I don't like the legal good, he should still get the same rights and the same respect by the law that I give to Shauna. That's all we're saying. And sadly, we're watching what I personally believe is injustices being metered out in 4K. Like, we're all watching it. And everybody globally, literally in Australia and Colombia and Alaska and deep Atlanta are watching injustices being done. And I think there's good reason to like pause and be like, wait, hold on. Again, I'm not saying it. I'm not speaking on the character of Young Thug. I'm not saying that because I've said it ad nauseum. I believe he probably has done some things that were not good. I don't know if he's done everything that he's being accused of, but that should cause you to think, well, hey, if the state has had this case for almost 9 months and people still don't know what is being accused, that's a problem. Like, why are you not upset about that? Like, wait, y'all had at it for 9 months, 3/4 of a year, and y'all are no more closer to convicting anybody than you were when you started? That should be problematic to somebody. Somebody should be upset about that. Maybe I'm just being, a little bit bombastic, but you should be upset about that. Because what would it be like if it weren't for the fact that Young Thug, I see somebody's upset because Young Thug has money, and well, if it wasn't for him having money, guess what? They would already be thrown in jail. And we wouldn't know it. But we also wouldn't know how slimy and grimy and underhanded Fulton County is. I'm sorry. I'm not saying again. I'm sorry. I just saw Al, come on, man. You don't dislike everybody, man. Come on. You like Miss Johnson down the street. She's a nice lady, man. Somebody. You got to like somebody. And Roseanne says right here, I did not know Young Thug before this trial. Okay. But everyone deserves justice and is innocent until proven guilty. Constitutional rights for everybody. That's it. And hear me. If he's such a terrible person, let's just say Young Thug is just such a grimy, terrible, low-down person, then go ahead and get it done. Why is your number one witness somebody that's equally as grimy and untrustworthy? Come on. This should have been a slam dunk if he was that bad of a person. I'm just saying. I'm going to go out on a limb and say, if he was such a terrible person, Paul Howard would have dunked on him. What? I got an amen from the legal good? Come on, man. I'm doing all right now. Now I'm cooking. Paul Howard, if this case was so good, Paul Howard, who was the predecessor to Fonnie Willis, he would have took it all the way to the house. He'd have been like the Heisman we were talking about earlier. He would have did it. The reason he didn't do it is because Paul Howard, out of his own mouth, said, this is not a good case. Fonnie Willis took it, and she the one fumbling down the field. dropping the ball, running out of bounds, losing a helmet, running in the wrong direction. That's them because the case wasn't good. Again, I'm not saying the young thug is innocent or guilty. Again, they probably did some things. They probably have done some dirt. Okay, I'm not saying these are choir boys by any means or measures. What I am saying, however, is that they deserve to be tried properly, and I don't believe we're watching a proper trial. My name is Jason DearWolkC@gmail.com. Please email management if you have a concern, question, or comment about what I said. Especially if you think I'm crazy. We might have you come on the show and tell me how crazy I am. I'm telling you, because now, I mean, that's why we talk about this, and I think most people here, if this case was being tried in a just manner, I think we would all be like, good, you got some criminals off the street. You got a criminal enterprise. You broke up a criminal enterprise and you made Atlanta a little safer. Fulton County is a little bit better. I don't think people feel that way because the case is such a boondoggle. It is such a dumpster fire that it's hard to sit there and cheer for the state because they don't even look like they want to win. I mean, they don't look like they're trying to be successful. It's like they're almost, again, I think they're just trying to do a war of attrition. We just drag this out long enough till you go broke and then you just cop a plea. All right. So how long did they say they were going to be gone? Because they've been gone for a minute. We cruising on. It's almost 30 minutes. Judge Whitaker, good gracious. You started at 9. They discombobulated. Is that what happened? Foster Cathead, they discombobulated. Thor's paralegal says this. Fonnie is not even playing football anymore. She fumbled so bad, I think she thought she was playing badminton or something from jump. I agree. This case from Paul Howard, because again, Paul Howard had access to this, and this was not a good case. So the fact that she ran with it should tell you a lot of stuff. And we see it wasn't like this case was any more masterful. And I've said this before. I really want to say this again. A lot of the data, a lot of the evidence that they're using is old. It's not new stuff. This case was brought on information and evidence and crimes that were committed 8, 9, almost 10 years ago. Why has it not gotten better? Why has it not gotten more clear? Why did you not break it down to the very salient points of this is what's going on? Why don't you have an editor, Fulton County? I'm just saying, like, the fact that you don't have an editor should absolutely just, like, that's embarrassing. Yeah, that's embarrassing. You can get you an editor on Fiverr. Y'all over here, just, it's a mess. Anyway. This is, I don't even think they even, Amethyst said, like, the kid that submits his homework but doesn't show his work. I agree. The only thing is, I don't even think they even submitted the homework, though. I don't even did that part. They're like verbally telling you, trust me, I did my homework. That's what they're doing. I'll at least accept somebody turning in their homework without showing their work. I would make them sit down and take the first, let's say there was 10 problems, take the first 6 problems and do the work and show me the work. That way I know you did it. Or do all the evens or all the odds, something like that. You had 10 problems, do the first 5, do the all the odds, show me the work, and I'll trust that you know how to do it, or something like that. And you got to do it right here at your desk or silent lunch. All right. They need Snoop on the witness stand. All right, we got to stop right there. Nance, we got Snoop on the witness stand. You already know that's going to be wild. For defense, Death Row Records, yep, had Blood, Suge, and Crip Snoop on the record label. I mean, street dudes probably should stop making records. That would probably help out a lot. No more records, no more social media. Just stay out of it. The streets don't need to know that you committed a crime. Just do your crime and keep it moving. All right, what we got? All right, so legal good says I gotta get back to my day job. My 5 kids have to eat. I will catch you on the replay. Take care, chat. Hit that like. Thank you so much, man. I appreciate you stopping by. Grace and peace, man, for sure. Hey, man, 2nd grade was fun, man. I have to admit. Nothing's gotten better though. It's like I was like, you would think it would mature like wine or brandy or something, right? Bourbon. Over time, it gets better. Nah, this stuff is just as rancid as it was when you put it in there. Like nothing has gotten better. Like just stop it. Stop it. Yo, what kind of break? What kind of station break are they taking? They're literally on 30 minutes now. They're on 30 minutes, man. They've actually been almost on break longer than they've been in court. Good morning, Chicky Brewer. How are you? How are you? Man, can you imagine if the judge stopped allowing them to get away with that? How things would change, and this whole game would get on some different. It would be on another level. Man, thank you so much, Black Gold, dropping the $5 super chat. And what does he say? The judge is helping the state build the case as they go. That's crazy. That is crazy. And we're watching it. We are sitting here, front row seat, watching the judge help the state build their case in 4K. And again, this is a case that's 8, 9 years old. They could have been doing this multiple years ago. This case has gone from bad to worse with the bad news bears, says Gladiator Girl. And I'm right there with you. Yes, it is time to make sure you hit that like button. Thank you. These men's freedom has been taken. This is the bottom line. Statutory time limits on some of these filings are for a very critical constitutional based purpose. The dragging on of this case is sad. No argument for me at all. I just saw somebody walk by, so hopefully they're going to be jumping back in. Thank you again to everybody who's been commenting in the chat. Thank you so much for those who've already hit that like button. All that kind of good jazz. I'm dropping out Monday. You dropping out of are you dropping out? Oh, you're dropping out juror number 5? You dropping out? Dog, man. Can you get like 5 or 6 more of your other jurors to do that? And then we can go ahead and get a mistrial. No, because if they get a mistrial, they got to start over again. Never mind. Don't drop out. Just hang in there. We'll take a collection for you, juror number 5. But thank y'all, everybody who's been tapping in, commenting, and adding some good stuff to the conversation. Y'all are not having anything to do with love. Let me tell y'all. Love is getting no love over here. Hold on. Love is getting no love over here. Max Shard is doing love's homework right now. You've had enough of it, Juror 5. Come on, Juror 5. Don't give up, man. Hang in there. The bad thing is somebody probably thinks that Juror 5 is actually a juror, when that's not it. Chapo is a juror. They know they can't point one person to the killing for a fact. So they're just going for a RICO to have a chance. That is so sad. That is absolutely sad. Because if you could tie all those people to an event, you could still try 3 people for this particular event, but each one of them has their own individual charges that themselves are criminal. At this current moment, we got guilt by association. He did call her unloved. You're right, Brittany Gibbs. When Steele called her unloved, that was bars. You're hilarious. No, we need, wait, hold on. We need the jurors to stay on this. So it's not a mistrial without prejudice. I agree. That's what I'm saying. Yes. Your juror number 957? Okay. What was my juror number? I forgot what juror I was. I forgot. Oh, okay. There we go. 216. Oh, you're juror number 7. But just like you trying to keep it on the low. We got you. Your secret is safe with us. Don't you even sweat it. We got you. And they're throwing darts at the wall, hoping to hit a bullseye, aka beyond reasonable doubt, and the jury will convict. Yeah, they are definitely shooting for, hoping for a Hail Mary. No, not yet. We still Pond Walden. We still got. I want to say it's about an hour of jail call still. So when they come back on Monday, they're still going to have. The state is still going to have Woody for a few more minutes or whatever. Oh, that's right. That's what you beat me. That was it. That's my juror number. I remember now. But that's okay. I got another juror number. All right. Here's my juror number. Your witness number 500. Oh, Teresa, I wish I could tell you that you missed something. I really wish I could tell you, like, man, you missed something, but I can't say that because I don't want to lie. Retired. I don't think they're going to let him get it. I think they're going to come in on Monday and they're going to waste time with some more jail calls or videos, and by Tuesday for sure. But I don't think on Monday though. The state's gonna have a field day with these videos when court's back with jurors and Woody. I agree. Well, thank you so much, woman of valor. I must stop in to at least hit that like button. I appreciate you. Hit that like button. I'm Glanville support dog. Y'all are wild. Yeah, wow. We are really, they're on some major break game. They could have just started court late if they were going to do all that. Jenny called once. I mean, since we're posting numbers, I just figured I would, post that number. They're going to drag Woody out as long as possible because they know he can decimate a case on cross. Right. So they're going to definitely try to keep him away from Brian Steele and Weinstein and them. And please understand, every juror, every lawyer is going to have a bite at the apple. So every one of them is going to have the opportunity to cross-examine Woody. So there's going to be crazy. What are they doing? This is craziness. They're trying to trip up Woody. Having another secret ex parte. All right, some good conversation in the chat. I appreciate it. And I am sitting here waiting. This thing has... they should have just started court late. They've been in study hall court for 38 minutes. They should have started court late. They've actually been in study hall court longer than they've actually been in court. That's craziness. She discombobulated. Does he mention Steele in his... I don't know. I don't recall. I would play it, but it's not appropriate. It's not family friendly. What is going on? Thank you for the super Penny G. Every time defense gets stuck, judge puts in a break to restart. That That is true. I can't argue with that. I mean, it's pretty obvious that she's definitely helping them out significantly. Wait, court is coming back at 12:30? Hold on, I gotta pull that up. Let me see where they break. I think. Hold on.
Would fall under the same exceptions as the others. Do you intend to, I mean, the night commander copies part, can you
I can redact that, Your
redact
Honor.
that out? Okay.
Yes, Your Honor.
All right, what's next? Is there anything else?
I believe that's it.
Okay. All right.
Oh, how many? 10?
Let's ask Mr. Adkins since he seemed to be handling
He
it.
was.
Mr. Adkins, how many different incidents are covered in the CAD calls that we just reviewed?
3 incidents, Your Honor.
Okay.
That's low.
How many different 911 calls do we need for each incident?
So, Your Honor,
Mhm.
there is, let me get my notes.
These are all like, okay, go ahead.
So for the club crucial shooting, which is going to be letters JJ, like the exhibits are going to have that when we introduce them. There's only one 911 call.
Okay.
So that one's easy. For Adele Drive,
Mhm.
there is 4 CAD reports, 4 911 calls.
And why is that?
So, Your Honor, a couple of these is, for example, and Adele Drive is a good example of this. APD gets multiple calls from different neighbors.
Right.
And so in the state's mind, there's some relevancy to kind of some initial chaos of when these, because some of police work or investigation of cases. And so in real time, when it's 2 a.m. and someone's house is shot up, sometimes they get 5 calls.
Mhm.
And sometimes they're half a block over, 2 miles over, and it takes APD, as it would anyone, some time to figure
Sure.
out where it happened. So I think it's important for the jury and evidence to exist to show that process, real 911 calls and CAD reports associated with acts in the case that come in real time. They come in fast, and APD has to decipher and figure out what happens, which leads to investigations.
So are we going to need to listen to 4 different 911 calls? I mean, it's easy enough to say, are these the 4 CAD reports? Yeah, they are. They're admitted.
Your Honor, specifically with the 911, we will not have to listen to 4 911 calls.
Okay.
And so there is specifically for at least Adele Avenue, the 462 911 audio, that is the, 1428 is the victim's address, and that's the victim's, I believe, niece calling.
All right.
And so that, a 911 call the state wants to play.
Okay.
And there was, of the 3 other calls,
Mm-hmm.
the 455 the state wanted to play because these CADs come in sequential order.
Mm-hmm.
And so the first 911 call that we have audio for is in the case file is 0455. So the state wanted to play that because Ms. Latner kind of explains how they associate cases together when they get multiple calls.
Okay.
And so I will not play the audio associated with 460 or the audio of 456.
Okay. You can just say there were 2 other ones. Here are the CAD reports.
Yes,
Okay.
Your Honor.
Super.
And for Drew Drive, we have 1 911 call, 2 CAD reports. So 0587 has a 911 audio, and 0588, which is the one right after it, is just a CAD report.
Okay. All right. Thank you.
Yes, Your Honor.
Okay. Now, Ms. Love to the Miss Love or Miss Holden. I don't know.
It was me.
Okay.
So that's as to Mr. Stillwell's call. We just narrowed down the area that we were going to be intending to introduce. And of the bucket of calls that are in the folder for Mr. Sprinkle under defendant Stillwell, we've identified for the defense the October 31st call, 2015 at 12:26 p.m. from 1 minute and 10 seconds to 2 minutes and 5 seconds. We have eliminated the November 9th, 2015 call at 12:04. We've discussed and do not agree on the November, well, we don't agree on any of them. Mr. Sharp wanted me to make sure that I was clear. We don't agree on, they don't concede any of these, but November 9th, 2015, 1627 and 1645, those are two different calls. We are keeping those. We have eliminated the November 9th, 2015 call at 10:57 p.m. The November 10th, 2015 call at 16:41. We are introducing the portion starting at 1 minute and 50 seconds to 2 minutes and 30 seconds. And then the portion at 5 minutes and 51 seconds to about 6 minutes.
Okay.
Then the November 13th, 2015 at 16:58 call. We are introducing the portion from 12 minutes and 40 seconds till the end, which I believe is about 15 minutes. The November 18th, 2015 call at 17:30. We're introducing the portion from 10 minutes and 45 seconds till 11 minutes and 21 seconds. You want me to continue?
Yeah.
The November 18th, 2015 call at 18:43. We are introducing 1 minute and 52 seconds till about 4 minutes and 35 seconds.
Previously, just told it was 3:20.
So 1:52, the call starts, and then 3:20 to 4:35 is a specific portion that we have identified to Mr. Sharp, but we may have to back it up a little from 3:20 just for context, but 3:20 to 4:35 is the portion that we identify.
Is that all of them?
No, there's a couple more.
Okay, go ahead.
So November 19th at 17:26 from 2 minutes and 15 seconds to 3 minutes and 50 seconds. November 19th at 19:35. This is 1 minute and 27 seconds to 9 minutes and 20 seconds.
November
19th, 2015 at 19:35. is 1 minute and 27 seconds to 9 minutes and 20 seconds.
Okay, give me just a second. Okay, this just went out.
Okay, so apparently Judge Whitaker has muted her mic.
So
Up to the back.
19, okay, I'm gonna repeat for Mr. Sharp. November 19th, 2015 at 19:35. We will play from 1 minute and 27 seconds to 9 minutes and 20 seconds. Then for the call dated November 23rd, 2015 at 16:08 p.m., the state will play from 8 minutes and 50 seconds until the end of the call at about 15 or 16 minutes, 16 minutes actually. So it's about 7 minutes. 8 minutes, 7 minutes. Then December 4th, 2015 at 15:48, the state will play 11:57 to 13:15. Then on December 4th, 2017 at 17:31, the state will play 8:10 to 8:30 approximately. And finally, on December 7th, 2015 at 16:55, the state will play from 13:50 to 1600.
Okay, so do we want to just start with the first one and I'll hear what the objection is, or hear the tape and then hear what the objection is? Maybe hear the objection and the tape.
So, Your Honor, I think that's a good way to do it. Maybe hear the tape and then the objection.
Okay.
The reality is, I've listened to all these calls, but I'm not going to be in an agreement with the state, so we're going to have to litigate it. So there's not really any sense in further negotiations, respectfully.
I mean, we at least have the portion that they intend to play now.
Yes.
Okay. All right, so if you want to just start with the October 31st one and play that portion that you intend to play, and if I need to hear, well, I assume if you intend to play it, it'll give the jury enough context also. Is there like a general objection on all of these, or is it going to be different depending upon?
Well, I will note that several of these calls involve people threatening Mr. Stillwell and him reaching out for help to stay alive because the system has placed him in a cage with people who are potentially trying to kill him. I find something rather perverse about the system putting him in a cage in a situation where he needs to reach out to help to survive and avoid having a shank plunged into him, and then us using that against him. So that is my general objection to some of these quote unquote gang related statements. I think we all know about the danger risks and the deaths and stabbings that have occurred at 901 Rice Street. So he's really in a no-win situation there. And I don't know, that just does not, on policy grounds, that doesn't seem like something that should be held against him. He didn't ask to be put in that situation. But other than that, Your Honor, there's different topics, there's different objections.
Okay. Give me just a second.
Judge Whitaker, what in the world? Give me a second. I like that the cameraman is panning around the room a lot. I wish he would pan to the defense. Oh no, darn it. Just gave him a compliment. And now look, we're back to the Georgia Seal. All right. Tainted Love. Y'all are giving me some great titles to some videos. By the way, I have a whole playlist of videos that I've made making puns off of the name Love. So check it out if the moderator could drop the playlist in the chat. I'm liking Tainted Love. I'm liking Stop in the Name of Love. I think I had one called Blazing Love, Frozen Love, Out of Time. Love is out of Time Love, I think it is. No, these are good ones, though. These are some good ones. Greg is all the way over on the left coast. He said, good morning. That's right. You're correct. You're correct, Justice Fly. That's why I didn't get my Rule 22. I film the judge is not in the courtroom. That's right. Uh-oh. Real Woody said he pleading the fifth on Monday. For real. Okay, Real Woody. Okay. Hey, we're here to watch it, man. We support you, man. Stop in the Name of Love. Love will keep. It's got to be short title, though, because I'm making Love Stinks. I think I have one called Love Hurts. Oh, that's what I was doing. I was supposed to pull that up. All right, let me pull it up real quick. All right, so I got a playlist called Love. 6 videos in it. Overt Love, Blazing Love, Frozen Love, Love Off the Tracks, and Brady Love. Here, let me drop it in the chat. Why can't I do it? So, yeah, it's cooking. It's cooking. I'd love for y'all to check it out. Give me some more of your feedback on it for sure. Some of you probably already saw it. This is crazy, man. How are we? Look, they should just started court late. This should be like, y'all should just started court late at this point. There is no benefit. Oh, Endless Love. Oh my gosh, that's good. Crazy Love.
All right, so we're going to listen to the October 31st portion that's at issue.
Store or go to www.visitfromhome.net to learn more.
Thank you for using Securus. You may start the conversation now.
Hello.
What's up?
Hey. What happened?
Lois and the lawyer, I had to talk to the lawyer.
Oh, okay. What is that?
I need to let him know he behind me, everything good. Lois sent him down there so I can interview him to see if I wanted him. I'm like, so I can hand the tape in.
Your Honor, I'm going to double check to make sure it seems unusually quiet.
Okay.
So I'm going to make sure the volume is maxed.
All right. Your volume.
While we have a minute of downtime, I'm getting dispatches from colleagues that are not here.
Okay.
We wanted to make sure that we're all on the same page, and I guess the court acknowledged that the Mr. Kendrick's video that was discussed yesterday, the video of his interview, that everyone was on the same page that Mr. Kokomo, Mr. Steele were going to provide a copy of that video because it was not introduced at the time we were discussing it yesterday.
Okay.
And I think that everyone wants to make sure that you are on the same page that we will be supplementing the record with a copy of that video.
Right, and I think didn't we talk about that yesterday, that would be Defense Exhibit 1 to that motion? Yeah.
Yes, I thought we
Okay.
did, but
Yeah, we did.
Okay.
So it's admitted. The court reporter will await receipt of it.
yes, thank you.
Thank you.
Okay, so what are we doing?
What's up?
Hey. What happened?
Lois and the lawyer, I had to talk to the lawyer.
Oh, okay. What is that?
I need to let him know he behind me, everything good. He said Lois sent him down there so I can interview him to see if I wanted him. I'm like, so I can hand the tape in. I want him. If you feel like you can't, then don't waste my time.
Oh, okay. You want him?
But he talking like he can handle it, like everything. He can handle everything. He said he's been working with all type of stars on all type of murder cases and all type of cases.
I'm sorry.
Okay.
Can't hear that at all.
Your Honor, we're bringing over a Bluetooth speaker. I'll give the court what is being said so that at least we can discuss it.
Okay.
Mr. Stillwell says, when asked how he's doing, that Thug sent the lawyer down for me. I went and talked to him. He let me know he's behind me. Everything's good. Thug sent him down there so I can interview him to see if I want him. I feel like he can handle the case.
Dang, don't help your friend out and send him a lawyer, because that's going to be part
I'll
of RICO.
start over. Thug sent that lawyer down here for me. I went and talked to the lawyer. He let me know he's behind me. Everything's good. Thug sent him down there so I can interview him to see if I want him. I feel like he can handle the case. And if I want him, If I feel like he can't, then don't waste my time. He's talking like he can handle it. He's been working all types of stars and murder cases.
All right, so the extent of it.
What's that got to do with it?
I agree with the state's rendition of what that says. My objection is relevance and 403 specifically confusion of the issues. So to my knowledge, well, first of all, let me just say this. Factually, I think the state would acknowledge this. I did not represent Mr. Stillwell in 2015. I did not meet Mr. Stillwell in 2015. I am not the lawyer that represented that. I beat murder cases all the time and have represented all sorts of stars. So, factually, this creates an impression to a jury that, and I know I'm not a party to this case, but I am linked inextricably with my client. This creates an impression to the jury. A reasonable deduction of the jury would be that he is talking about me, that Jeffery Williams sent me, and let me just be clear, I have no information that Jeffery Williams sent anyone, but Jeffery Williams sent me to talk to Mr. Stillwell, and that this is just a continuation of Mr. Williams sent a lawyer. I'm here representing Shannon Stillwell in 2024, and all that is completely false. I know who represented Mr. Stillwell in 2015. I don't know if that's the individual that's being discussed, but it wasn't me. Furthermore, I don't know of any information or any evidence that Mr. Williams ever hired a lawyer on behalf of Mr. Stillwell or had any role in that. I don't believe that to be true, but the state has not provided any information. So this is misleading. It's confusing the issue. It creates the impression that Jeffery Williams sent me, current counsel, and I'm continuing to work on behalf of Mr. Williams representing Mr. Stillwell. All that is false, and the state, I would hope, would agree that that is that any impression that it was me would be misleading to the jury. So I'm not sure what the relevance is, but certainly there's 403 issues that outweigh any probative value in this piece of information.
And Your Honor, just to add a bit more context to that, certainly we agree with everything that Mr. Shard has said. We're going to have an objection as well, of course. We don't believe that that conversation that you're about to hear is, number one, irrelevant, that it advances any issue specific in this case, but more importantly, and the state knows this, I'm sure they do, there is no indication, and there, in fact, was not any attorney hired by Mr. Williams for Mr. Stillwell, Mr. Jackson. And so any discussion that the court would hear, that the state would intend to introduce about Mr. Stillwell talking to someone else about Mr. Williams sending an attorney down, or whether he's going to hire an attorney, or the fact that he did not hire an attorney for him, I don't see the relevance. And so that's just adding a little bit more context for the court.
All right, thank you. I'll hear from the state.
Yes, Your Honor. As far as the relevance goes, the fact that the alleged leader of the gang that Mr. Stillwell is a member of is securing for him representation for a murder that is alleged on this indictment, that we allege that other members of this gang committed. And the fact that we allege that in part, one of the ways that the gang protects its members is to pay bail for arrested gang members and enterprise members, and to obtain and procure representation for them. The fact that Mr. Stillwell is relaying out of his own mouth that the alleged leader of YSL has sent someone down there, And the fact that this person has been, according to Mr. Stillwell, working with all types of stars and murder cases. And he is saying in one of his songs that he's talking about paying a lawyer, having beat a murder rap. I don't think anyone is going to get the impression that Mr. Sharp is the person who represented him. And even if they did, it doesn't in any way impact the 403 analysis, which with Mr. Sharp bears the burden of showing that this information somehow or another is so substantially more prejudicial than probative as to permit its exclusion on 403 grounds. And he hasn't done that except to say that they might think that I'm the one, but Mr. Sharp's not the person or the proper inquiry around which to make that analysis.
All right. I mean, it doesn't actually say anything bad about any lawyers.
Well, I'm not.
Whether they think it's you or not, I don't see what that matters. I mean, if you want me to tell the jury that you want them to know that that wasn't about you because you didn't represent him in 2015, you know, we could think about that. But I mean, it's definitely relevant evidence in that it makes the state's assertions more likely than they would be without that evidence. And
would you consider two things? I would like that instruction.
Okay.
And second, would you consider taking out the lawyer said he represents all stars and is beating all sorts of, I mean, that's just lawyer puffery. And I don't know why that was said, but at the same time, I don't know why that would come in.
Go ahead.
So as it relates to Mr. Sharp asserting or asking the court to assert or put before the jury evidence about him, I don't know that that would be appropriate, but we can
do it anyway.
Time. And as for whatever the lawyer said about him representing all types of stars and murder cases, the fact that Mr. Stillwell made that assertion is the part that we believe is most relevant, because that means that it was important to him, and that's his belief. He's telling this person that he's saying he can handle it. You know, he's been working all types of stars and murder cases. That repetition of that part of whatever the conversation was is the part that we believe is most pertinent.
Okay, and you're saying that then shows up in a music video, or what did you say about that?
With respect to the music video, I pointed the court's attention to the music video that we heard earlier.
Just that he had beaten a murder rap. Okay.
Pay my lawyer $30 for that. To beat a murder, I just beat a murder rap, paid my lawyer $30 for that.
Okay.
Your Honor,
Me and my sponsor above the law.
I'm sorry. The problem is that there's nothing to indicate that there's any connection between that particular lyric that we saw in that video and this conversation that Mr. Stillwell is having with his significant other about an attorney coming to see him. And the important part pardon my seat, the important part, I think, to add into the analysis is that, Mr. Williams does not hire an attorney for Mr. Stillwell. And so there's been an association that's been shown already between Mr. Stillwell and Mr. Williams. And the fact of Mr. Stillwell having a conversation with his significant other, his girlfriend, about whether or not a friend of his or an associate of his is going to assist him in getting an attorney doesn't prove anything. I know they can argue whatever they want to argue, but there's got to be something to indicate that that's a reasonable argument that they're discussing this, or Mr. Stillwell is having this discussion in the context of the quote unquote gang leader getting him an attorney as part of this overarching and ongoing conspiracy. And there's no evidence to indicate that. And then so for that reason, I would say that, again, I don't believe it's relevant at all. I think it does confuse the issue.
Okay.
I'd ask that it, well,
I
you've got to hear it.
understand the objection. It is admitted. I will give the instruction that it wasn't Mr. Shard if you want to come up with something like that. And otherwise it comes in. What's the next one?
To address my concerns about the idea that the jury would think that the lawyer in question is representing Mr. Stillwell currently, I'm probably going to include Mr. Botts in that too. It was neither Mr. Shard or Mr. Botts.
Okay.
I would also ask that in that instruction that it be added that it was not Mr. Steele who represented or who came down, quote unquote, to talk to Mr.
How
Steele.
about it wasn't any of the, what, I mean, was it, I don't know who it was.
Judge, I would.
Mr. Steele.
No,
Or myself.
Sit down, love. Just
we
sit
don't
down.
know that. And in fact, Judge, when we have in 2022 with the murder of, with respect to Mr. Steele, we don't.
Okay, who entered an appearance, if anyone, on Mr. Stillwell's behalf in the 2015 case?
A gentleman by the name of Michael Bixson.
Anybody else?
No.
What's the-
At some point there was, and just to give full context, a lawyer was not, the state keeps arguing that Jeffery Williams hired this lawyer. A lawyer was not hired for a significant amount of time. He was represented by the public defender.
Okay.
I believe Mr. Bixson was the gentleman who entered an appearance and is being discussed here.
Okay.
And Your Honor, that's not what we said. We just read what Mr. Stillwell said, and that Thug had sent a lawyer down there. We didn't say someone had entered an appearance. He just said he talked to him. So we don't know who it was, and that was the point that I
Well,
was.
that doesn't matter because I'm not going to say it wasn't Mr. Shart that talked to Mr. Stillwell. I'm going to
Okay.
say it was none of these lawyers who represented Mr. Stillwell in 2015.
Or just get rid of it because
So
it's
do
not
you want it to
necessary.
be Shart Bot Steele, or nobody here today?
Nobody here today.
All right.
An entry of appearance.
All right, y'all need to draft it.
Look at Weinstein.
Give me a second.
What's the purpose of that video though? I mean that phone call. What's the purpose of it? And keep in mind, that means we're going to still have to hear this with the jury. When the jury comes back, we're going to still have to hear this. So we'll hear this audio again.
All right.
Crazy. Thank you very much for the super sticker, Becky. I appreciate you. Thank you so much.
Next.
Yes, Your Honor. Judge, I'm going to try and play it through a Bluetooth speaker rather than.
Okay.
Oh my gosh.
And this will be the November 9th, 2015 call at 16:27. Just 1 second.
At what time are we playing?
I didn't give it's the call, the whole call.
Whole thing.
Hello, this is a prepaid parental.
It's a little loud. Hold on. Do it without the mic. Okay. Yeah. I'm going to start where the cost. I'm going to start where the call starts at 1 minute and about 27 seconds in. After the security.
What's up, bro? Hey, man, what's going on, man?
It is.
Maybe it is better going through the microphone.
I'm gonna try one more time because we had a microphone on. If it does do that, I will play it.
Okay.
This is embarrassing, y'all. Come on, electronic progression. Get down there and help them out. They needed some help. And if they're doing this now, you know they're going to do this when the jury comes back. So they're going to have this exact same problem next week or whenever they're interviewing a witness. This is embarrassing.
What's up, bro? Hey, man, what's going on, man?
Honestly, if you could transcript, that might be easier.
It's a safe place, Chicky.
I mean, it was
This is
better
a
once
safe
you
place.
moved that away, but.
So we'll do it.
I can see that, Cuzzo. I can see that.
Put it right here. Away from the
Look at Weinstein. Look at Weinstein.
Yeah, man. Hello. Hello.
Judge, does the court, is the court able to hear that? Because I'll just play it through Zoom if not.
Not really, I mean, I can hear it.
I can
Am
hear
I
noise.
concerned what they're saying? No. I mean, some of it, but.
Ask Thug, can he pay his engineer to come?
Okay. Do you have a transcript of it?
Not one that's really that accurate.
Okay.
Or maybe he can just throw it out because it's not useful.
On the left paperwork got going on, these niggas come out, you on hold and all that. Man, y'all just stop playing with me, bro, cuz I know how to fight, bro. Y'all fuck at me, y'all cap ass shit, bro. I ain't with all this suck shit, bro. All this fake ass gangsta shit. I was just on the street, y'all niggas just come out, bro, everything good, man. Come on, man. He need some hold.
And Judge, I'll point to the right of the screen where the court sees the lines indicating talk. That's the transcript that's coming up. It's sort of closed captioning. It's not the best, but that's what I was talking about.
Or you could just go get some good evidence.
The
and run a clean case.
Hey, bro.
What up?
Man, what's up, man? You fuck ass nigga trying all that suck ass shit, bro. You shine, nigga, bro. For real, huh? I don't know what paperwork had going on. I just out there like he kicking like he's there with a lord or film or whatever he's doing. Man,
Who said that?
paperboy, these niggas trying, they don't know nothing about paperboy, man.
Who are they?
They trying, they shine.
What's their name? Who they big bro?
He's my hit big bro, Montana.
Bro, what channel ain't got no wisdom?
Hey, bro. Come here. My bro said Montana ain't got no rim. Montana, your big bro. Hello?
Let me holler at him.
Hold on.
Stay pause it just a moment. I think this is important to note. At this point, a jail phone is being passed to a third individual. So we're about to hear a conversation between two individuals. Neither one of them are my client.
Okay.
Hold on, boy. He's trying to have something near the door. Hold on. He ain't got no run, no flow or nothing. What you say, Montana ain't got no
Shit,
flow?
bro, a green light and a floor is different, man.
Hey, I said here,
Bro. Hey, yo. I'm here, bro.
Bull.
He scared to get on the phone?
I don't know, man. He trying to do the door to another nigga, man. These niggas monkey, bro.
Tell the nigga get on the phone.
Man, these niggas monkey, bro. I beat one of these fuck niggas up, bro. I ain't playing, bro. All that lame shit. Come holler at my bro, man. Hold on.
Hey, yo, homie.
Yo.
Rise and shine.
I shine, you shine, we shine. Hey, who your big fool, bro?
Yo, my big fool A1, dog.
A1?
Yeah, that's the big bro over Georgia, my nigga, behind the G-Wall, 5. Listen, son.
You talking about behind G-Wall? A1 is behind.
Yeah, A1 behind the G-Wall. Listen, 5. Listen. But we just had a 5 on 031 day, dog. My channel don't even have no realms, 5. My handle is busy. Hold on, bro. My handle is busy, 5. You can ask any nigga about me, dog. My name busy, 5.
Your
My
name who?
channel don't got no what? Busy.
My son got the green light. Joe Shine gave him the green light over the whole right street, dog. I'm telling you, I'm telling you about the Joe Shine house.
Bro,
hey, look, you can three-way Joe Shine right quick.
Hold on.
Hey, bro, call Joe Shine, bro, cause I ain't gonna keep going back and forth on me about nothing, bro. He about to do it, Joe. He about to do it, man. Hold on, bro. I ain't with all this suck shit, bro. All that lame ass.
Bro, and who the fuck is saying that paper? Who put what the paper mouth?
I don't know. I think his name Pete. That some nigga named Pete in that door. You thought that name Pete, man, some murder ass shit.
Hold up, huh? I ain't about to do it on three-way because I don't.
I'm sorry. I don't see the purpose of this. This is just this. I'm sorry. I don't. This is not making me feel sympathetic to the state anymore. This is just. You just want to introduce profanity and the fact that these cats just talk like this. Like there's no benefit to this. What's the purpose of this?
9113.
They've already ascertained that this is not any of the men that are on trial. What is this?
Yeah, that shit be right.
What what the fuck? Oh,
This is craziness, man.
Green light, but he ain't say my time ain't got no sign. He said he's green light.
Absolutely stall
bro,
tactics.
I know my
Absolutely.
channel. Find my channel used to be a brown.
He keeps telling nigga next door.
The translation can't be correct at all. This is a bunch of mess. Like, I mean, imagine thinking this is proving your case. What kind of case are you trying to prove?
But that's the only my channel who shine fire and got the green light done.
It's like middle schoolers. Prejudice is the reasoning. Okay, maybe so. I don't know. But being the fact that it's not actually any of the men that are on trial, I don't know how it's prejudicing them.
Hold on. Hey, yo, call his number.
Hey, who over Georgia, boy?
Right.
Hold on. 44 632.
This is like, and they're giving out another phone number again. They're giving a number again. What kindergarten is this? Prejudicing the jury. I think they're going to be peeing off the jury. They're going to get them upset. I can't. Okay, I can totally see it, but it's just what in the purpose of this, man?
I don't know.
Who they saying got it? Joe Shine?
Who got Georgia? Who y'all saying got Georgia? Who he saying got Georgia?
Hey, yo, Robin Shine, son.
I saw what's up.
Bro, listen, you know Shannon and Rice Street, he just went upstairs, right?
You know what?
Listen, bro, these niggas talking about files on hold and all that kind of shit. This buckshot.
It's buckshot. Hold on.
Man,
hey, yo.
They talking about what?
They saying that the files is on hold and all this Montana shit. Bro, tell these niggas Montana don't even got no fucking room.
Montana don't got no fucking rims, nigga. That nigga's a flat nigga.
That's what the fuck I just told these little niggas. These little niggas don't even know shit.
What he saying? He got the same. Hey, he said his name Finesso and another bro named Pete.
Bro, and then on top of that, these niggas want to tell me that Pop not running the whip.
Pop pushing the whip, nigga.
That's what I'm telling them. Pop. Georgia. Pop, man.
Pop. Yeah, he know Pop pushing. Bro, Pop just running the whip, G. That's who got the runs by now, G. This shit going on. Hold on, let's say, bro. Yo. Hey, yo,
this is some kindergarten stuff.
Who is saying that Shannon is on hold?
Yeah, like I'm just gonna at this point in the game, there's no benefit in this. I'm gonna just go ahead and drop the audio a little bit more because I don't want to get a ding from YouTube for playing this because this is just ridiculous. I don't. It doesn't even make sense. Like I don't understand what.
Over the whole right street, right? Goddamn, the hood we pushing is living proof or no proof, right? Y'all say the high is hot. No.
All right, let's see what we got.
The high is not Pop, bro. The high is Doug, bro. Doug Ski, bro.
Yeah, this is,
bro, Doug is not. He's inactive right now, bro.
there's like 9 people on. Okay, I can't mute it. Thank y'all. There's like 12 people on the call, man. Like, what's going on? I'm sorry. This. Whether I don't know where you're landing on this, whether you think it's it's a good case, it's a clean case, whatever. I know somebody thought that we were being sympathetic to Young Thug. How is having 4 people on a party line in jail cursing at one another making a point? This is just ridiculous. And this is Judge Whitaker's fault. I'm gonna say that again. This is gonna be Judge Whitaker's fault because she's the one that did this. They have no case, Marcus. They have no case. They're just literally wasting time. They're finagling because they realize they got 2 more days. The rest of today, Thursday and Friday of this. And then the jury's back. And they were supposed to have done this. This is actually them doing their homework in class. Again, I just want to say this is study hall court. And we're still listening to this, man. There's still several minutes left of this diatribe This thing is almost 6 minutes long. No, I'm sorry. Yeah. The whole thing is 16 minutes long. And on the side, they have the closed caption. And the closed caption is crazy. Right there on the side. And that closed caption is bananas. It does sound like a party line, an old school party line. And it is talking. This is crazy. Yeah. Yeah, I was just going to keep it low, but yeah, there's really no benefit. I do apologize for that, but I was trying to, yeah, this makes no sense at all. There's a lot of hearsay, but in RICO, you can get away with hearsay. There's a lot of, in RICO, you can get away with what would be otherwise known as hearsay. Because a lot of it is hearsay, like so-and-so said this. Because they don't have a lot of physical evidence, so. This is a hearsay trial. That's hilarious. It's ridiculous. I agree. And look, they still got time left on that thing. We need to hear it though. For what? I'm not under. Is this a lot of profanity? Even though it's, fair use. Even though, I mean, I could end up getting dinged for that. And that's just not the speed of my channel. So I don't know if it hinges on listening to four guys on a jail party line, cursing back and forth to one another, then I guess they in trouble. If that's what it takes for them to go to jail, is listening to four guys cuss back and forth at one another. Okay. As I said before, this case is in the tank. No problem. Appreciate you. I don't think, I'm hoping nobody's really truly offended by this. I mean, by me cutting the audio on this. But it is what it is. Oh, they're going to hear it in court. Yeah, they're going to hear it in court that day. This is so embarrassing. And being the fact that apparently 3 of the people on the call are not actually the ones on trial, according to Mr. Shard. How do you even know who's the ones that are saying what they're saying? I'm sorry, State, you are toast. All right, so this is almost done. I'll bring it back in once it's over. Looks like it's got about 15 seconds left. And looking here at the closed caption, it still looks crazy. All right, and here we go.
Thank you for using Securus. Goodbye.
Throw that out, Judge Whitaker. Throw it out.
Okay. So, just before I get started with the facts, I do not accept Ms. Love's assertion that I bear the burden of proving that prejudice substantially outweighs probative value. I believe that they bear the burden that it doesn't. They're the proponent of the evidence. That being said, what we have here, just in context, Your Honor, in November of 2015, Shannon was in a car on University Avenue. People shot into the car, tragically shot a young lady in the face, causing the car to crash and flip over several times. Shannon and the mother of his child were sent to the hospital. Shannon had a collapsed lung, several broken bones. While at the hospital, Detective Thorpe took out a warrant for Shannon for the murder of Donovan Thomas.
Oh my gosh.
Once Shannon was finally medically cleared, he was brought directly to Rice Street and dropped into this environment where he is wounded, hurt, and apparently, from the context of this phone call, individuals who seem to be associated with the Bloods started threatening him. I believe the context of this call suggests, if I'm being candid, it suggests that Mr. Stillwell calls an individual and asks him to tell the people that are in jail with him to get off, basically get off his back and stop threatening him. It's clear from the context, and that's why I said what I said before we started with this, is the idea that Shannon has to do this to survive and stay in Rice Street, and now it's being used against him. I don't particularly care for.
Wow.
From the context of the call, it appears that Shannon is associated with G-Shine, which are Bloods. It appears that this individual he called for help communicating that he should not be attacked is associated as well. And then an individual by the name of Busy, who is locked up and apparently has been coming at Shannon, takes the phone and talks to the individual that Shannon called. They have an argument over blood politics. Shannon, there's no indication, has any part in that argument. I don't know where Shannon is at that time, but they have an argument over blood politics, over who runs this, who runs that. One individual thinks a gentleman by the name of Montana is calling the shots. The other individual is saying Montana doesn't have the authority to call the shots. But either way, the message is sent: Shannon is hurt, Shannon is injured, don't mess with Shannon. If this were a case about the G-Shine Bloods, my argument would be more difficult to make. This is a case allegedly about YSL and the alleged gang, criminal street gang YSL. Now, the state believes that they have this unbeatable argument, which they've brought out dozens of times already, and I'm sure they will again. Well, this is a hybrid gang, so therefore everything's relevant. No, it needs to be specific. They're saying that YSL is an entity, is a criminal street gang, and they're moving together to for a common purpose. This has nothing to do with YSL. This is internal blood politics, internal G-Shine politics, and quite frankly, my client just trying to survive in 901 Rice Street. Additionally, Your Honor, there's another concern that I have, and I would assume Mr. Adams has too. There's an individual, they're talking about who runs things. There's, and one individual thinks Montana runs things. And then there's talk, again, when Mr. Stillwell is not on the phone at all, that a gentleman, and what I believe is said, is Dub. A jury hearing that could quite possibly misinterpret that as Thug. I was concerned, I heard that at first, but that is not the case. So that's another wrinkle into this, but I don't believe any of this is relevant. I believe it's highly prejudicial. It's not relevant to this case, I should say. It's highly prejudicial. It confuses the issues. And for a substantial amount of time, I did not note the starting time, but from a time till 8 minutes, Shannon is not even a party to the conversation. A certain time, I'll say around 6 minutes, but I didn't note the exact time, to 8 minutes, Shannon is not part of the conversation. And from 10 minutes and 40 seconds onwards, Shannon is not a party to the conversation. So it's unclear to me how this could be labeled statements by a party opponent and be admitted that way, or any sort of admission. Finally, Your Honor, I don't think I need to say this, but we have not been noticed that any of these individuals in this phone call are on the state's witness list, so we will not have the opportunity to cross-examine any of them.
All right. That conversation was clearly not testimonial.
I understand.
I don't know what the conversation was, Judge Witt. The right
Your
thing
Honor,
to
with
do
the
is
court's
throw that
permission,
out.
I'll address the issue of burden in a moment, but I'd like to just start out by talking about the relevance. Mr. Shart's assertion regarding the fact that this case is against YSL is, and therefore any calls that defendant Stillwell makes to have someone verify his blood gang credentials are therefore not relevant, is belied by the part of the indictment wherein the state asserts YSL claims affiliation with the National Blood Gang, and that some associates also claim the blood subset gangs, Sex, Money, Murder, and 30 Deep. We also go on within the indictment to discuss that YSL, as Mr. Sharp correctly stated, is a hybrid gang, that they actually have members of both Bloods and Crips. But specifically, we also assert that YSL associates often use and write the word black, which some of our witnesses have come forth and said means other things than what our experts have said, which is blood love all the time. The court heard within the context of this call a reference to G-Shine and Shine. As Mr. Sharp correctly asserts, G-Shine is also a blood gang subset. And Mr. Stillwell did not call someone to have the authorities come and have these people get off his case. He called another blood gang member. He had one blood gang member get on the phone with another in order to verify and validate his credentials as a bona fide blood gang member. So we would argue that Mr. Stillwell's words are words of a party opponent, that the words of the person who spoke on his behalf when he gave him the phone is an adoptive admission. He's making these assertions on behalf of Mr. Stillwell. And regarding, so in terms of relevance, our argument is that it very easily passes the low hurdle of relevance. And under 402, it's therefore presumptively admissible. And under 403, Mr. Sharp has not made any showing that it is substantially more prejudicial to Mr. Stillwell, such that the evidence would create a risk that defendant Stillwell would be convicted on a ground different from proof specific to the offenses charged in the indictment. Regarding the objection burden, Your Honor, I'm citing a line from Carlson on Evidence 8th edition that, echoing federal authority, Georgia cases have placed the burden of demonstrating a violation of Rule 403 on the objecting party. But the case that I'll cite is State versus McPherson, 341 Georgia App, 871. And the pen site
Did she not have time to prepare?
A74, specifically in discussing or analyzing whether or not there is a 403 reason to exclude the evidence. The court says that it finds no basis in the record to support the extraordinary remedy of excluding this evidence as unduly prejudicial, particularly given the strong statutory presumption of admissibility. There has been no showing that the evidence would confuse the issues, mislead the jury, waste time, or be cumulative of other evidence, or that the probative value of the evidence otherwise would be substantially outweighed by its prejudicial impact. And the fact that they're saying that there's been no showing.
But is that because at that point it's on appeal?
When the court says,
are you talking about at the trial court level, somebody didn't show, or here on appeal? Because that's
I see what
different.
the court said.
Yeah,
Oh my gosh, come on.
I think it's,
Love, this is just throw
If
it
the
out
court
there.
will give me a moment to analyze that aspect of that case.
Just make it up. You're just making up everything else. Just say it. Just say it. Whatever you want to say. Apparently, they're saying that YSL is a hybrid gang. I've never heard of a hybrid gang. I don't get it, but apparently it's a hybrid gang, mixture of two different gang sets in one gang, I guess. Love acting like gangs are charters of other gangs is ridiculous. You're either in a particular gang or their enemy. No charters. It sounds like franchises, in my opinion.
So the court references later on, in this case, there has been no showing that the potential witness's memory about the alleged incidents is either impaired or patently unreliable.
Look at Weinstein. We need to all jump on Twitter and comment to Doug Weinstein, because I guarantee you he's on Twitter right now. I guarantee you. Doug is on Twitter right now. I guarantee you. I'm going to tag him. Shout out to JC. Is in the chat, has been posting some great videos on Twitter. Thank you, JC. I'm going to go ahead. I don't even understand anymore. I mean, part of the problem, in my opinion, is that Love is able to make definitions, and I don't know if they're solid. I don't know if she's made these definitions or what.
So, Your Honor, my reading of the case is that in this particular case, in the record that they're looking at, the record below, that there was no showing in that record that the evidence would confuse the issues, mislead the jury, waste time, or be cumulative of other evidence, or that it would be substantially outweighed by its prejudicial impact.
That sounds like what Doug wrote.
all right, well,
For his question.
be that as it may, 403 is a balancing test for the court to apply. So,
Ms. Love, are you done?
So I might have a little bit more, but if I may cede the floor to Mr. Sharp for a moment and come back.
okay.
All right.
Okay. Two things. The state thinks it's relevant that Mr. Stillwell called someone else for help because he didn't call the authorities. He's in jail surrounded by the authorities, put there by the authorities. I don't know who he's supposed to call.
Come on.
He's around law enforcement. He's not being protected. As far as adoptive admissions, there are two phones. There's not an ability to have a party line in the jail where you can just pick up a third phone.
There's not supposed to be an ability to have any kind of cell phone, but
I agree.
anyway.
But in this scenario, another individual has the jail phone. The idea that Mr. Stillwell has adopted what's being said because he doesn't pummel the man with the phone, retake the phone and say, no, that's not true, when A, he's not hearing what's being said because he doesn't have said phone. B, we don't even know if he's next to that person. And C, there's not a phone for him to speak into to deny what's being said is preposterous. So it's not an adoptive admission.
So
Come on, Whit. Do the
when
right
does
thing.
Mr. Stillwell, obviously Mr. Stillwell starts the conversation. He gets back on the phone 2 different times.
No, he actually is on the phone where Mr. Sharp stood up and said that from here on out, this is not going to be him. You hear him throughout that portion. You hear Mr. Stillwell throughout that portion talking on the phone at various times. There is a point at which the talker on the call, the person to whom he gives the phone says he went upstairs, but then you hear the person to whom he gave the phone to speak on his behalf continue to assert his credentials, and his being the person now talking his own credentials to speak on behalf of Mr. Stillwell and to assert his validity as a blood gang member throughout the call. So it's at various points, and I could go back and, you know, obviously I could sort of demarcate those specific times where you hear Mr. Stillwell's voice, but there is not a point at which you stop hearing his voice 3 minutes in, and now it's only these 2 people calling or talking. And it's certainly not a point at which you expect Mr. Stillwell to pummel this man because he's making these assertions, when Mr. Stillwell placed the phone in the man's hand precisely to make those.
And it's almost like he's an agent for Mr. Stillwell at the time, somebody speaking on his behalf. I mean, I am going to overrule the relevancy on the 403 objection. I find these to be either admissions by a party opponent or adoptive admissions. And it also probably, to the extent neither of those covers it, I think both of those cover it.
Wow.
So.
Your Honor, will you grant me, for all of these rulings that do not go my way, will you grant me a continuing objection?
Yes.
Thank you.
I'm going to presume that we're under the Harvey rule. So I'm going to adopt it.
Haven't taken that back, so that's what we're operating under.
All right.
All right.
Thank you so much. For
Move to the
joining
next
public
one.
room.
Yes, Your Honor.
Wow. I guess not.
The next one is going to be November 9th, 2015 at 16:45.
Hello, this is a prepaid collect call from an inmate at Fulton County Jail. This call is subject to recording and monitoring. You may start the conversation now.
Hello.
Yeah.
Huh.
Nah, I said it did like 1 minute. That's what I'm saying. It is. I hope this shit don't fuck up.
Everything good. What are you talking about?
Yeah, he talking about everything that you feel. You know, you still sign or whatever, you official or whatever. He said he gonna go up there, tell Pete, and he gonna tell everybody else in the jail. But he said he did get that boy green light over on Rice Street. He said, but tell him, yeah, they gotta be behind you 100% because you hurt. I'm trying to see if that, what's it? All I said is see if that bull call 698. I remember when he checked me for that number when his phone broke. He said,
What's the purpose of this
they
call?
told you what was going on. They said nigga supposed to be behind you 100% on my situation.
Hello?
Yeah.
Hello?
You want me to call him back?
Yeah.
Which one, bull? Well, I was not so fast, and I don't really know what bull is. Hello. Because I think I don't sit on the phone because they were still talking. I just hung up because you weren't on the phone.
Alright, they call for 5 minutes.
Go.
Yeah, but
Go.
Yeah.
Hello.
yo,
Yeah.
yeah, but what's happening?
What's up, bro?
Why you niggas screaming this nigga my Shannon name like my Shannon just that type of nigga, bro?
Exactly, bro.
Come on, niggas.
All right, so I'm gonna go ahead and mute that again. I don't really see any value in it, and YouTube will turn around and give you a ding for that, and I ain't got no time for that. All right, who's passed illegal cell phone? I don't know if this are illegal cell phones because it starts off by saying you're being recorded. It's a collect call, so I don't know if it's a jail call. I don't know if it's a cell phone. It's crazy. I don't know. Yeah, who's passing out illegal cell phones tapped by the police set up? Okay. No, I can totally get that. I don't know how they're getting phones in, but I think it's a jail phone. If somebody could confirm, because it does give you that little intro at the beginning when the call starts. All right, let's see what we got. When the judge first took the stand, people thought these boys had a chance. I told people this lady is not saving grace. Glanville and her are a part of the same team of Fulton County. I agree. Yeah. So it is a jail call, right? It's the jail phone. Okay. Yeah. I don't think it's a particular, like a cell phone got snuck in. Yeah, definitely. No, I agree. But they were arguing with before whether or not it was a real phone, a cell phone or a jail phone. It's very possible the guards might be, absolutely. All right, let's see. Build 2 set. All right, so we're doing the hybrid gang discussion as well as a jail call. Wow, this call is really long. Okay. I believe during lunch. So while this is going on, I'll just real quick. I believe during lunch we're going to play the Brian Steele before the Georgia Senate oral arguments before the Georgia Supreme Court, not Senate, Supreme Court yesterday. So we'll play that during lunch and get your feedback. It's about 40 minutes. So it'll probably be the breadth of lunchtime, but we'll play that then. This is craziness. I gotta get this caught up on my other side so I can tell where they are. Okay. Oh, his part's only 20 minutes. I'm sorry. Gotcha. Appreciate it. Everyone in jail knows that the calls are recorded and adjust their conversations accordingly, therefore unreliable. I don't know why they're reliable, especially stuff like that. I agree with you 100%. I don't know why they're using them. I mean, I shouldn't say it like that. What they're doing is clicking other people in on the line like they would call one person, and then that person will call another person and add them to the line. Gotcha. It's hard to determine like who is who and where are they. Like who's in jail? How do you know that's Shan Stillwell? And then how do you know the other people are who they are? Yeah, so we're going to do the Brian Steele during lunch. That's crazy. Like, what's wrong with y'all people, man? What's going on? All right. Okay. Yes, I got the Brian Steele queued up, ready. Shout out to Cat Not Williams. I mean, peeping what she did over there. Actually, I think I got it. I downloaded it. I do have it. Okay. So, yeah, I'm not 100% why these jail calls are so important. I understand what they're trying to do. Hey, they're back. I'm sorry. Let's get back to what they're saying.
G-Shine, not YSL. YSL has nothing to do with this call. YSL is in fact a criminal street gang. I understand that that would be evidence in this case, but evidence of gang membership outside of YSL is prejudicial. That's my argument. And really, Your Honor, this call is just a recap of what had transpired 18 minutes beforehand in the previous call.
So I'm interested in you addressing, is there anything additional in this call that's not covered in the other one?
So no, what this call did was belie the assertion that Mr. Stillwell wasn't making those assertions that were made by the person he gave the phone to. This is Mr. Stillwell, but this is it basically coming from his mouth that that's what he was doing.
Okay, well, I think it supports then that argument, but it doesn't need to come in separately to the trial.
Yes, Your Honor.
All right, next.
Your Honor, so are we saying that that's coming in or not coming in?
It's not cumulative.
Wow. Okay. So the first one gets in, but the second one not.
The next one is a short one. It's November 10th, 2015 at 1641.
2015. 9 years ago.
Maybe we'll do this and then if lunches are ready, we'll break for lunch.
Yes, Your Honor.
You said 1641?
I did. November 10th at 1641. Twice. Okay, it's the same one. And I'm going to start, Your Honor, at around 1 minute and 30 seconds to about 2 minutes and 30 seconds, which is 1 minute. And then I'm going to go from 5 minutes and 51 seconds to 6 minutes, which is about 9 seconds.
Same dog.
Yeah, who told those dudes?
Who?
I told those dudes.
Man, man.
We can admit, yeah.
I'm talking to my man after the phone, man, so I gotta put some money on that book right quick.
How much?
I don't need nothing but a 20, so I'm trying to make the little store right quick. I know she
I got it.
You got it, but you can't put it on. You at work, nigga.
Yeah. Who need to do it? Tell somebody so I can live my man.
I don't know. Do this shit. That's what I'm trying to see. I think you can call. I think you can do it online. Call 113 real quick. You still got number?
Nah, I got a new phone. I ain't got nobody's number.
I'm giving you number.
What it is?
678.
Hold on.
Oh, they don't get the phone number this time? Way to
I'm
go.
gonna fast forward, Your Honor, to 5 minutes and 51 seconds.
Slug and DK on third floor.
Yeah. We trying to come in.
Yeah, man. I'm good, really, though. I'm chilling, man.
And Your Honor, that call has to be, the pertinence of that call has to be, is realized when it's played in conjunction with another call that I'll play with the court's permission whenever it's time to play the next call.
No, it's never time.
Your Honor,
Where they,
maybe I can help us out.
Okay.
That's not my client. And nor is the other call. The state is attributing calls that are not my client to my client.
Oh my gosh.
Okay, well, that might be an issue you'll need to sort out at lunch. Let's go ahead and take our lunch break.
Wow. Judge Whitaker is mad.
Let's do 115.
115. Shout out. All right. Mandy, what are you thinking?
Not even the right client. I mean, Love can't even do her homework to the point where she has the right person.
You don't feel safe? You don't feel secure that this case is being properly adjudicated when you have the wrong person on the file?
Oh, I feel safe, all right, because after watching this, I always curl up in a ball in the corner and rock myself to sleep crying.
I mean, this is insane. Good to see you, Mandy. Now, Mandy, you wanted
MCAR, welcome. You remember?
So, Mandy, you had a special treat you wanted to share.
Yeah, I wanted to show you guys the Supreme Court.
Steele.
It's actually the oral argument. It's something beautiful to behold.
Yeah, absolutely.
Do you mind
I'm gonna
if
let
I
you
show
tap
it to 'em?
in, and
Okay.
I'm gonna go get some sunlight because I feel like
Go touch some grass.
I need to go touch some grass while my melanin is fading. It's fading. It's fading.
You don't want to be
fading
as white as I am.
away.
You really don't.
I'll see you in a second.
All right. If y'all have not seen this, yeah, Greg said I like watching steel work, and I did not watch it all. I watched about 5 minutes of it, and I was like, I have to watch this either on Jason's stream or mine, but I've got to watch this with people. So I only seen about 5 minutes of it. So I'm gonna pull it up right now. Here we go. What is it? Okay, I'm watching on Kat, not Williams' channel because she is amazing. State oral arguments. There it is. So this is State versus Riley oral arguments. Brian Steele defends conviction reversal, and this is what he does. This is his healthy space. So let's get to where he actually comes in. I'm going to be about 30 seconds before they introduce him because he steps up to the podium confident and ready to go.
Would certainly survive, as well as all of the others that that can be accused.
It's fantastic.
If you find it's an accusation. And I'll reserve my 1.5 minutes if permissible.
He reserves it, I think, for the end, but I don't know for sure. I think that's right now.
Welcome.
Go have lunch, actually.
Really pleased,
Give me
this
some.
honorable court. I am Brian Steele, and I have the honor
The man of steel.
representing Appalachia. The way I looked at this indictment I did not try the case. When I first read the indictment, I don't see the grand jury charging appellee. So that concerned me because the way I
Looks nice.
understand our law is that we require 16 to 23 people to serve as grand jurors to make a finding of whether the person should be held to be indicted or no billed. So as I went through this, I then raised it as an ineffective assistance because I believed that there's no jurisdiction on certain counts. I believe that every count, there are 6 counts except for count 5, have no jurisdiction.
So counsel, I understand your cause for concern. Do you have any evidence or really belief that the grand jury did not convene as to these counts?
And I've got to say, this is the first time I've actually really watched an argument in front of the Supreme Court. And it's nice to watch a lawyer that I'm familiar with. And I didn't realize that the judges argue back with you. And they're arguing back with them and they're giving him case law and they're coming back at him and saying, no, but this and that. And I'm going, whoa. So that's how that works.
There is no evidence that they did convene on the counts at all.
Is there any evidence that they didn't convene?
The only thing I have is the indictment.
Sorry, I'm backing it up because I was running my mouth. So he's saying there's no evidence that the jury convened. There's no evidence that the jury met. And she's like, wait a minute, what?
Do you have any evidence or really belief that the grand jury did not convene as to these counts?
There is no evidence that they did convene on the counts at all.
Is there any evidence that they didn't convene?
The only thing I have is the indictment where the grand jury, to me, ratified or true billed the fact that the former district attorney of Fulton County charged counts 1 through 6. That's how I looked at it. And we can call it, this court can call it a complaint, an information, an indictment, accusation. I don't believe the name matters.
So what do you make of sort of the first page and a quarter? The first page and a quarter of the document looks in form like I would expect an indictment usually to look like. It says indictment, it has the counts, it says true bill, it's signed by the foreperson, and then it appears to list grand jurors. What do you make of that? And what should we make of that?
I agree with what you said. That goes to form.
And it's not signed by the DA on the first page, which I think it would have to be if it were an accusation. Is that right?
At the end.
And why wouldn't it be form having the language of the DA included if it's form for the other?
Because it's the person, you always taught that it's the individual counts charged with crimes, not what's alleged on page 1, as Justice Peterman was alluding to. It's what's actually charged, and all those counts are charged, and I believe that's the substance by the district attorney.
So what says you about the part that shows that the foreperson of the grand jury signed it and said true bill, and then the names are crossed out? What does that have any significance?
Not really. I feel like from a reader that those grand jurors ratified that Paul Howard, the former district attorney, is making a statement, but that doesn't mean that they ratified it on their own.
What is the significance of the word true? Is that a synonym for charge? I mean, what does the word true mean on that front page? And then signed thereafter by the foreperson.
True goes back to when we had indictments, and it was either going to go forward as a true statement on the charging document, or no, it's not going forward. So to me, I don't put much emphasis on it because I'm wed to, and if I'm wrong, I apologize, but I'm wed to the counts because you always taught me that's what matters. Now, there are 2 cases I'd like to bring to the court's attention that were not written.
You always taught me.
That I think may, the Court of Appeals, I understand they're not binding, but I think they're important to the court. One is Campbell, or may be important, CAMPBELL versus State. It's 294 Georgia Appeal. 166, it's a 2008 case. I actually did that case in the Court of Appeals of Georgia. I represented this gentleman.
Quoting his own case.
There's a mechanism called the complaint. The complaint is really an accusation. If you look at the complaint and the charges, it's identical to Appellee's case, but it says complaint. But what happened was exactly what you were asking on the Honorable District Attorney. The District Attorney, I filed a demand for a speedy trial on the complaint. So it's a little different, but under 17-7170. And I said that's an accusation. So it's a charging document, so it runs. The District Attorney then presented evidence that the court accepted, the trial court accepted, and the
I'll
Court
have to
of
look,
Appeals
Megan.
said,
This is
complaint a
actually
placeholder. It's
just
solely
oral
to get
arguments right now.
a person who is
This is
arrested
state versus
before a
robbery.
magistrate judge to get bond. It is never intended to be a charging document. So I want to point that out to the court because it may seem bad for me, but I'm just, I have to tell you all the opinions that we have. So, but I believe it's different. Another case which I found fascinating is Pearson, Pearson.
Yeah, Dixie Dickens.
Versus State 258, Georgia Appeal 651. It's in Division 2. It's a 2002 case at 574 Southeast 2D 820. It's in Division 2, like I said. I think it's closer.
Let me look up
So this is
information.
Newton County. It's a multi-count indictment, 20 counts. The first count says everything that you would expect to see, that we always see, typically, I shouldn't say always, but 99+% of the time. Grand jurors aforesaid charge and accuse Mr. Pearson. Kidnapping, bodily injury, kidnapping, hijacking, armed robbery, etc. Count 1 is perfect. But count 2 through 20, the prosecutor is charging. So I would say it's an accusation. But what the Court of Appeals found was they said, listen, the grand jury charged count 1. The grand jury, or Mr. Pearson, pled not guilty to the indictment. It was called an indictment on every single page of the proceeding. So that you may think is bad for me, but I wanted to raise it for you. I don't think it's necessarily bad because I wouldn't be here if it said that the grand jury charged anyone. And in Pearson, the Court of Appeals said that does go to form because we have the grand jury meeting, we have the grand jury charging, and then counts 2 through 20 go to form. So if you find that interesting, I just want to raise it to you. But I think it's distinguishable because I don't have a grand jury charging appellate.
Can you spend a few minutes, and I heard the state's rendition, and I appreciate it, talking about the harm side of the IAC, the prejudice side of the IAC claim. I understand the argument that, well, if you had filed after jeopardy attached, then you'd get dismissal and you'd have, with prejudice. Can that be the right standard?
Yes.
So then tell me, if a demurrer was filed before jeopardy attached, would that be an ineffective assistance of counsel?
If a demurrer was filed before jeopardy attached.
If in this case,
yes.
If in this case,
no
the document's returned,
yes.
and you file a demurrer on that day, the day the indictment is returned, and the indictment or purported indictment is quashed, wouldn't that be ineffective assistance of counsel?
Absolutely.
Because you should wait for jeopardy to attach.
Yes, that's what you taught us in Heath. I mean,
We taught you that?
listen, you can do whatever you want, but that's what, in
Well, I
Heath.
mean, so look, in all seriousness, it sounds like, typically diligent attorneys raise claims that are advantageous to their clients. And if you have a defective charging instrument, it is not unreasonable to raise your hand and say, there's a problem here. Your point is, if you say it at that early stage, it's just going to get fixed and you're going to move on. The contrary view is a little bit of gamesmanship. And is it ineffective to not engage in gamesmanship? I don't know. That's a little bit of a trickier question.
I think it's, please, if I'm wrong, I apologize. State versus Wilson, there's a footnote, I believe, by Judge, I'm going to tell you Mickle, but I may be wrong, but Michael, but where it says, this is gamemanship, and then that's been corrected. This is proper lawyering. So if you don't wait until jeopardy attaches, then this is clearly, to me, a jurisdictional problem. The trial court had no subject matter jurisdiction over appellate, except for count 5. And if I'm right, and if this court agrees, I've made it known, I believe that under statutory, not constitutional double jeopardy, I believe that all charges should have been brought at the same time. And therefore, there's a reasonable argument. Obviously, courts would have to decide everything's barred. But as you taught me under Strickland, the second prong, the prejudice prong, is the outcome of this trial. The outcome of this trial. And if you wait till jeopardy would have attached to the outcome of this trial, would have been different if it would have been raised by.
Mr. Steele, can we move to the deficiency part of ISC? I guess if you put yourself in the shoes of trial counsel in this case, I know you weren't, and maybe if you were, we wouldn't be here right now, but what argument would you make? You'd make it after jeopardy attached. What argument would you make here? What case law would you rely on? And do you think you'd be able to do so clearly enough that it would have been unreasonable not to make it, right? I mean, we've talked about sort of these different cases, nothing quite on point. I'm getting to the question that I asked your colleague on the other side, which is there something here that was clear enough that it was unreasonable not to have raised it?
Justice Pearson, I don't find this to be so novel. I mean, you read the indictment and you see a murder case. You could go back to Thornton and Weatherbed, and the district attorney charged it. This is not.
But you got, I mean, you have a very clear case on if it's not an indictment, then you succeed and it's dismissed. But you don't cite nobody cites a case that clearly explains how we are to determine, is this an indictment or is this an accusation? And I spent a lot of time looking. I didn't find one either. I find, just like you, I found lots of little bits and pieces that inform that decision. But on IAC, it's got to be pretty clear.
You know, you're the court, but you read count 1, 2, 3, 4, and 6, not 5.
Where does your ratification theory come from? It's interesting to me. I had not thought about it as a grand jury ratifying a different document. Is that just sort of your post hoc explanation, or does that come from some kind of case law?
Well, I always,
intuition.
You know, we don't have to have page 1 or 2 like Justice Peterson said, excuse me, you know, which look like the indictment. We don't need that. All we really need, that's a form. That's a form that the legislature said you should substantially do this. This is correct. We don't need any of that. The substance of this indictment is in the counts 1 through 6. And to me, I don't see it so novel. I don't see it, you know, for ineffective assistance, deficient performance. Somebody had to read that indictment.
In a sense, the Mayo case that you cite, I think works against you a little bit here, because that case was about, look, the state really tried to use an accusation against someone when they weren't supposed to. And it really wasn't disputed that they tried to use the accusation. If those were your facts here, I think it would fit much more neatly into that line of cases. Here, we're still trying to figure out as a threshold matter which one it is.
Well, if you're figuring it out which one it is, then the trial court, in my opinion, made a determination factually that should not be.
Is that a factual determination, or is that like, I mean, there's an argument it's legal and there's an argument that it's applying law to fact that we would review de novo?
I think it's factual because the state had every opportunity. Once I raised this, the face of this indictment shows it is not the grand jury's charges. That's how I read it. And if I'm wrong, I apologize. But I read this a lot. I cannot get where the grand jury charged any of these counts. And if that's true, if I locked in correctly, then everything else is mere surplusage. It's the form, the substance is there. So the burden then shifted over.
So is that a special demurrer if it's form? Should it be special, not general?
But the substance, the form is the page 1 and 2. The substance, we could admit to this. I could go to trial right now on this case, and I could wait till Jeffery attached or didn't attach, and I can say you have no jurisdiction. And in my opinion,
because what you would be admitting to is District Attorney Paul Howard charged you with this.
That's exactly, and he cannot charge me. So I am innocent of those charges.
So coming back to Justice Pinson's question about novelty, it seems to me there are two types of novelty. One is you've come up with a brilliant new legal strategy and legal argument that nobody has ever thought of before. And IAC deficiency doesn't attach to.
Wow. You come up with a brilliant legal argument that no one has ever thought of before. To be told that in the Supreme Court, you know, he clipped that and he's playing it over and over. You come up with a brilliant legal argument that no one's ever thought of before. Did y'all hear that? I would be playing that to my great grandkids.
Types of novelty. One is you've come up with a brilliant new legal strategy and legal argument that nobody has ever thought of before. And IAC deficiency doesn't attach to failure to come up with a new novel theory nobody's thought of before. But there's another kind of novelty, and that is somebody made an error below that is so obviously an error that nobody has made that error before that resulted in a published opinion.
I'm making a shirt.
And it seems to me that when you're in that category of novelty, that's not a category of novelty that precludes deficient performance.
This was not novel. I mean, this court
is downright
reads
laughing
indictments
at
all
that.
the time. You would not have read it but one time to realize this is very wrong. I mean, this was not.
I'm making a shirt because I just remembered a picture I have of him with his law practice of him standing like this. I am making a Man of Steel shirt. That's just it. Thank you, Nisha. That we got Nisha to credit. Man of Steel shirt coming.
Not novel to me. It's just obvious, actually, to me. So once I realized that this is not an indictment, we could dress it up, call it a contract, call the first 2 pages a contract, call it a novel. It doesn't matter what you call it. That's the form. The substance is that the district attorney charged crimes that jurisdictional.
Yeah, wealthy.
The district attorney should.
So everything about the grand jury is just form in your
Yes.
mind. It has no significance whatsoever.
Yes. Unless the state wanted to call the grand jurors and said, did you sit on this? Did you hear evidence? They could do that. I mean, it's privileged, but the
No, you
court can
can't.
allow that to happen.
No, they can't. I don't think they can. I don't think they can call them because that is what happens in the jury deliberation room is privileged. We saw that in the Karen Reed trial, right? They can't contact them, I don't think, because jury deliberation process is privileged. I don't think they can do that still. I think you're wrong about that. And I think they're probably going to inform
They
them.
wanted to call the grand jurors and said,
Maybe
did you
grand
sit
jury's
on
different.
this? Did you hear evidence? They could do that. I mean, it's privileged, but the court can allow that to happen.
Oh, he said it's privileged, yeah.
I would have no problem. I would not have a case. And the judge asked for that. And there's zero coming. And here we are. So I don't know why I have the ultra burden. I proved it on
Yeah, I
what
didn't
the
think so,
evidence
Wilkie.
was. I submitted the indictment. It was already in evidence before the trial court. The trial court read it. He said, I can't believe no one realized this. I mean, it was obvious.
So I know, obviously, this is not this case, but I'm trying to think, okay, well, if we're going to delineate when is something on its face an indictment and when is it not? What about a charging document or a purported charging document that had all of the form of this case, but when it got to the actual counts, it didn't attribute the charges to any entity. It just said, we, in the name and on behalf of the citizens of Georgia.
Or the defendant is hereby charged.
Or the defendant is charged. Would the form save the substance, or would we, does it have to say the magic words of we the grand jury? I understand that's not your case. I understand, but I'm just trying to get a sense of when you say it stood out to you, I want to get a sense of where you think that line is.
I believe the line is in the counts itself. So let's just change the facts very simply. Don't call it an indictment. Remove the 23 grand jurors with the names crossed out. Just remove that. Call it an accusation. And then we're charging capital offenses. But you say in the charge, the grand jurors charge and accuse this person. I would say I'd have the burden of showing that the grand jury did not charge. That's what, so I think that the first 2 pages
This
are
is
the
a different
fluff.
trial, Diane.
So to answer your question, I don't know if I answered directly, but I don't think it matters anything in the indictment except.
The counts
Yes.
itself has to say
Yes.
the grand jury.
Yes. Otherwise, we don't know that the grand jury charged the person. In this case, actually, the grand jury, I'm sorry.
I'm sorry, go ahead. Ms. Steele.
No, I guess
Let me
I'm
ask you,
repeating myself.
if we follow the route that you're telling us, what does that say in the future when someone brings an IAC claim and it's a novel issue? I mean, we know they couldn't have known about it because it's never happened before to know that that may be a deficient performance. Wouldn't we be setting a path that would take us down a road that we wouldn't want to
That's
go as a
too much
court?
for precedent.
I don't think you're changing anything because I don't find this to be, I apologize, I don't find this to be novel.
Mr. Steele, what's your best authority for the proposition that the grand jury has to show up in the counts?
That the grand jury has to charge and accuse?
That it has to show up in the specific counts? I mean, your theory is, look, the first couple pages is the fluff, I think, as you said. The piece that matters is the substance, and that doesn't say the grand jury charged, it says the prosecutor. So what's your best authority for that point, that the language about the grand jury has to show up with respect to each individual count?
The Constitution of the United States of America, the Constitution of Georgia that says that a person has the right to be charged by grand jury, the statute in Georgia.
Beautiful, Mr. Steele. The Constitution of the United States of America. Gosh, I sounded like a hick right there. Constitution of the United States of America and the Constitution of the state of Georgia. Fantastic answer. Oh, that sets off my patriotic tears. I love it. It's beautiful.
That says that in certain crimes, I understand it's changed in the, I don't remember, the 80s, 90s, has to be charged by the grand jury. And it's not listed there. You know, if we just want to assume that this is correct, because we do assume that certain things that when they're filed, people do it, juries follow instructions to strike, etc. But you'd be rewriting this charging document.
So what about
Right.
the stamp, the file stamp on the front page showing that it was filed in Superior Court? And I'm going to ask a question that reveals my ignorance. Are accusations filed in open court?
Yes.
With the clerk of Superior Court?
No pleading is the pleading until it's filed with the clerk. Just like
In
an order.
Superior Court?
Correct. Well, if it's not in Superior Court, then the Superior Court wouldn't have jurisdiction.
Oh, now we're going to get into jurisdiction.
So I want to.
So an accusation, accusations would contain this exact same file stamp, and the file stamp doesn't really tell us anything about what
An accusation, this to me is an accusation. So the district attorney did this accusation. Somehow it went to the grand jury. I'm not agreeing that they heard any evidence. The grand jury, somebody put their label on it and a type thing, and the grand jury, they said, Paul Howard, excuse my language, the former district attorney, found this, and they wrote true.
You're absolutely.
And it got stamped filed. And if that's true, then this is an accusation. And an accusation is a charging document, except for these crimes, certain crimes. Thank you. Thank you, Senator.
Thank you, Mr. Steele.
Wow. Oh, we'll see what he's got to say.
Thank you, Your Honors. Let me, in my
you saved
last
that
90
minute and a half.
seconds, try to give Justice Warren a little bit of that research that she was looking for. And these are just
Got some big shoes to fill here, guy.
as I say, venerable cases. I say venerable because it's a lot better than saying old. They're still good law. But I have start here, Barlow
Doing a
and Williams.
1906 case.
The real entry which is necessary to give the paper authenticity as an indictment by the grand jury is the endorsement of that action upon the paper signed by the foreperson of that body. And here are some other examples of omissions which are stated in the statute as being part of the form, which are
Do
not.
any of these cases include not just an omission, but an affirmative statement that the person charging the defendant with the crimes was not the grand jury?
Right, this is not necessarily, this is not an omission. The point is that the fact that the phrase, the grand jury charges and accuses, is not a magical phrase that has to be in every charge. If the indictment as a whole is obvious what's happening, I don't think that it's appropriate for the court to just regard some text as just fluff and irrelevant, and that's just picking and choosing what part of the indictments. We look at the indictment as a whole, and everything about this indictment, other than that era, says that the grand jury is the one acting.
Thank you, counsel. We appreciate the fine argument. We will have a decision for you as soon as possible, counsel. Thank you.
I want to know what the decision is. Oh, that was so good. Oh, that was so good. And I think they've already come back with a decision, if I'm not mistaken. Let me take a look here. I was looking at Catnut Williams' detailed description here. Hold on 1 second. Give me 1 second. He got the conviction reversed. So Riley is set to have a new trial. The state is appealing that reversal. So he did get the conviction reversed. The state is, or blah, 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 the case, wow, the case is State versus Riley. So he did get it reversed. Wow. Yep. He's going to have a new trial. Here is the trial and the case information. I'm going to put it into the chat if you guys want to look it up. And I'm also going to put a link to this if you want to watch it. And here is the link to Katnott Williams' video. To my knowledge, she's the only one that has it uploaded because the grand jury does not, they do not keep it uploaded. They show it and they move on to the next case. So there's a link to it. Hey, Q, why does it Judge Kigglesworth always assume YSL Steel is right? And let's get this over with. That's a very good point. I think, she watched this. She did. I mean, let's just be honest. It's not allowed to retrial. That's not what it says here. It says Brian still got the conviction reversed in Fulton County after the court agreed the indictment was defective. Riley is set to have a new retrial. The state is appealing that reversal. That's what it says here. I don't know. That's under Katnott Williams' information that she has up about it. Now, this is going to set new precedents for reversals and trial going forward. This will create new case law. This will create new case law. The original conviction was already tried. I agree that it was. However, it did not prove that there was what's the words I'm looking for? That there was a jury present because of the wording on the document, if I'm saying that correctly. So because of that, the court can't prove jurisdiction. Am I saying that correct? It can't prove there was a grand jury present. So because of that, they can't prove jurisdiction. Am I saying that right? So because of that, that's how he got that ordered. Said it was the first time this has ever happened, like ever. But yeah, right, there we go. They don't have jurisdiction on the charges that were not approved by a grand jury. Right, because they can't prove there was a grand jury present because of the wording on the document. Right. Which is crazy. To me, that's just crazy. I get it. I get why he's saying that because of the wording on the document. But what an argument. What an argument to say, because of this wording, you can't prove that there was a grand jury present. Wow. There actually may not have been. There may not have been. There may not have been. They could have been playing low down dirty. If I ever live in Georgia, please let this man be my lawyer if I ever need one. Who was the prosecutor on the Riley case? I don't know. I'm trying to find the documents on it now, but they are not available right now. Probably there's too many people in them. I'm guessing there's a lot of people trying to pull them up right now. The state was the prosecutor, so, but I don't know who was the head prosecutor. So I'm guessing an ADA of some form. Paul Howard was the DA at the time. Okay, Paul Howard. Okay. Was it Love? I don't think it was Love. I don't think it was Love. Yeah, Hawk. I don't think it was Love. Yeah, no, I don't think it was Love. I didn't hear any ums, e's, huh? Yeah, I didn't hear any of that. Paul Howard. Okay. All right. Well, that was fantastic. I'm glad we watched that together. Does he not present a solid case? And he played some mind games with them too. This is what you taught me, like you, the court, you, the justice system, you, the enforcers of the Constitution. This is what you taught me. And I loved it. I was totally here for it. Were you not? I was living for it. This is what you taught me. I was sucked into it. I was like, yeah, this is what they taught you. I was living for it. It was great. Yeah, it was brilliant. Yeah, absolutely was. Seems like they would now need to get a proper indictment from a grand jury and to retry. Yeah, well, he's getting a retrial. That's been granted. No one attended the grand jury. That's what he's saying. That's what Steele's saying. But there are grand juror names on there, which I find very sus. Does anybody else in the chat find that a little shady suspect? And let's talk about YSL for a second, okay? While we're here, let's talk about YSL. So I grew up in a bad neighborhood, okay? I grew up in Section 8 apartments, right? There were gangs everywhere. My mom did a good job of keeping us in the house so we would stay out of shady business. But unfortunately, I know a lot about gangs because of growing up in this bad neighborhood. Did anybody ever see a hybrid gang? Did y'all ever see Bloods and Crips hanging out together? Because from what I saw, Bloods and Crips were rival enemies. If you were friends with a Blood, you could not be friends with a Crip, and that's just the way it was, because if they ran into each other at the little yellow store down the road where you could cash in your food stamps for money, then they would beat each other up. And that's just facts. I'm just speaking facts right now. Then there was a shooting and all this other stuff. Like, you knew that was the store that the Bloods went to, that was the store that the Crips went to, and the two shall never mingle. Right? Does anybody else know what I'm talking about? Am I talking to the right people here? Egregious darkly. Egregious darkly. I'm sorry, it made me laugh. It's not funny, but the only place Bloods and Crips hang out together is the morgue. Gang implies division sides, right? I would think so. That's sad, but I believe you. Sad, but I believe you. cousins that were in rival gangs. They didn't even come to the same events. Yeah. Yep. That's facts, though, egregious. That's facts. I had a cousin that had an ice cream truck who used to take food stamps. That's another story for another day. And like was in one of those gangs. I'm not going to say which one. And people from the rival gang wouldn't even go up to the ice cream truck. I mean, 50 cents on the dollar. Becky, Becky knows. Becky knows. The yellow store. Becky knows. Becky, I'm a kid of the 80s. I know. Becky knows. Unless they rent Michael Jackson's Beat It video. You Sadie on your side, we say. Yep, that's true. But yeah, I don't know nothing about the gang Tango. I've never heard of them. I'm not 57. I'm mid 40s. That's all I'm gonna say. 42. Well, that's not mid 40s, but yeah. I'm back in the day when you had to tear the food stamps out of the little paper book. Texas tea, right? If you've ever listened to rap music, East Coast killer, West Coast killer. All paper, right? All paper. All paper. That's what it was. You better have them books and them papers together, or they ain't gonna take your food stamps. Jason gonna kill me. Unless you go up to the little yellow store, then they don't care. It was a rule. It was a rule. It was a rule. They would match them serial numbers up. You guys are a trip. I love y'all. But yeah, I never seen Bloods and Crips hang out together or even heard of that until this case. And they're talking about them having a hybrid gang. Like, let's just all go to the skating ring together and hang out. No. I thought YSL was a gang at first. Now I think they were just a record label, because I don't believe in this hybrid gang stuff. Now, do I think there's gangs that maybe let other people from other gangs in, like if they're trying to get out? Yeah, sure. But a hybrid gang that has Blood and Crips, that I don't believe that exists. I think that's something that's made up. No. Nope. You were the bookkeeper that had to count them? No. Bitter, Lily. Now, what are your bitter? We love you, Bitter Lily. We are here for you. Bring it in. Oh, Bitter Lily. I'm sorry. Thousands of dollars. What? What? Oh, That's crazy, Bitter Lily. Y'all remember government cheese? Okay, I'm going too far. I'm sorry. I'm gonna back up. I'm gonna back up. Motorcycle gangs allow other biker groups to attend their fundraisers. Yeah, I'm going to tell you, if you know people in biker gangs, good people. They're good people, and they do tons of fundraisers to help people. They do. They're good people. They do lots of charity organization events and right. And that peanut butter. I'm talking a block of cheese this big. Oh. Yeah, I don't know anything about Hells Angels. I know there's a local gang here. It's just local to this town, but they do so much for like children that have been burned or seriously injured. And they do Toys for Tots run every year. And 5 pounds of the best government surplus you ever did have. And it would be scary because it would have no expiration date. Right, Q? I remember telling my mom, we ain't got no milk. We got milk. Where is it? On the shelf? In the cabinet? That is not milk. Yeah, it is. So mix it with water. That is not milk. Give me just 1 second here. All right, sorry about that. Let's find something to watch. So there's new details in information about Matthew Perry's death. Should we watch that? Oh, it's on Emily D. Baker's channel. I better get permission before doing that because Emily can have a mouth on her sometimes. All right, let's see. Oh, I think I found something. So here's funny court moments from high-profile cases. Let's watch that. This is like the Amber Heard trial and all right, here we go.
A mega pint of red wine, correct?
A mega pint. I'm winging it, Your Honor.
Did you smoke before you came here?
I did not.
I should.
I should have.
Sometimes you just can't help but laugh at absurd moments in court. From attorneys to defendants to witnesses and even jurors, you just never know what someone is going to do or say. Here are just a few examples of the law's lighter moments. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. So I don't need to tell you that courtrooms are very serious places. It's where judges and juries, they decide the fates of people accused of some of the worst crimes imaginable. We hear the weeks-long trial was full of quips and comebacks and jokes, especially from the man of the hour, actor Johnny Depp.
You know what?
I was in that courtroom out for a large part of that. I was covering it for us here on Law and Crime, so I saw and heard some of this firsthand. Now, a little bit of a recap here. So Depp had sued his ex-wife, Amber Heard, an actress, for defamation after she wrote an op-ed piece for the Washington Post. Wasn't named. The op-ed was clearly about him. He said that the false claims damaged his reputation. It cost him acting roles that would have furthered his career. And Heard ended up countersuing Johnny Depp for statements that were made on what she argued was his behalf by his attorney, Adam Waldman.
Hey, what's happening?
Welcome back.
What happened to your case?
You were muted.
I'm muted. I'm not muted.
We watched it.
Oh, okay. Okay. I just tapped in. I was like, wait, are you playing that? What happened?
Yeah, we watched it.
All right.
And talked about
Y'all
it.
ready for the afternoon?
Yeah.
Are we ready? Let me
And
see
we
the
talked about
cases.
how we've never seen any trial or any trial anywhere that we grew up where Bloods and Crips hung out together and intermingled their gangs.
Yeah, I think, and maybe I didn't hear the gang expert. Shout out to the gang expert. I didn't hear their testimony. I'd see so many problems with that, but there's a lot. Yeah, this is just such a weird case, man. But
I grew up in a not great neighborhood, and anywhere that I ever went, Bloods and Crips went the opposite direction of each other. They didn't commingle their gangs.
They got to co-mingle them, and they got to mix them up. All right, here we go. Up on RICO if you don't, and you get caught up in the RICO if you don't co-mingle. All right, real quick. Everybody, thank y'all so much. Mandy, appreciate you. How are you doing? How was your day going so far?
It's great.
I love it. I love it. Here, everybody, let's real quick. Let's do a temp check. How are y'all feeling about this case so far? With these record labels, is anything now, though? I mean, Matt says, with these record labels, it is a thing now. Okay. I mean, technically, somebody did point out that Death Row had commingled gangs in LA or wherever that is. So, I mean, there's some room for it. It just seems
I don't
really
put anything past LA, so I'll give it to LA.
or California, yeah, for sure. It just seems like they're definitely very conveniently able to coexist in this world that we're in. But shout out to this being almost a 10-year case, man. Shout out to that.
Shout out to the prosecution for not being prepared after 10 years.
After 10 years. What did John say? John C says, and Crip thinks, I got major street creds for my actions. Weeks later, a bunch of guys with blue bandanas showed up next to my house. Shortly after, guys with red bandanas showed up. Everybody left. I think I definitely feel like I missed a conversation. I'll go back and check it out real quick. But we got a present, not perfect. Thank you, sir. I don't know if the gang experts were ever in a gang. I'm sure they have some credentials somehow. So I'm not going to besmirch their credentials at all. But Texas T is
One
angry.
gang expert was in a gang. That one gang expert was in a gang.
Oh, was he? Okay. Yeah.
Yeah.
Becky has a lot of feelings, lots of feelings. They're not happy feelings. Dream is clapping. Hopefully you're clapping that this thing's going to get over with. I'm hoping for Judge Whitaker to actually start shooting down some of the speciousness, but we'll see what happens. Nisha, thank you so much for the comment. Yeah, this is very interesting, but all right, let's get at it. Let's get at it. Come on, Judge Whitaker. Let's get this thing going.
I'm going to drop off.
Well, thank you so much, Mandy, for hanging out with us for lunch.
No problem. Thank y'all
Thank
for
y'all
letting
so
me show you
much.
that video. It was pretty great. Steel is the
Oh, yeah,
man
it's
of
great.
steel.
The Man of Steel. I like it.
I have a
Thank
picture
you.
of him standing like this with his law firm. I said, "That's it. There's a Man of Steel shirt
I like it.
coming." I'm going to work on that today. Bye, y'all.
Hey, you got to take care, friend. The YSL Bible translation. Blood shall mingle with the crip. That's wild. Yeah, appreciate it. Everybody, real quick, thank Mandy for hanging out with us today. Give her a shout. Let's shout out Mandy in the chat. Thank you so much for hanging out with us and getting us through the lunchtime break. But yeah, if you're just tapping back in, everybody, welcome back. Hopefully you had a good lunch break. Let's see what happens the rest of this day. It's looking real interesting, so we'll see what happens. Yeah, this is getting bonkers. I'm looking through Twitter, trying to find that. I think I found some clips I want to use in my next video. So I got a lot of good stuff that I'm going to be using today. Oh, gotcha. Okay. All right. What is looking through? Thank y'all so much for hanging out with us today. All right. So yeah, this is going to be a good one. Hopefully the next part of the day will be worth it. We'll see what happens for sure. Yeah, thank y'all so much for thanking Mandy for helping us out during lunch, allowing us to get a little stretch out and all that kind of good jazz. All right. Don't say that out loud now. Bitter Lily, we don't want people to know that. Thank you so much, Mandy. Appreciate you. Yeah, we're gonna see how this day goes. Prayerfully, it's gonna be worth it because we gotta see. We are going to see for sure. All right. All right. I do want to thank you so much, Republic Tea Room. Thank you so much for gifting a membership. I'm not certain. I believe that Texan has joined. I'm sorry, Texas Cali has joined. Thank you so very much for that. And what is Wealthy Wisdom had something to say. The Supreme Court will agree with the appeals court, and it will be a case law moving forward to state that it must be done properly and not, or I'm sorry, and if not, this will happen. Okay, I totally get. I think y'all are talking about Brian Steele's case. Thank you so much for that. I appreciate it for sure. Thank y'all so much. Let's see what we got up in here. Oh, okay, I got you, John. Gotcha. Yeah, the chat is not friendly to long messages, but I totally get your point. Thank you so much. Oh, let me look real quick. I'm going to just check my mailbox just to see. I doubt highly I'm going to worry about this Rule 22, but let's just check real quick. I have not gotten the Rule 22, but got some other things, so that's cool. All right, all right. I appreciate it. Hawk, do they have a school for gang experts? It's a good question. I don't know. That's a good question. I hope after watching Steel, it is watching Steele is that Witt takes her position more seriously and gives Steele the respect he deserves. I'm not holding out any hope anymore. I've given up hope on Judge Whitaker. For real. The streets, I guess that's the school for gang experts, the streets. But like Brian Steele mentioned it yesterday, that, I mean, I could say that Foster Cathead is in a gang, and that's their evidence. And Foster Cathead is doing things like, in the live chat and all that kind of stuff like that. They're looking at Foster Cathead as if they're in a gang, but really there's no true evidence that, except apart from me saying that Foster Cathead is in a gang. So I think it's just interesting. I hope that they're a little bit more judicious in parsing through that than just somebody says it. Oh, there is proof that, yeah, that's what I'm saying. Like, I don't want to just say like there's never a commingled or never a gang that doesn't move like that. Because again, Death Row was one, or is one, or used to be, or whatever. Yeah, it used to be aspirational, but now they're just, it's just a dream, just a dream. All right. Being in a gang is not illegal in and of itself. I concur fully. I don't think they have the best determinations of what is a gang and then what is a gang activity. But that's just me. They can use CSI type investigations too. Okay. From the West Side, Kels back in the building. What's going on? Rock the bells, Kels. How are you? You think so? The judge is setting herself up to make money off this trial. Okay. Used to also work as a deputy sheriff, commissioned. Really? Okay. I feel like I might have missed a little sentence or two. To scan back up here, see if I missed it. I don't think Love expected as much pushback. That is a true statement. But see, doesn't that make you wonder how many times she's done this before, though? That she did not expect any kind of pushback, but she's clearly bumbling the bag like this? It just makes me wonder, like, yo, what have you been doing? Gangs have changed through time. Yep. I don't think Love has much street knowledge or experience at all. No. I think she's definitely taking other people's word, good, bad, or indifferent. She's taking other people's word for it, for sure. All right, just checking to see. All right. Yes, Axel, DWC. What's happening, Axel? Good to see you. Thank you so much, Axel Wheels, for stopping through today. I saw you earlier today. I don't think I shouted you out, but I thank you nonetheless. Love's profile on 88's website is strong, so it surprises me that she's so unprepared. I just don't think she wrote it. That's just it. She didn't write it. Let's see what we got. She sounds like a nun talking about the simplest things clueless. I feel bad for her in this sense, and then seems out of her element. I'm just worried that there are other people that have gone to jail or suffered loss because of the way ADA Love has handled this. Her practice is Brady with intent. I love it. I think so, Charles. Charlie, I got to look. I have to look. That's a great question, though. Is Woody the only witness that's been granted immunity? I think so. Yeah, I don't. He's definitely the most entertaining and most problematic witness, hands down. But that's a good question. I don't know that. I will look, though. Is that where she went to school? She street creds from the Girl Scouts? Free Young Thug. I got you. He's definitely a good lawyer, Axel Will. I'm not gonna say he's the smartest lawyer because a lot of people say that Harvey back there is Brian Steele before Brian Steele. But before Brian Steele was Brian Steele. But yeah, Harvey is definitely a good lawyer as well. What did you say? They definitely did the How Love Is Just Dirty DA. Yes. Hilton something about immunity with DK was on the stand as well. Okay. Like I said, I'm gonna look into it, but Steve Sadow is a great lawyer here in Georgia as well. See, when we say great lawyers, I'm sure there's other great lawyers in other cities and states. So I don't want to say that they're the best ever because I don't know. There's definitely other good ones for sure. All right, let's see. Lots of good commentary here. Thank you so much. I bet they give the. Oh, they're going to give it to Quandavis Zachary. Interesting. Mandy's page is Miss Mandy Reacts. If the moderators could drop it in the chat, that would be fantabulous. Karen Reed's attorney was fantastic. See, I think there's lots of people who have different opinions on Mandy's page. Oh, there it goes. Miss Mandy Reacts is the channel. Whoever was asking. Axel Wheel. What's going on, Black Law student? Good to see you. Grace and peace. Thank you for rolling on through. Hollering at your boy. Appreciate you. The thing about Steele, along with his argument. Yeah, I agree. There's definitely, it doesn't seem like they always do that on the defense, on the state side. It seems like it's definitely a lot more passion, a lot more feeling, but not a lot of law. And we'll come back. We feel we'll come back and get some law. Let's see what guy. All right. Okay. Appreciate you. Alan Jackson. Who's Alan Jackson? All right. Yep. Oh, I didn't spell her right. Miss Mandy Reacts. Oh, I didn't even see that. I didn't even notice it. You're right. All right. Karen Reed attorney. Lots of people say Karen Reed's attorney was on point. That's kind of cool. All right. So they are cruising on roughly 5-6 minutes left before lunch is concluded. Appreciate you, Dixie. Thank you so much. All right, what do we have here? All I feel is love, personal outrage. All I feel from love is personal outrage. With peace and love and a little Mr. Sprinkle. Yeah, that Mr. Sprinkle. I don't know who he is, but they love talking about Mr. Sprinkle, which is wild. So we're gonna see. We'll definitely see how that works. Okay, got you. Karen Reed's attorney. Got it. We'll definitely be going over the Karen Reed soon enough. Harvey's the guy, him in those glasses yesterday. Yeah, we call him YSL Ponytail. So Ponytail, however you want to look at him, definitely seems like a solid attorney. So sure. Now, thank y'all, everybody who's tapping back in. If you haven't already hit the like button, go ahead and hit that like button. Jump into the best live chat on the planet. Real quick, before we do get started, drop an emoji for how you're feeling or thinking about the first half of the morning. We had some pretty interesting back and forth between Shard, Love, and the court. What y'all think about that? That whole situation with the jail call or the rap video. Oh my gosh. We can't let that one slide. I almost forgot about that. The rap video. How'd you feel about that? Let me drop my emoji too. Let me see how I feel about that myself. It's definitely a bless your heart type of moment for sure. Yeah, I don't know who's yeah, that phone call was kind of weird. So I agree with you. A little bit of angry person there. Annoyed with this whole case. Gain experts do have classes, but they make up as they go along. I probably agree with that. All right. It's a dumpster fire. Hey man, thank you, law student. Law student, thank you so much. I'm at the house. Pull up on your boy. Okay. Oh, you're at Morehouse? Really? Okay, well, okay, I'm gonna hit you up in a minute. Y'all, shout out Black law student hanging out down at the house with all those Morehouse alum. I want to hear it. I think I know what you're here for. So I think we'll have a conversation. Oh, yesterday would have been great because I was down there yesterday. Is there a leaning tower emoji? I like that one. We'd have to make one. I think we need to make one for Doug Weinstein. A leaning tower emoji would be good because this thing is definitely leaning over. I can get it for sure. I meant about the case itself, not necessarily how you are feeling, Axel Wheel, but how are you feeling? Uh-oh. Lola Lisa said, no words. Can't say those words. I appreciate it. Keep those words family friendly here. We are a family friendly show. Thank y'all so much. Let me real quick. So yeah, they're supposed to be back in a few minutes. I'm going to get rid of this banner. Again, thank you so much to Amethyst for being the stream sponsor today. Thank you so much, Amethyst Angel, for supporting with that very kind $20 super chat. I'm glad that you all have found value in the show. I saw Fonnie on the stand the first time. It was very telling as to how they operate in Atlanta. Full stop. I do think that is very true. If you go back and watch Fonnie Willis in the infamous pink dress, she's not prepared. She's hyper emotive. She's extremely masculine, Brahma bull. And is that not exactly how Adrian Love has behaved? Maybe a little tampered down. Maybe not, but she's not prepared. She's always emotional. She's very rarely given like law and case law. It's just like, this is what I think. And it's such like that. It's very clear. It's very clear. Let's keep going. In my opinion, she's very arrogant, off-putting, and is problematic as a feel what he is. And I could say a lot more. I agree. Thank you so much, Kels. Rock the bells, Kels. Thank you so much. Thanks for that insight. Where did you watch it? May I ask? It was literally the disqualification hearing. If you go back and we can definitely find that. Moderators can find it and drop it in the chat for sure. Garbage. Don't even recycle it. Don't even recycle it. It's just garbage. Oh, thank you so much, Tracy. T555. Thank you. It's finished. Oh, I didn't. Yeah, that finished flag right there is definitely coming in clutch. Where'd it go? There it is. Bitter Lily. This thing is finished. Get it over with. Yeah, it was the February. Yep, that was it. It was the February 13th hearing where Fonnie Willis comes in. Ashley Merchant just got done grilling Nathan Wade, and Fonnie Willis comes in, and it was like crazy. Yeah, we'll find it. Thank you very, very much, friend. Thank you so much. When this case gets started, maybe I can just pull it up real quick and drop it in the chat. But yeah, that was she comes across extremely unprepared. And you never hear her. Please understand, and I've listened to Fonnie Willis quite a bit. She doesn't actually argue a point. It's usually a reactionary, emotional discussion. And from the church speech at Turner Chapel to the one at Big Bethel, the infamous Big Bethel speech, to the Easter egg discussion, to the standing outside Big Bethel when she did that press conference, to the International Women's Day dinner. All of it is just an emotional treatise. Like they're mean, they're bad, they don't like me, and I need y'all to support me. That's basically it. Zigzag is asking the question I've been asking. How many people have been put in jail because of this that really didn't deserve it? Yeah, very good commentary. Very good. Fonnie's running the show. She's not working for the people. Yeah, I remember that. This is a lie. This is a lie. This is a lie. Absolutely. So let's see where they are. Let's refresh real quick. We are fresh. I see them walking across the screen. Okay, we are ready. So we're up to date. So hopefully no surprises will pop up. Would the Black Panthers be considered a gang? I definitely believe they could. Following this logic, yes. I do believe the state is going to get this to the finish line. It will not go favorably for them at said finish line, but I do believe they're going to get it to the jury because Judge Whitaker is bent on that being a reality. So that being the case, it will get to a jury. Excuse me. It will get to a jury. Again, what will happen at the jury, I think that's going to be the disappointing part because I don't think they're going to convince these people like they're trying to, in my opinion. I would say that the majority that didn't have decent attorneys would have probably been found innocent. I concur 100%. I mean, there are cats that are still in jail that were, I guess, swept up in this and they don't have attorneys. So just think about it. Like if Young Thug was just was a broke thug, he would still he would either be in jail or somewhere in the Malays. The only reason we know about this is because Young Thug had money. That's really the only reason. But good commentary. Thank you so much. Fire in the hole. Let's go. One in the chat when you can hear.
That fuck nigga envy me anyway, man.
Yeah.
Pussy asshole. Good asshole.
Shut the hell up. You don't know.
Oh no, it's another recording. Oh, for the love.
That fuck nigga envy me anyway.
Oh, for the love of Pete the cat. Come on.
Yeah, I got one crazy relationship.
Fuck nigga envy me. He hate this
She gets
thing I
sleepy.
had.
Y'all be back rocking with all over.
Crazy fuck. I don't know that bitch. I really gotta shoot myself in the face. Y'all go back right. I don't want to fuck that nigga, man. They just want this little young nigga ass in here.
That ain't funny. I know you were laughing.
I wasn't laughing. I was just like, eat that baby.
Shannon, shut up.
Your Honor, can we pause this for a second? Your Honor, I understand that this is going to be a statement about my client speaking about Woody, who is Kenneth Copeland. I would just ask for context if we could just start. I believe that they started in the middle of the conversation about Woody. Okay. And so I think if the state's going to insist on playing this, we should start when my client's conversation about Woody begins.
Okay. Do you know about when that is?
I have in my notes, and these are imprecise, at 10:40.
Okay.
Today, that's I did to you in 10 days.
I might get about next Friday.
Huh?
I said I might get about next Friday. We can talk. We can talk. Jury came back with him yet?
I guess so. But she a lot of picture and said I asked for a selfie. He sent his waist and below to her. She like, I asked for a selfie, but I guess this would do. With a heart.
That's what the whole world about. Yeah. Go put my food. I go to jail back. Yeah.
Imagine trying to play this for the jury.
You know what?
I've been waiting. Hold my breath, man.
I had wrote Treasure like, oh, we didn't know he had the same charge because Lloyd said he didn't.
Yeah.
They said gonna text back. Lil Woody on the phone. He said, what did he say? I don't know.
We have no idea what he said.
He said you told the Treasure they dropped the charges on him. He want to know what was said. I said, I never said they dropped the charges on him. I said, I didn't know they had the same charges. I guess that what Treasure was talking about. Okay, thank you. But she.
Imagine thinking this is a case.
They trying to sit up, push that out for a nigga slap.
I don't think she gets much love to her.
You and your push ass baby daddy got in there, fuck that. Y'all both y'all on that lane, fuck that little boy ass shit.
We're gonna have to do this with the jury too. Good night.
Good asshole.
Yeah, I am so
Listen, you
sorry, y'all.
don't
This is such
know.
a
Wait till you get your package.
That fuck nigga envy me anyway, man.
yeah. This case is definitely downvoted. Definitely downvoted.
Yeah,
This
I got
case.
one crazy relationship.
Fuck nigga envy me. You hate this thing I had.
Oh, the new Rico emoji has shown
Yeah, I'll
up.
be back rocking with y'all over.
Thank you so much, Miss Mandy.
I really gotta shoot myself in the face.
I don't know why.
I don't fuck that.
I don't know why. The transcript is probably garbage. The transcript is probably garbage too. Thank you so much, Amethyst Angel, for the very kind and very supportive super chat. Been supporting the channel all day. Thank you so much.
Oh.
Appreciate you. Thank you very much.
I hear blood and he ain't real right.
He what?
He ain't real right, public blood.
He what?
He ain't real
What?
right.
Please just call a cap on this.
Oh,
Judge, come on.
Different shit like nigga push up on different niggas and
Just call the end of this. This is ridiculous.
pushed up on me the right way. They pushed up on him the wrong way. Like, hey, bro, you got to go and do this. Man, we finna go and get at you, man. You know they did. They pushed up on me like, shit, bro. You know, they saying, man, listen, man, do you want to talk to these people because you stressing these big hoes?
Hang in there, Debbie. Sorry about
Bro, I
that.
got these folks, man. You want to talk to these folks? Yeah, bro.
Thank you,
Now
Amethyst.
these niggas
Thank
be
you.
I be asking, I like, bro, you got up for rug, bro, but you in here panhandling, bro. Y'all niggas is big.
shut up.
But hey, man, that's how
You said it doesn't match. Let's see how it looks. Yeah, it looks kind of wild.
I feel like I'm wild the clock. What I am.
you got shit.
I just said that.
What you said?
Please
I said I
end
feel like
this.
I'm round the clock. I said, well, I am.
You have 1 minute left. I'm stopping at 15 minutes and 5 seconds.
Okay. Your Honor, from 11:25 to 13:30, there is discussion about Woody, Kenneth Copeland, lying on my client, and having my client falsely accused of these charges. That is one aspect of what was just played. After 13:30, there is a brief discussion, as far as I'm understanding it, about the previous calls, about the same subject as the previous calls, where we're talking about the Bloods, quote unquote, pushing up on Shannon. Very brief discussion. And then we get into stuff that, quite honestly, I'm not tracking or following, but I don't believe it has any relevance to this case. To the extent that 11:25 to 13:30, I would object. For the record, I don't think it paints my client in the best light, but if I'm forced to deal with that, I'll deal with it. That's 11:25 to 13:30, but I think that's the extent of what is admissible, or what is relevant at all in this case.
All right.
So, given that,
I don't know why the volume is so low. My goodness.
that Mr. Stillwell's commentary about Kenneth Copeland and Kenneth Copeland telling on him and his expressed feelings about Kenneth Copeland are relevant, our position is that that portion I agree, is relevant because it is talking about his feelings and his knowledge of a witness in this case. And the fact that the witness is
Why is she
telling
not
on
using her
him about
microphone?
things that have to do with this case,
People are embarrassing.
we would argue as well that that is relevant and therefore admissible, and there's nothing that is substantially more prejudicial about that information than probative. The portion after that where after Mr. Stillwell is asserting that people envy him, and he starts talking about the guy that just got beaten up in the jail. Defendant Stillwell asserts that he's a blood, he ain't real right. He's acknowledging his awareness and his use of the terminology, he's not real right. He's not a real blood. He's supposed to be a blood. And I believe that the female asks him, does he know his oath? If that's not what he's saying, that's what I heard, and that would make that relevant to us. Mr. Stillwell then starts talking about, I believe, the way that law enforcement spoke to him, or how he was approached about talking, and how law enforcement, how other people were approached about talking about the facts of their case. And that colloquy is relevant. He's particularly as well for what he's not saying, as well as for the fact that he's aware that he is being asked to talk about things and how he's dealing with that. So our position is that it's not substantially more probative. There's nothing in that span of the call that is substantially more prejudicial than probative.
Okay. Honestly, that was the way I took that last part about getting pushed up on the right way or the wrong way. My impression was he was talking about law enforcement as well, wanting to have him say whatever he was going to say about the case. So I think that would be relevant. And I mean, if you can shed more light on it.
Thank you, Charlie.
Go ahead.
I'll drop it
But
right
that
here.
appears to be the topic of it.
I mean, the only thing I can do is ask everyone to listen to it again. I mean, we might just have a difference of opinion, but when I've listened to these calls, I'm of the belief that, I mean, all this has been discussed in the previous calls, but he's talking about people pushing up on him, which
In the jail.
in the jail.
Is that what you think it
Yes,
means?
I mean, that's what I believe it to be. And so I understand that Your Honor has already ruled one call in. I think at this point it's becoming cumulative. I didn't hear the thing about the oath, but to the extent that the young lady is talking about Shannon needs to know his oath, which I didn't hear, but to the extent that that was said, I mean, that was said in the previous call. So to me, the talk about Woody, I believe it's fair and accurate to say that it appears that Shannon's talking about Woody when he says he envies me, he always envied me, but that ends at 1330. So that's my stance, is any relevance, which I know that the state's arguing it's relevant and it passes the 403 test, ends at 1330.
All right, well, can you start from 1330 again?
Yes.
All this is painful. Come on. I got them headphones. Absolutely.
I know you were laughing.
I was like, eat that baby.
Shannon, shut up. Let me find one.
I hear blood and he ain't real right.
Thank you, man.
He what?
Appreciate you, Charlie. Grace and peace, friend.
He what?
He ain't real right.
What? Shit, you know your own?
It be different shit like nigga. pushed up on different niggas, and the wrong way. Nigga pushed up on me the right way. They pushed up on him the wrong way. Like, hey, bro, you got to go and do this. Man, we finna goddamn gonna get at you, man. And that's what they did. They pushed up on me like, shit, bro. You know, they saying, man, listen, man, do you want to talk to these people because you stressing these big hoes, but you ain't on the phone with these folks. I got these folks, man, you want to talk to these folks. Yeah, bro. Now these niggas be goddamn. I be asking me, I like, bro, you got a Ferrari, bro, but you ain't help panhandling, bro. That nigga just big.
Hello.
But hey, man,
All right.
that's how it is.
Whether it's about how people are treating him and other people in the jail or law enforcement, certainly the part about certain people being bloods but not being real right, I think that's all.
Why's the volume so low?
relevant and not excludable.
Hey,
under
Bridget Williams.
403, so I'm gonna allow this over objection.
Thank you, Honor. The next call is November 18th, 2015 at 17:30, timestamp 10:45 to 11:21.
Nigga, what mother called that? You been a hoe, man. Hell nah. What the hell wrong? Shit, man. I mean, all these fucking slides in the dome, man. Hell, these y'all didn't come here back to back on somebody all along.
Listen, so you fat man, you want a twin in?
Yeah, twin in here. Fat in here.
I got it back on. Oh man, you ain't seen none of them suckers.
Man, oh no, I ain't seen nothing.
Yeah, it's funny, man. Three don't come upstairs. I say, I know this nigga. I told him the same thing. You know, you don't matter if you go there or not. I know you gonna go there.
So I had them for I said, shit, how long I'm gonna stay out here? They like, shit, we finna pay you upstairs today. I like, shit, yeah, what's it?
Yeah. Well, so what you don't heard? You ain't heard that? You ain't talking to nobody like no man, one of them bad detectives I can't talk to you, man.
I don't want no, I think for the court tomorrow.
These are adults that are doing
Thursday,
this.
I think, yeah, somebody said Thursday.
Yeah.
Crazy.
So that would be your first time saying most of all, man.
Nah, I think most on last week on the 12th.
Yeah, what?
On the 12th. We went to court on the 12th. We've been to court like 2 times, 3rd and on the 12th.
Oh, but y'all were put together, right?
Yeah. Me and Monson been up together, but the D, they got that nigga ass, I don't know. They be having him separate.
So what y'all heard like for what's the reason they would think you did something?
Shit, they keep trying our 4 names will come common names keep coming up like on some shit like, oh y'all did it. Everybody like keep expressing like we crazy. They keep saying like we crazy, like we just unruly. Oh, that's so true. Oh, that got a name on some crazy shit. Like nigga just.
That's all that is. We didn't like I just explained them struggles. You know, they were just doing a lot of extra talking. You know, I had got there, got to throw a lot on. So I'm like, I can't just vouch and say that a nigga
What's going on? What is this?
Everybody had eyes on everybody when it was time. When they said the boy got killed, nigga had eyes on these folks. These folks was, you know what I'm saying, around a nigga, you know what I mean?
Yeah.
So how the hell they can leave in 10 seconds and go do shit like that and be right there around us all, you know what I mean? I'm like, shit, it is what it is, what the police do their job, man, you know what I mean? Yeah, I mean, just saying it because it was on some really on some shit where I told nigga, y'all outside something to do with it, whoop, you know what I mean? And, you know, shit, I got there I had that, what the nigga name, I don't even know that name, he a lawyer. I had just looking through it, just through the head going on. He like, man, so much shit just going on. He said, it just, man, that shit real. He say, she say.
Yeah.
Yeah. So I was like, man, these folks, they'll be back with a nigga soon, man. You know what I mean? Fuck these niggas.
Yeah, the nigga thug shit down here. He was just like, he was just telling me, he was like, the shit that they saying, it like, oh, shit, like, yeah, I can go for it. I can say he had something to do with that. I can say I can say that, this and that. You feel me? But he said, motherfucker not saying I seen home do this. You feel me? So they can't say that anyway because, come on, bro, look at his name they saying.
Look at these there. I ain't never see these. You gotta see these fed, boy.
Huh? Yeah, that's
No, look, boy. I'm past the federal penitentiary.
yeah.
Man, they had like 18 marked out cars. Like, he didn't go bust them out of their JV. Man, and them were like vans, explode. Man, them folks deep as a motherfucker. They been go hit somebody, hit somebody. They leaving out the federal penitentiary.
You have 1 minute left.
Man, they need to be hearing me, letting me know what's going on, man. I be and that word about you, they be asking everybody shit I don't know, man.
Oh my God.
Yeah, I be chatting. New baby tell me she be talking shit. I just be like, man, I be so down, bro. I be like, man, I don't want to talk, no. I just be.
I know, but you know, like I told a nigga, man, it's a process. Man, y'all coming home, man, y'all ain't did shit. That shit dead, man. And the niggas just so long. I said, man, you should have seen the date that they hit all y'all with. All the suckers come out to my they were there having it. Next thing you know, that goddamn week, they pick their ass up.
Hey, New Baby, somebody go to my shit. I was waiting on Shannon to get locked up. That's why they call New Baby. I can't wait to get New Baby. I was waiting on Shannon to get locked up. This nigga suck.
They came out, leave about 30 beats that day they hit y'all with that shit. All the brothers and all.
Thank you for using
Please stop.
Securus. Goodbye.
I want to make that correction. It was 10:45 until the end of the call at 16:05 instead of at 11:21.
This has got to be cruel and unusual.
They're talking about the case. I guess it's relevant.
Okay.
So the next call that we're going to play is November 19, 2015 at 19:35. And this one will be played from 1 minute and 27 seconds to 9 minutes and 20 seconds.
So 9 minutes of that? Oh my gosh, come on. I just wonder when Judge Whitaker is going to call quits on this.
Yeah, I know Jim wrote me, said D said, what's your number?
Man, fuck D, bro. Fuck them nigga, bro. just like that, bro. Fuck you. Straight up, huh? All that fake friendship, bro. Fuck you, folks.
All right, what do we got?
Wish I get on tour. Fuck
Huh?
I wish I get on tour. All these fuck niggas, fuck all y'all rat ass niggas, man. Fuck that nigga, man.
I didn't know able to be on the phone. He said, what happened to the XB in court because they just need more from charge. They didn't even take on the court.
That fuck nigga, you know what's going on. Pussy ass nigga.
Shit like that.
You a fuck.
Let's see.
All right.
Fuck you.
Okay. I said, fuck D. He know what he talking to tell you.
All right.
I just said,
Yeah, this is. What are we doing?
she just read it. It look like she
Just
wrong
I
it.
can't understand this.
Catch know your number?
Huh?
I don't got your number.
You only didn't have enough when you said, what you say? Some old shit now. Wait, what happened, nobody?
That fuck nigga rat. They just went till I had went to court and they just let everything got. Tell that fuck nigga rat him and Wood and the other people. I don't keep going with folks. That fuck nigga know what's going on. Bitch, you in love with a rat hoe. Everything that came out, see. So I don't even qualify for that house arrest, 24-hour house arrest.
Sure.
They don't qualify for a fucking bond.
Huh?
So I don't even qualify for a bond. I can't even get a bond.
They said it in court.
Yeah. So I can't even get on house arrest. I asked for 24-hour house arrest. Still trying to know. So my record, my history, bad.
Your Honor, just so that I can ease the court's likely concern about this portion from about 450 on, we're not going to include any part about his bond and house arrest. But we're going to keep playing it just to get beyond that point.
So you don't know nothing about another court that name. That's going to be up to you when you get a lawyer.
Get on the 18th. December 18th.
So,
She'll be another time. Just run up. That fuck nigga, boy. I want to slap that fuck nigga boy in court, right? Yeah, keep.
Did in court with you?
Nah, somebody down. Fake ass private attorney ass nigga, man. Fake ass lawyer, man. I want to slap that fuck nigga, bro. God, most of lawyers just get out there eating them folks' ass up. I'm just like, bro, why the hell you ain't doing that, bro? Cause the shit they bring up, bro, that shit was just weak as fuck, bro. I'm so like.
Unless there is an objection, we'd also take out the part about the way that he wants to do his lawyer. But you know, we don't mind playing it. But I wasn't going to play that part, but it doesn't matter to us either way.
So there'll be objection if they redact that part.
No objection.
All right. Thank you.
Like, eating their ass up.
We object to the whole thing.
In here, this is not the time right now. Everybody get out. Everybody get out. Mom, can you get out too? Shut though. I'm not calling phone. You know what I'm saying? See, that's why I don't pick up my damn phone. People keep telling me that, just trying to keep your head up. Here, a real one, for real.
That's all you hear. Oh, you're real. Man, that shit don't do nothing for a nigga. That shit don't make a nigga feel good. That shit don't do nothing for a nigga.
I really get out this house.
Oh, hell.
I can't believe we're still
Told them
listening
about
to this.
do what name, nut name, yet name. Okay, yeah.
Get that shit on me too.
Okay, yeah, nut, do what. Oh, man. My head hurt, man.
Okay. Yeah, I think this is just cruel and unusual. Like, for real?
You all like that, baby.
I'm stopping at 9 minutes and 5 seconds instead of 9:20.
All right.
So, Your Honor, from what I hear, Mr. Stillwell is calling someone who lied on him a rat, and that's something I will deal with. I don't have any problem with that.
All right.
As far as 640, we have a complicated situation. I don't know how the state is going to try to play this, but there's a way to try to play this that would likely mislead the jury. I would hope that the state wouldn't do that. In 640, factually, Your Honor, Mr. Stillwell had been charged with this murder with Mr. Copeland and others. Mr. Stillwell brings up yak and doo-wop. The reality, as people in the criminal justice system and are familiar with Fulton County know, that you have a prelim. And at the prelim, yak and doo-wop came up in the statement, in the testimony about what other people were saying. So it is completely logical that he brought up yak and doo-wop there. However, if the state wanted to mislead the jury and not tell them about a prelim and not tell them about how yak and doo-wop were brought up in the prelim, they could try to twist this into something like Shannon's bringing up people that weren't even charged. But I mean, we're gonna, if we need to have 3 days educating the jury about how the criminal process works in Fulton County and preliminary hearings and all the rest to really complicate matters, to explain that to them, I guess we can. I prefer not to. But he's just recounting what was said at the prelim. So I would object. It seems like a simpler solution is just to take out where he's talking about yak and doo-wop at that time.
Judge, June 10th, I believe we are midway, if not further along in the Copeland interview. I believe that it's Mr. Copeland who is bringing up these names that Mr. Shard is talking about. I don't hear Mr. Stillwell talk about a preliminary hearing. I hear him say they're bringing up.
So this conversation is November 19th of 2015, right?
Yes.
All right. What you said something about June 10th. What are you?
Just that prior to that time that Mr. Copeland was the one who was bringing up these names.
Did anybody have a prelim
They all did.
on a couple of days before?
They did. And Mr. Sledge, as the state is very aware, in these other phone calls, there's discussion about the prelim, and Mr. Sledge's case was dismissed for lack of probable cause at the prelim, and the testimony or the statements made by other witnesses, including Mr. Copeland, was discussed at the prelim.
Okay. Well, I mean, I don't know that you can tell from here what he's saying is somebody else let these names out. Somebody else is throwing these names about, and your client seems concerned about that. And that's relevant. I don't know that it's relevant how he heard that was going on, but it doesn't sound like, I mean, it sounds like as long as they play the whole thing, he's saying, you know, whoever this is throwing these names around. It doesn't sound like he comes up with that on his own. He's talking about this other person is saying these names.
Right. But here's the dilemma. It's an unindicted case at this time. He doesn't have discovery. And what I am concerned of is the state saying, oh, wow, probably in closing when I don't have a chance to respond anymore. Oh, wow, what a coincidence. Shannon Stillwell on that jail call is saying yak and doo-wop, even though they weren't charged at this time. That just proves everything. And the reality is those names were thrown around in the prelim days before.
All right. Well, they may have been thrown around in the prelim. They may have been thrown around
Of course you're
in
gonna keep it.
interviews. Apparently, it's a whole lot of gossip that goes through the jail. But the state needs to make sure that they don't
We couldn't do that.
mislead the jury during the evidence or in closing with something that you know it ought to be true.
We agree with that.
Okay. All right. So it doesn't sound like there's an objection. It just sounds like there's some caution about how this might be used. And I'm telling the state right now, you better not use it in a way you know is not supported.
We agree and understand.
Okay.
This is wild.
Notes are clear. To recap, November 19th, the state is planning on playing 1:27 to approximately what time?
That was, Your Honor, 1:27 to 9:05.
9:05 minus reference to
The
bond and
bond,
criminal
yeah.
history and minus reference to wanting to slap an attorney
That is correct.
who is not me.
Who once again is not you. All right.
The next call we'll play is November 23rd, 2015 at 16:08 p.m. from 8 minutes and 50 seconds till 16 minutes.
What your book look like? You straight?
Shit, I'm gonna have $6 on them.
So when y'all go back to court?
On the 18th.
And what they said, a hearing?
Nah, I just did the preliminary hearing.
So ain't nobody get no bond?
Nah, they tried multiple trial because multiple had a lawyer. They said the same thing about both of them. They tried all multiple trial. They did only thing different was the little nigga name, Deep Cleveland. He told me, I told him I did it. So they was, he said that's the only different thing. Then he just wrote multiple to my, man, oh God, bro, I ain't say that, bro. I go to court before no police lying on me, did that, third.
So multiple got the lawyer.
Yeah, multiple got all this shit, they missed.
So if you would have had a lawyer, you would have got your own than me?
Hell yeah.
How much, what he paid on? I called my man.
Huh?
I called my man and see what's going on. You ain't got nobody else who you think give you nothing on lawyer?
Shit, I ain't called. But Kim just telling me got down to call him my knees on and shit.
Who?
Kim. I ain't calling it though.
Who?
Kim Tay.
Kim Tay?
Yeah.
Man, them niggas that be talking, bro.
Yeah, that's what I be saying. That's why I ain't really just put no effort. Like that fucking stuff was been sent the lawyer down here. That nigga, he keep coming down here, but he just like, shit, Doug keep telling me he ain't got all the money yet. Now fuck you, money yet.
Who's saying that?
Oh, that was the lawyer. Like, the lawyer keep coming down here though, but he just like, shit, I won't go and represent you, but he keep saying Doug saying he ain't got all the money together yet.
How much they charge?
This nigga, he ain't telling me the price. He just like, I told Young Thor he gotta give me everything or nothing. It's everything or nothing. That's all he kept saying.
So he want all his money at one time. He don't
I
want
believe
down.
he's doing that. He doing that because of Thor. You feel me? He knows I don't got money, so hey man, I want all my money.
You ready? Yeah, that's what I'm saying. Cause most lawyers, they do a payment plan, bro.
Yeah, exactly. New lady talked to some lady and she was like 4,000 some shit. She was
4,000 for what?
Start.
Man, that nigga I had, he want that money, bro. Yeah, now nigga who beat my brother murder case. You know, I'm cool with him. He don't even want that much. 4,000 start, that's too much.
Yeah.
I probably give him about 2,500. He probably put me on payment plan like every 2 weeks. Probably pay like $350. Right, what?
That's cool, man.
Mm-hmm. Hold on, sir. Well, so what you got out of here? What you got now? What you got now?
Most of they got now, they got all them aggravated assault shit that they had. Aggravated assault, aggravated battery, all that shit, some gun charges. No, they had
what part of that truck? That murder truck?
Yeah, they just dropped the murder charge out of them.
Man, that ain't shit. That's based on just like that.
Yeah. That's how he got like, they got like 9 charges apiece.
You know what they'll try to do, bro? Drop that murder and stack some on the aggravated assault. Cause they're like 20 years.
get what the lawyer said, you know, he was like, man, listen, he was like, if everything go bad, he was like, you'll be looking at 20 and Mr. Schledge will be looking at life without parole. I said, God damn. Who is? Moonstone, he was saying, Moonstone will be looking at life without parole. I said, God damn, why the hell you gonna do that? He like, shit, that man record's fucked up. Then the other choice he's facing. I said, good God. That's what I'm saying. Them aggravated assault charge and all that shit. That shit.
And then we need to say this part we would not be keeping in, the part about the sentence and the punishment for those charges.
All right, thank you.
Because I have from 12:15 to 12:40, there was discussion about likely sentences. According to the lawyer, whomever was advising Mr. Stillwell, apparently, according to him, this lawyer said, if everything goes bad, he's looking at 20 years and Moontuk's looking at life without parole. When you say we're not getting into the sentencing, we're including what Mr. Stillwell is facing, correct?
All of the sentencing for all of the charges, this portion that mentions sentencing, we would redact.
Okay.
Okay.
Still the same thing. Yeah. But murder, they just make niggas say, woof, these ain't got this. They got to fight that red stuff. You know, that shit, they be better though, like that murder, you facing the murder charge and them, that shit better because them folks telling on them, like, the nigga mama, she like telling them folks, like, yeah, they did it. And then Lil D telling them folks, like, yeah, home with me that night. And they said, Lil D already told him he did it. And, Lil D told him he did it when he left the club. Lil D? Yeah, he told him he did it. And he told them that most of them were with him when he left the club. So they like, shit, he with you, then he had to do that too. You want to talk about that? Yeah. No, he take pictures. No, the Fed. Oh yeah. No, babe. I told you a proud investor. See, so we pull up. See, y'all talk. Damn, hey, how you doing? I'm not gonna do this like that. Give her an oh Lord, she gonna say the why they
All right, I'm sorry.
Yeah. That's what the Wu says don't do this. Yeah. Nigga say anything, try to say they ass, but yeah. No, you know that shit be having it down, but I just really be shaking that shit. No, I'm saying that shit be crazy. You be with a nigga 380 days, 180 days, whatever. 2 years, 5 years, and situation pop up, and you're like, boy, he did. That be crazy. I want him to touch me, bro. Exactly. The nigga sit right there.
Thank you for using Securus. Goodbye.
Man, I wish we could ask them, like, how many calls do y'all have? Oh, is that all for the calls? Praise his name. Oh my gosh. It is a jail call. That was a jail call. Prayerfully, it's over.
On this call.
Oh my gosh.
There is extensive discussion about the issues Mr. Stillwell is facing hiring an attorney. I don't believe that that should be relevant. That's A. Regarding 13:15, approximately at 13:15, as I hear it, Mr. Stillwell is saying that Mr. Sledge told him that that someone, and I think it was Lil D, said that he being Sledge was with him during a separate incident, which I believe to be the 428
please don't say-
incident shooting up houses. But in that segment that starts at approximately 13:15, we have Mr. Stillwell passing on hearsay from Sledge about what Lil D supposedly said about Sledge in I'm not going to say non-related because it is on the indictment, but non-related to, it seems, the Donovan Thomas case situation. So that seems to be hearsay wrapped into a statement by my client. I don't believe that should be admissible. And that's 13:15. I don't have an end time. And then, quite frankly, after 13:15, there seems to be a lot of kind of laughing and giggling that don't really have a lot of relevance to anything that I can ascertain.
Okay. So we got the discussion of the lawyer, the kind of hearsay from what Lil D said, and then the sort of end of the call. Sorry. Yep. I just was summarizing what Mr. Sharp said.
What I heard in the court summary was the discussion of the lawyer, the summary of what Rudy said, and then the end of the call.
Right.
Okay. So in terms of the lawyer, as I said earlier, with respect to what the lawyer is saying about sentencing and all that.
Yeah, no, I know. We all know that's out before that.
But the part about defendant William, or Thug, as he puts it in the call, getting him a lawyer, I'll point the court's attention to over at number 97, wherein there is in the lyric of the song Just How It Is, the assertion gave the lawyer close to $2 million. He handles all the killings. We don't speak about shit on wax. It's all my business. We know how to kill the biggest cats of all kittens. And so our assertion would be, considering that Mr. Stillwell is discussing a lawyer who has been sent down there to talk to him by defendant Williams, and that he wants all his money up front, that could be, their inference could be made by a jury reasonably assessing the evidence that this is part of the proof for that particular overt act. It's not just in a vacuum discussion or negotiation with the lawyer. It's who's providing him the lawyer, what it is the lawyer is asserting that he wants.
Okay.
So that's our basis for the relevance of the portion about the lawyer.
All right. I agree that's relevant, and I don't see 403.
Of course you do.
issue
Of
with
course you
that.
do.
All right. What about the kind of hearsay reporting that Lil D says or kind of admits to have done it, and that Montauk was with him for one of these other?
It goes to show the level of awareness within the jail by defendant Stillwell of what other people were saying, and the fact that Lil D swore to God the police lied on him. It would help explain. I don't know what, and I think he's actually talking about Garlington, but it was Quindarius Zachary was one of the people that told that he and Mr. Sledge committed the April the 28th shooting on Adele and Drew Drive. And to the extent that either one of YSL members, Shannon Stillwell himself or anyone else, confronted him about telling, the fact that he's asserting, I don't know what the police are talking about, they're lying. It speaks to this culture of you're not supposed to snitch, and the fact that they know that they're snitching. If there are changing stories, it would help the jury understand why stories get changed when witnesses take the stand, in particular the witnesses that we expect will be called, and frankly one of the witnesses that's already on the stand now.
All right.
believe that what Ms. Love is using to defend that portion is not in the portion that I'm seeking to omit. There's a discussion about Lil D told, and then he swore to Sledge that he didn't tell and the police are lying. Okay, that's not what I'm talking about. At 13:15, there's a discussion about Sledge saying that Lil D told on the 4/28/15 shooting, told on Sledge. It seems to me
That's a co-conspirator statement. Sledge telling him, or if he's discussing that Antonio Sledge is bemoaning the fact that Lil D told, he's apprising him of the fact that someone's snitching on a member of YSL.
well, we just changed the verb. He was bemoaning, and now he's apprising. The bottom line is he was bemoaning, it sounds like to me. He was bemoaning the fact that Lil D told on him on something that Mr. Stillwell is not charged with. So I don't know how that's relevant.
The fact that the information is getting passed along through members of the gang to other members of the gang is what we believe is the most relevant part of it. And it explains, it's defendant Stillwell's assertion, his asserted knowledge, and it explains people's behavior when they get in the courtroom and tell God's honest truth.
Okay.
Mr. Stillwell in his calls makes it clear that he's being transported to all his court dates with Mr. Sledge. That's not a mystery. The state puts him in the same bus, and apparently, I'm not denying that Mr. Sledge would have probably talked about things going on in his life to Mr. Stillwell, but this is a completely unrelated incident that Mr. Stillwell is not charged with. So,
Well, he sort of is based on the RICO count. I mean, I don't know that he knew he was going to get charged with RICO at the time, but
let me just add this, just for the court's understanding where I'm coming from. Mr.
okay, do not come back in here with that if that's going to go off again.
Somebody in trouble.
Mr. Stillwell, Mr. Sledge and Mr. Garlington pled guilty to this
Right.
incident. So,
Okay, and
Stillwell, Mr. Sledge and Mr. Zachary, I should have said, pled guilty, and Mr. Garlington.
right. And so how is it a co-conspirator statement, I guess, is, I think, the gist of, are you just saying relevance, or are you saying something beyond that?
The state is always saying to in furtherance of the conspiracy, and I'm just failing to grasp how Mr. Sledge bemoaning about that someone's telling on him is in furtherance of any conspiracy.
Okay, so yeah, that's the issue on the floor.
So it's the statement of Shannon Stillwell about what Mr. Sledge has said, and it's showing Mr. Stillwell's awareness of what is happening with other members of YSL and these charges that each of them are facing.
Right, and how is Sledge's having told him that in furtherance of the conspiracy?
Well, letting
Buffering.
one gang member know that another is telling on them is letting that other know and to be aware and wary of, as that other also told on Shannon, let them know and to be aware and wary of that person ratting and telling the truth on the gang itself. It's apprising them of something that may harm them.
Okay, all right, I'm gonna let it in under the co-conspirator exception.
What?
Right, and then there's the part that's sort of the end. Is there anything relevant in that part?
Not beyond the part where he's not at the very end. There's a little bit, and when the court says the end, I'd have to go back because I think I played it.
Well, I
all.
guess everything after that little part is about the, what Sledge says about Lil D saying. After that, is there anything? And there may be.
Let's see. Hang on one second.
Sure.
I'm checking my notes. This is it right here. I see. My recollection is there's not, but I mean, to be safe, I can just start at the about a minute before the end, replay it.
I would ask if we could start at 14 minutes because I believe there may be something.
I asked that we just let this all go. How about that? But I'm just being petty, I guess. I'm starting to see that, Jazzy. I'm starting to see that.
We're starting at 13:35.
Him, when he left the club, so they like, shit, he with you, then he had to do that too. I don't even want to talk about that. Yeah. No, no. Jose. Yeah, Jose. He take pictures. No, the Fed. Oh, yeah. New baby. I told you she a proud investment. See, so when we pull up, see, y'all talk. Damn, hey, how you doing?
I'm not gonna do it like that.
Give her an oh, Lord. She gonna say, why they, should I let her now? What'd you say? Y'all talk. Pulled up. Oh, Lord. She once told me there was new baby number. I was like, I don't know that number. She said, that new baby, what you gonna call your phone? I was like, Michelle? She kissed.
Shout out to Doug Weinstein. Sitting there on his phone. He's probably on Twitter. Shout out to Doug.
Now I'm saying that, you seen Shot go down there. Yeah, you know, them folks would cook me and everything. Girl.
You have 1 minute left.
They talking crazy. They just talk shit. Well, you would talk shit, you just like, you know how niggas just shaking their head. And I gave you a young nigga over there, the young nigga was like, shit, I got down talking crazy with that little bro, but shit, you know, nigga Ryan, shit, them niggas just talking about they guns up. Shit, yeah, guns been up. Yeah, I ain't stunning them niggas, man. Fuck them. Yeah. They took my the Wu said something too, then. Yeah. Niggas say anything, try to say they ass, but. Yeah. So you know, that shit be having me down, but I just really be shaking that shit. That's what I'm saying, that shit be crazy. You be with a nigga 380 days, 180 days, whatever. 2 years, 5 years, and situation pop up and you're like, boy, he did. That be crazy. I want him to touch me, bro. Exactly. The nigga sit right there.
Thank you for using Secure.
All right, here they go. I was cutting it down because it was just
Hello.
rambling.
This is a prepaid collect call.
So to answer the court's question regarding the portion after that snippet, there's a 14 minutes and 15 seconds and 15 minutes and 15 seconds that we do not need to play. Starting at about 15:15 and going down, we think that that portion is necessary to play. It entails a couple of things. They're talking about Woody telling, they're talking about, the little N saying guns up, and I'm saying guns stay up. We believe that that's a reference to Peter Rolak, sex, money, murder, Bloods. So for that portion, we believe it'll be relevant.
I mean, those seem relevant. That other part in between, you can redact out.
Yeah, I don't know what the state's talking about with the guns way up thing, but I would ask that the last minute be played.
I'm sorry, you would or you would not?
I would.
Okay. Got it. I think they will. Right?
Yes.
Okay.
That's what we were saying. From 15 minutes and 15 seconds
Okay.
to the end,
Okay.
we were playing that.
All right. Let's move on to the next part. Or the next call.
The next call is December 4th, 2015 at 15:48, starting at about 11:57, but just we'll start at 11:30 to be safe to give context.
Again, thank you everybody who's tapped in and hanging out with us today. I know this is an arduous process, but they're going through all these jail phone calls. So prayerfully, this is hopefully they're drawn to the end, but we'll see. Thank y'all so much for hanging in. If you haven't hit the like button, go ahead and hit the like button. Jump into the chat. Best live chat on the planet. I appreciate y'all. Thanks so much.
Don't wait on no $300, man. That shit, wait, no stuff, man. And these folk off me 5 to 2 yesterday. Man, you think I'm finna go? Hey, bro, no time. I ain't fun out, man. Like, what the fuck? Man, like, fuck out that jail, man. Then these nigga with this fuck shit yesterday. Nigga, man. Oh, I said, fuck a YSL. I ain't finna go ahead.
All right, so
YSL won't even fun. I want to fight for their ass, too.
This is not my client.
I swear I'm finna go in there and get big shell carry lad, bro. Straight up, tell him through the gas bone, everything, bro. I'm like, nigga, what's up, then, nigga? Nigga, I don't give a fuck what you talking about, nigga.
No, it's not. In the beginning of the jail calls, it says who the call's from. These are from a gentleman named DJ. I don't know why the state believes it's my client. It's not, though.
We'll verify before we would speak to Mr. Sharp. So we'll pass on. We'll hold on this one.
Okay.
It's my stance isn't changing. It's verified.
Understand his position. We'll look at it again, and if we feel differently, we'll bring it to the court's attention. But right now, we're not planning to play it until we look at it and reassess it.
they're getting a little snippy. John C., first of all, it would be a ton of information that maybe isn't appropriate. It doesn't apply to it. Because you see right now, the state has been bringing in information that's not appropriate. And you don't want the jury to be sitting there bogged down with 200 jail calls that are not, and let's say,
Do you mean 2015?
a lot of them are not even relevant.
You said that before. Is there one of them that's from 2017?
Yes.
Okay.
I know.
That was Brian. That was Max Shard
It's-
was speaking.
Let me make sure we didn't label that wrong.
If it is 2017, it is definitely not my client. I'm jail call.
Yeah, Max Shard is getting. Look at.
Kind of odd.
It was a typo. It was a typo.
Of course, it was.
It was, I'm sorry, it was a
Okay.
typo.
2015.
Yes. And we're gonna go from eight minutes and 10 seconds to 8 minutes.
My
and 30
pleasure, Tracy T. Thank you for hanging out with us.
It is, for the court, it is December 4th, 2015 at 17:31. And it is going to be from approximately 8 minutes and 10 seconds to 8 minutes and 30 seconds.
Thank you.
That shit on there. Stop, shit. Yeah.
But I still want to add one question though, babe. Is y'all fucking with
Who?
you? You know what I'm talking about.
For me, baby?
No.
Who?
Oh.
Oh. You to my, him.
Mm-hmm.
Yeah, he want to pay for everything.
Oh, okay. You're right.
Judge, that's a short snippet of the call. We believe that the him that he's referring to is the same person that he referred to as providing or sending down the lawyer earlier. That would be our argument for it. If there's an argument that we need to play additional portions of the conversation by Mr. Sharp.
I mean, is there some context either within this call or what's going on that day or something that leads y'all to believe that?
The only context, Your Honor, is that prior to that exchange, and I'm not representing that it's immediately prior, but it is prior in the fact that my notes, one note before this is Shannon says he had talked to Kente. Kente, as it has come out, I believe it's come out in this case, is the owner of Club Lacura, Lacura, which is on Metropolitan Avenue. So that was, I'm just saying, on my notes, that's the note right before they say, is Shorty effing with you? So I know what the state's trying to insinuate, that Shorty is Jeffery Williams, but no, there's no context that suggests it's Jeffery Williams. And what I'm saying is, according to my notes, there is some context that suggests it is someone else.
I'd like to play 7 minutes and 29 seconds.
Hey, too much.
Yeah. I love you, boy.
Man, come on, man. You know what's up. Don't nobody know what's up. You know what's up.
Oh my God. God, it's my heart back in my life.
Yeah. This shit gonna be over, real soon.
Oh, you gotta come home. We gotta get on the real grind. We gotta get on the grind.
That's how I've been telling him can't take everything. He like, man, what the hell? How the hell you get into this shit? Like, you know how this shit go, man. Stop, shit. Yeah.
But I still want to add one question though, baby. Is y'all fucking with
Who?
you? You know what I'm talking about.
For me, baby?
No.
Who?
Oh.
You to my, him.
Mm-hmm.
Yeah, he want to pay for everything.
Oh, okay. You're right.
I was saying, you my bitch, my nigga.
Man, I don't care nothing about no hoe.
Yeah, Shawty, he doing all right, though.
Yeah, I'm gonna be hungry, that's all. I ain't gonna never stop that. You know, they thought we all told each other.
I know, exactly.
I love you, though, baby.
I love you, too.
Home.
Huh?
I want you home. What we got?
So, Judge, what I did was
They're talking about somebody else when they start that conversation. Because at first he's like, oh, who do you mean? Oh, you mean So they're not talking about the person they were talking about a minute ago. Now, it's an argument that the state's going to have to make. Sorry, it's an argument the state's going to have to make. I don't know whether the jury's going to buy it or not. Y'all can argue differently. But I think it's certainly a reasonable inference. So I'm going to permit that.
What was the argument?
Thank you. The next call, the last call that we have, outside of the ones that we have just said we're not going to do for now,
all right,
is the December 7th, 2015 call at 16:55 from
Wow, this is crazy.
13:30 to 1600.
That's a great question. Look at Doug. Doug has had enough of this. Chicanery. Good gracious. Yeah, this jury is going to be struggling through this. This is going to be wild.
If you have no teeth. I know that lights, right? I have an ear from yesterday, right?
Yes, the jury can take notes.
You remember when the nigga got on the phone with blood? He got on the phone. You remember when blood nigga got on the phone? When we called Bull, Joe Child, all them niggas.
Oh, okay. Well, yesterday, yeah.
All right. So you remember when he was like his big home name Montana? You might don't, but he was just like his big home name Montana.
And he run Rushby.
Yeah. I'm not thinking this nigga Montana is the same guy I got rolled with, like you ask me who just at Willow with me, like that bull just be like, bull, what the hell?
All right.
Like, anyway, he was just
I'm going to
like,
lower it down because they're not really saying much. Just a lot of foolishness, but.
Like, and when he came in here, he was like, hey, yo, HB, why who the hell that is? Like, it's Montana, bro. He ran from a dope, showed his face, and ran up to his room because they tell him to go in his room. I was like, swear out Montana, these young niggas up on you. He was like,
You have 1
yeah.
minute left.
He was like, yeah. I said, man. Yeah,
Wait, they've been talking about Montana in here.
He's like, man, look, bro, I heard about that shit. I was telling niggas like, you my personal, this, that. I'm like, yeah. But that shit crazy. But like, okay, but I was listening yesterday, and the nigga who I was telling you who was slick Hank downstairs, he pushed up. When I was like, man, these niggas being like fit, these niggas some hate, these niggas Hank, these niggas be throwing YSL.
This is craziness.
Oh, yeah. All right, he walked over to my channel, so I didn't know each other on the street. So I guess he just talking. And I just heard my name. Now I just heard Lil Bro. And I heard my channel say, man, that's not personal, punk. Anytime I'm home, I'm going to hate shit about it. So he like, yeah, I fuck with bro. He here real right nigga, but I be sick.
Thank you for using Securus. Goodbye.
This just seems like a recap of the whole Montana situation. They're just rehashing the jail call that the state's already going to be playing.
Cumulative.
If Your Honor is going to allow this in over my relevance and cumulative objection, there is a point where Mr. Stillwell says something to the effect of, I knew him from when we were down the road. That is common parlance and for being in prison, and so that reflects on my client's character.
Okay. We agree that will come out, the part about prison or being down the road. And with respect to the remaining portion of the call, is the reference to throwing up YSL in the context of that similar call as the other one. That makes it different and a little bit more.
I mean, there's a specific mention of YSL, so I don't think that is cumulative based on that. So I'll admit that.
And Judge, there was one more call. I said this was the last one, but there was
Wow.
one that we passed over.
Okay.
It is the November 18th, 2015 call at 1843. I don't believe that we played it. I think we referenced it. Okay.
Negated that yet.
Okay.
So fun.
You.
Your neighborhood rolling 60 cars? Ain't nothing. You rolling 60 neighborhood? Your neighborhood rolling 60 crib cars? You what? What is she like? Hello?
You need to stop playing with people.
What?
Okay, you need to stop playing with people.
Neighborhood rolling 60 cars? What? Yeah, right. We the second field. We the first. They work. Yeah. Sunny side the fuck up, son. Shine up and line up. Straight up and lay up. Yeah. You know, it's always a shine to the nine, though, you know? Shine to the nine, my dude.
Yeah, me shit. Oh. Oh my gosh, this was just do
We went to 434, but it was really 428 that the call stopped at. And that was just from about 320 to 428.
Is that the entirety for that call?
That's
Shard
the part
sounds
that we're
mad.
looking to get into.
I don't understand the relevance. If it, yeah.
What's the relevance and how is it not cumulative?
The first call with respect to Shines and G Shine and the defendant Stillwell was dealing with his blood credentials. This call shows him interacting with who he believes is a Rolling 60s Crip. Martinez Arnold is a Rolling 60s Crip who we also allege is a member and who has pled to being a member of YSL, the criminal street gang. During the course of this trial, there have been repeated efforts on cross-examination to disprove the state's assertion that YSL is a criminal street gang.
And that it's hybrid?
Yes.
Okay, so this goes to that?
Yes.
Okay. And I will allow it. All right, that's it for these. Sorry, Mr. Harvey, that's it for these this set of jail calls?
Yes, for Mr.
Okay,
Stillwell.
for Mr. Stillwell. All right, let's take a break. Not quite sure what we're going to tackle next, but something.
Y'all got 2 more days, though.
Let's take 15 minutes.
Y'all not going to take 15 minutes. You're going to take 45 days. Wow. Okay, I'm gonna let that marinate. Yeah, James, I don't think I'm sorry, John C. I think this would be, hear me, like just look, in this day, the state has tried to install or insert rather 3 phone calls that were not anybody that's in this trial. That's just what we saw today. There's countless others that are still going to be contested. If the jury had to sit through all of that, it would be crazy. There's no benefit to it. And it would only be prejudicial because, again, like with the whole Young Thug paid for my attorney, what would be the benefit of that but to cause the jury to think something different? Or my attorney came down to talk to him, and the only attorneys they know are Brian Steele, Adams, and Shard. It would be crazy. There would be nothing. It would only create more problems. Not like this ain't better though. Let me just be 100% there too. It's not like it's super better, but if they were able to see everything, all these ins and outs, it would only confuse. If you believe all the state has is Woody's statements to convict, hang on to your hats. Okay, no problem. Okay, probably so. Probably so. Yeah, judge has been arguing for the state, for sure. Mailbox time. Let me know if you got anything in the mailbox, Debbie. Okay. Is it evidence though? The state is reaching. There's no irrefutable evidence. It's all alleged with no real proof. I agree. I do agree with you. No argument at all. Okay, so just a good back and forth. I appreciate the good conversation and the good dialogue. Y'all, we got to change a tomorrow and Friday. I'm gonna add a new poll in a second. I'm gonna add a new poll for tomorrow, just because. Yeah, I'm not expecting that this is gonna get much better. So for Thursday and Friday, we're gonna do 9 a.m. Eastern Standard Time until 11 a.m. Because if they're just going through this, there's no reason. And then we'll kick back up. We'll kick a new live stream off at around 3 p.m. EST until the end of the day. So until 6 tomorrow. I'm just going to put it in the chat right now. And because it just seems like, especially listening to jail calls, listening to people using profanity and all that kind of jazz like that, it's not really as fruitful and beneficial as I would like it to be. So I'm gonna drop that in the chat. Shout out to Diane, says free Young Thug. All right, I agree. Definitely think there should be some freeing. There should definitely be a better court case for Mr. Thug for sure. Oh, did it not go? It didn't go. Darn it. Okay, so it's not really a question. I was just letting you all know. So I posted it in the chat, and you'll see the thumbnails tonight. It's going to be 2 separate live streams tomorrow and Friday. We're going to start at 9 o'clock until 11. See if anything pops off. Take a break. Go check your mail. Go do your life. And then we'll just come back at 3 o'clock and go from there. Because, yeah, this is just long. And it's discouraging because the stuff they're talking about is just wild. I'm sorry, John. I would be overwhelmed. It would be the amount of data. If the jury was just in the box all day, even during the horse trading, the amount of data that the state would throw out there would be voluminous. It would be crazy. We've already watched them do it. I don't think that there's a benefit I think the way they're doing it is right. I just hate that the state is still trying to bring in stuff that doesn't work. Because again, like just today, they had 3 examples of information that was not true or right and whatnot, and the jury would have been exposed to that. I don't think that would have been a good thing at all. Yeah, I don't get I guarantee you, if it sounds this bad for us, it's so much worse in the courtroom. Because there's no, I mean, it's being pumped through the audio for us so that you got to catch it's being shot out into the room in the courtroom. So yeah, that's going to be wild. Yeah, I should have did that today, truth be told. Yeah, I should have did that today because it's just, if I had realized that they were still going to be just listening to tinny sounding jail calls, yeah, I should have done that. But I learned. I appreciate it. Thank y'all so much. Let me see. Anything else here? Good deal. Man, I don't know what 15 minutes she's talking about. Judge Whitaker said 15 minutes. I think we're definitely past that. But no, I don't think the state has proven their case. I'm sorry. Well, one reason is the state's case is gigantic. In order, they would have been much better off, in my opinion, trying to prove that, there you go, that these men did crimes. I think they could have. I do think there was crimes committed, and I don't think these gentlemen were just put in jail because they're black or whatever. Like they're rappers. They did commit crimes, and so I think charging them for crimes committed or booking them for crimes, I think would have worked. But to this gigantic behemoth, aka RICO, which is much more than just saying somebody shot somebody or somebody robbed someone stole a car, is so much more, is the problem. Because I think they could have everybody would probably be in jail if they had just said, hey, we're going to book this person. We're going to charge this person with this crime. We're going to charge this person with this crime. These 2 people did these crimes. That would have been, in my opinion, that would have worked a lot better, and it probably would have been solved a lot faster. But if they had done that, Paul Howard would have done that early on. Because remember, Paul Howard had this case before Fonnie Willis, and Paul Howard said it's not a RICO case. Fonnie Willis said, yes, it is, and here we are here. I don't think the state has proven anything. So because the burden of proof is to do that. They have to prove all of this criminal enterprise and all this, that, and the other. And it's just not there. I don't think they're going to cross Woody on Monday. I think it's going to be Tuesday. Because as we're doing right now, remember, they ended still listening to videos. They still got calls that they got to go through with Woody. So, and as soon as I know that that's what they're going to do on Monday, we're going to make another, because we're not going to sit there and listen to that craziness. John, I don't know. No, absolutely, John. No, I'm just looking at it and I'm seeing what they're doing. And I don't think that it would go as favorably as, I don't think it would be akin to not trying to call jurors children. However, you wouldn't give your children every flavor of ice cream option available. You might say, hey, you got 3 options. You got strawberry, chocolate, vanilla, or something of that nature. There's no benefit in giving them every option available or where would you like to go eat tonight? That would be problematic. Okay. Because you just know it would be south. Like one kid would want to go here, another kid there, and the other one wants to go somewhere totally different. You say, hey, we are going to blank, and you just give it to them and remove some of the options and stuff like that. And in my example, again, not perfect, some of the examples and some of the options are not good for them. You wouldn't take your kids to go eat at a shooting range. You wouldn't take your children to go eat at a dog kennel. Well, because you're like, that's not a good eating experience. And it's not, sure, you could probably eat at a dog kennel. Sure, you could probably eat at a shooting range. It's just not the eating that you want. And it's not for what you want to do with your family. So I don't think that it's not problematic. I just don't think that it would work. And it's clear that it's probably understood that there's some information that doesn't need to be brought in because they're doing it here. And the defense and the state are in agreement, and the court are in agreement that some of this information needs to be vetted out and cleaned through and sifted out. The problem is the state has not done much of it, which is really, I think, why this case should have been thrown out on its ear. Everything against the wall. This is like literally love sticks for the last 2 days. That might be the name of the thumbnail, like love sticks. Because that's all she's been doing is just like, let me get something to stick. Let me get something to hammer these guys with. And again, I'm not saying that they haven't, I've said it multiple times. I kind of agree with you, Joe. I kind of agree, but don't tell nobody. However, I don't think that the way they're going about it is correct. So it is what it is. I don't think that these gentlemen are without fault, without sin, without crime under their belt. Not saying that. All I'm saying is I don't think the state is doing a good job of proving it, which is ultimately what they have to do. It's not just that I think they're bad people, or yeah, you kind of look like a bad person I know from another time. That's not the standard. The standard is whether or not they've proven it beyond a shadow of a doubt, and I don't think they're doing that at all. Yeah, sad thing is that we're on Judge 2 that knows the same yet lets it continue. I agree. Somebody mentioned, like, how odd it is that Judge Whitaker really doesn't seem to know much of the rulings that have happened before with the previous judge, which is just really telling to me. Either A, she's not being honest, or B, she really did not do any research. And I'm surprised at that. What does K-Way say? Let me see what you're saying here. No evidence is going to come in on Thug. It's about making the other defendants' cases messy. And if the jury convicts one of them, it will be a conviction for all. Okay, I got you. Thin line between love and Rico. I kind of like that one too. That's funny. I do wonder, do the jurors know all of their rights? Do jurors know that they can write a note to the deputy and say, hey, we are done with this. We're out. We don't believe that. The jurors can, ask questions, and they don't have to just sit there. They're not true hostages. I wonder, do they know that? That'd be interesting. And say, look, man, y'all is wasting our time. You know, wasting our lives. Hello, child. My favorite firstborn is home. Did you bring your sibling with you? Oh, there she goes. Hello there. Be right back. All right, so I'm back. All right, so apparently she's not going to be able to, she wasn't nominated to be on the homecoming court thing. But kids who were previously nominated were able to be nominated a second time when people who never been nominated did not get nominated to be on the court. So let's say, shall we say, there's drama in Whitaker Park. So I wanted to come on here and tell y'all at first, but I told her no. So there we go. That's what the issue is. Oh, and Judge Whitaker's back.
Several folders. We appear to have two for Mr. Arnold, Garlington, Kendrick's, other items, and then some, I don't know, pictures and things. So can we move through them methodically? There's a recording in Mr.
There's
Arnold's.
definitely
Is
some
that what we've already
corruption
gone
in high
over?
school election system.
Is there anything we need to take up that we haven't already dealt with on that? Okay.
Not with that I've.
Okay. How about in Mr. Garlington's folder? Is that his statement?
Mr.
Your Honor, the item in the Garlington folder is a jail call.
Okay.
And to make sure, at this time, I don't believe that jail call will be able to come in.
Okay, so state does not intend to use that. All right. And now I've lost my place. Well, what was next? Because I have no idea where I was just looking at who's gone to on this computer.
I agree,
think
Kenny.
The next folder,
Kenneth.
Your Honor, is the folder that says Diamante Kendrick.
Okay.
And there's 3 jail calls in that folder, Your Honor.
Maybe that's what happened to me too. It just went poof.
See that? There's a mic on the podium. Why do they not use that one? I thought there was a mic back here on the table back here behind them too. But there's got to be other mics.
Ms. Hilton?
Yes.
So just so I'm clear, we're talking about the other folders in the sprinkle folder that have other people's names, correct?
Yes.
Can you give me a minute, Your Honor, because I can't get the courtroom Wi-Fi.
Okay, and you know what? I think we've maybe got access to some sort of a Wi-Fi router or booster that Ms. Pursfield's going to go try to get right now, so that, because I'm not really sure why Fulton County can't provide stable Wi-Fi in the courthouse, but it's a continual problem. So let's see if we can get a router or whatever it is. Not very tech savvy, so I don't know what the right term is, but something to help us.
I think they had a mic
Thank you.
on every table, but it looks like one mic every table, but there's more. There's like 3 attorneys
All
at
right.
one table.
Now, there are 2 different Arnold folders. Do they contain 2 different things? Okay.
One folder is the
Man, this is a group project.
interview.
Study
that we
hall
talked
court.
About a couple of days ago.
Right, okay.
And then the other interview are 4 jail calls.
Okay. All right.
That will more than likely, he is expected to testify, Your Honor, and
Okay.
so we would use these primarily for impeachment purposes.
Okay. All right, so we probably don't need to take those up right now.
Well, all of it, I guess, the four jail calls as well as the interview would only come in for impeachment purposes.
All right, what's in the other items folder?
This is study hall court, Kells Bells. This is absolutely study hall court.
Looks like a social media posting. It is a social media posting of Justin Cobb. So I'm not sure if you're on a you can't open it.
I could open that, or I can see a little thumbnail of that one. Is that something the state's gonna be using? Could you put it up on Zoom maybe? I don't know. Is it working for y'all?
As of right now, yes, Your Honor.
Okay.
Now the Wi-Fi broken.
I'm not sure if you have access, Your Honor, to let me in the Zoom room.
How is it like exclude people once Wi-Fi goes out or something?
Or sometime at lunch, it'll kick me out at lunchtime.
Don't know why. Okay.
Okay, slightly. Let me, because they're just horse trading. I don't even care anymore. I feel like, so Bora Bora says one risk of the defense is while the jurors will not recall or understand the discombobulated prosecution case in chief, they will then rely mostly a closing Cliff Note version. I think that's true. One of the problems, however, Bora Bora, is that every attorney is going to give a closing statement. So that's Matthews, Shard, Harvey, Steele, Weinstein. You see what I'm saying? It's just the state making their case. So it'll be Love getting up there, rambling and mumbling for an hour and a half. But there's going to be 7 closing statements or 6 closing statements from the other defense attorneys. I think that's going to shellac them. That's going to be a lot. So though I understand your point, especially if they work together in concert, if the other defense attorneys work together to coordinate what they're going to say, it's going to be a mess for them. Okay, let's see what we got.
Any other social media posting, whether the jury believed that we have that right would be a matter for, I guess, argument. But we believe that based on what we were able to find, that this is Mr. Cobb's phone number. I think Mike Sprinkle is the one that actually found that posting. And
Mr. Sprinkles.
He's free_duop. And he's responding to @Stunna Bumpkin with his phone number.
It's hearsay, Your Honor.
How is that not hearsay?
It's
because that is being offered for the truth of that being his phone number.
It's how we were able to.
Are you offering it to establish that 678 number is the phone number that Justin Cobb /Duop was using at the time?
Yes, and we would not need
to
put that particular picture up as long as the witness is testifying how, he came
The witness
about it.
being Mr. Sprinkle?
88 Sprinkle. So he wouldn't just have that showing that it was his phone number. He would have other items of evidence to show that lead us to believe that it's his
All
phone
right,
number.
what would those other items of evidence be?
I believe that we got his records, his phone records, so who the other
Well, then
calls.
That would be the way to show it then, through his phone records.
Right. So when he's doing the deep dive into who did what and how we are able to find out who is where, he starts out trying to get phone numbers for people. And this is one of the ways that
do we need to know that this is how he got it, or do we just need to know
Not necessarily. It's not one that at this time I think we would need to put up. It's just one that we had.
Okay, well, I would think that if there's some reason we need to hear from either Mr. Sprinkle or a phone records custodian, that this is the number for Justin Cobb.
And also, Ms. Hilton's reminded me, we had a number that was being used by another person who was being called. So these jail calls involved calls made to Javaris Bradford, and there were other numbers in his phone logs and in other co-defendants' phone logs. This was one of them. And again, it's going back to the fact that he, in an effort to find out who this number belonged to, I think that he, in searching social media, came upon this.
Well, I mean, it might be kind of cool that Mr. Sprinkle is good at finding nuggets in social media, but I don't know that that's relevant to this trial. If this person's phone number is relevant to this trial, then establish that through the certified copy of his phone record showing that this is his number, okay?
Yes, Your Honor.
All right. All right, Mr. Weinstein, were you able to do what you needed so that we can go over Mr. Kendrick's jail calls?
Yeah, I'm just using my phone because I can't get on the Wi-Fi here. It's a little clunky, but
Okay.
I'm almost there.
Okay.
Give me a 5
Okay, no problem. All right, how about the other, like, what look like maybe individual pieces of evidence? There's, I don't know, the one that's labeled CKNQKS, whatever, that's a picture of somebody standing by a car. Is there any objection to this picture?
I think first we'd like to know from the state what it is they believe it purports to show, how it's relevant, and
Okay.
we can respond.
Your Honor, I believe this is a picture of Javaris Bradford, who is one of the individuals that we've alleged had a part as a party to a crime in the murder of Donovan Thomas. And specifically, Your Honor, we believe he's the driver of the Bonneville vehicle initially while they were at the Texaco gas station. And this is a picture of Mr. Bradford in front of what we believe to be that same Bonneville.
Okay. At a different time.
At a different time.
Okay, that seems relevant. All right, let's move on to the next. Color copy of Sprinkle report. Y'all are going to
Using
use
the
that,
Sprinkle
that's just
right.
giving that to them for, okay.
Right.
Very good. All right, then I guess we've got some more images, maybe?
The next few are again of Mr. Bradford at different times with that same Bonneville, just in case there was.
Okay, is that what all four of those next ones are?
Except for IMG _ 03901, that is not.
Okay,
That one is the Infinity after it was sold at auction to the person,
okay.
the next owner of it.
All right, and then is the last thing just a duplicate of that?
One's a distant shot and one's a close-up, Your Honor.
Okay. All right, any objection to any of those?
I don't believe on behalf of Mr. Williams here.
All right,
No, Your Honor.
okay,
And of course, for the record, Your Honor, we would take off the comments off of.
thank you. It's working on mine, but Mr. Weinstein might need it. Okay. I think I'll just leave mine alone. our new Wi-Fi router passcode, just let Ms. Firstfield know. I should try to email it to y'all, but in case you're not getting email.
Just read it out loud like you've been reading everything else.
Okay, perfect.
Thank you, Judge. So we've got what appears to be three calls, jail calls here for Mr. Kendrick. The first one is a call that occurs on October the 4th, 2015. I'll just go ahead and set it up because it's an issue that's similar to the issue we dealt with Mrs. Stilwell earlier. On that phone call at about the 2-minute and 50-second mark, there's a conversation between Mr. Kendrick and his significant other, someone named Tasha. His mom, yeah, she's significant to him. His mom, Tasha, is a conversation about an attorney. I believe if my recollection is correct, Mr. Kendrick says something to the effect of, I've got a lawyer or getting a lawyer, and Tasha says something to the effect of, Thug is working on an attorney for you. So number one, same objection as before. I don't believe it's particularly relevant. There has been an association shown between Mr. Kendrick and Mr. Williams. And so the fact that there is some discussion about whether or not Mr. Williams is going to assist him in getting an attorney, I don't think it particularly proves anything in the case other than what the state intends to argue, obviously, as they've said before. And it bears noting that he does not get him an attorney. There's no evidence, there's no factually, it doesn't happen. He never maintains that he gets an attorney for him. No attorney ever comes to see him at the behest of Mr. Williams. So I just don't think it's helpful to the jury in any form or fashion in regards to these charges.
All right. Ms. Hilton.
Yes, Your Honor. I think for the same reasons, Your Honor, it is our contention that when Mr. Kendrick is in jail following a fleeing and attempting a elude, but when they are actually intending on going up to shoot up the opposition's home, they get stopped at a roadblock, but they were on their way to shoot at the opposition with a number of guns in the car. They then take the police on a high-speed chase, and he's subsequently arrested at that point in time. This call is important for that reason. Is the state's contention that when YSL members get in trouble, they reach out to Mr. Williams, and he provides attorneys. Whether or not the attorney comes or not, it is the fact that they believe he's going to provide them assistance. But what is more important in this call is what happens after that. So Ms. Tasha on the call says, Thug is going to work on getting you a lawyer. And Mr. Kendrick says to his mother, don't say his name, say bro. And what we have found consistently throughout this case, and we'll believe the evidence will continue to show, is there is an effort to conceal his identity, conceal Mr. Williams and who he is. And so they never reference him as Thug, oftentimes on jail calls, but it's bro, slime, or different other terminologies. And so that is also what is important with this call, Your Honor.
All right. Thank you. I'm going to admit it over
I knew it.
objection.
I knew it.
And obviously, if y'all want to cross-examine the right person or put somebody on the stand to say he never got him a lawyer, that's up to y'all.
Wow.
All right. So was that the only of the jail calls?
Yes, Your Honor.
Okay.
Of those three.
All right. Thank you. So then I think we've taken care of everything in the sprinkle folder at this point.
Yeah, don't be a friend to help your friend out. Don't be rich and be able to be a
Yes,
means of help,
right.
I guess.
Okay. So then I think that also means we've taken care of everything in that whole entire 1 through 30 witnesses. Yes, let's pat ourselves on the back. All right. We can move next to, don't we have this same thing for 31 through 60? We can move to that, or we can move to the wiretaps, or if there's something more pressing, y'all tell me. But we're not going to waste this time we have without the jury getting stuff done.
31 through 60 would be more pressing before the wire.
Okay.
Your Honor.
All right, let's all find that one. And is that a different Dropbox link? Can you remind us what the email would be for that one?
Yes, Your Honor.
Thank you.
The initial email was August 12th, Monday, August 12th.
Okay, thanks.
Yes, Your Honor.
Your Honor, for the box 31 through 60, Mr. Ryan has 31 through 35, and that's the one we're discussing with the state in the background.
Okay.
So we're still working on that.
Okay, so 31 through 35 set aside for now. Okay.
Working on that.
All right, that's fine.
Okay, thank you.
The next folder says 32 through 39. And there's only one witness in that folder, that's Officer Rogers. There's nothing in his folder, so we can move to the next folder.
Okay, I don't actually, I'm still waiting on the email, but
So am I.
You got it. Okay. Thank you, Mr. Swanson.
well, I know it doesn't come directly to me, and Miss Pressfield's downloading everything now, but that's fine.
It hasn't come to me either.
All right.
Code 931.
Okay, go ahead.
So we can start where it says counts 3 through 7, Your Honor, that folder, Acts 88 through 90, armed robbery, DeWan Maynard.
So Melinda, we'd have to go over the bond motion. She explained that basically, I think there's three things they're looking for, and it basically said they're a flight risk, they're a threat to society, and other things. So that's why they didn't give him bond. So that's why they keep him in jail.
Everybody ready?
We are.
Okay. We're gonna just start with the Colin Russell folder that's in there. Ms. Hilton? Yes, okay. And are these videos or just images?
No problem at all, friend. No problem.
Okay.
Night of the armed robbery.
All right. And does anybody have objection to any of these 3 videos?
Not for Mr. Huey, Your Honor, as it relates to these videos. I assume that it's going to, proper foundation will be laid to get them admitted.
Anybody else?
Nothing on behalf of Mr. Williams.
All right. No. Okay. And then that last one looks like it's maybe a cell phone. Is that a video of something being shown on a cell phone, or what's that?
Yeah, let's look at that. Yes. It is a video, Your Honor.
It's a video from, we're alleging it comes from Mr. Huey's. It's someone taking a video of Mr. Huey's Instagram page.
Okay.
So we will lay the proper foundation to get it in.
Okay. Any objection? Assuming proper foundation?
Understood.
Nope.
No objection, assuming proper foundation.
All right. Let's see what's in our next folder. Joel Hines.
There's nothing in his
Oh,
folder.
you already said that, didn't you? Folder number 38, Mr. Maynard. A lot of images. Everybody take a second and look at those and let me know if there's any objection to any of that.
Your Honor, with respect to the second photograph on the first category, on the first line of photographs at the top, the second photograph to the
It's
right.
like the hand and arm.
Yes, Your Honor.
Okay.
I'm not sure. The Instagram says Hunchoke K, HUNCHOKAE. Maybe the state can talk to us about foundation for that.
Yes, Your Honor, that is the picture of the victim in his hand. That's the picture that the victim provided to us to show that those are his items that were stolen from him during the armed robbery.
Okay. With that information, any objection?
So just so that I'm clear, my understanding, Your Honor, is that this is not the alleged victim's Instagram account. So I guess they'll have to deal with that if they call
I
him.
mean, not really, because what they're offering it for is to show that these were the victim's items that got stolen.
During the
So
armed
it
robbery,
doesn't really
yes.
matter where the picture came from if he can say that's my arm and that was my ring and my bracelet.
We believe we have a different understanding of who the
Okay.
photograph that is, and we'll deal with that at trial.
Oh, you think that's not his arm?
That's-
Is this victim going to testify?
Yes.
All right, well, we'll see what he testifies to. But it doesn't matter whose Instagram it came from. If he's is going to testify that those are his items, I assume on his arm. I don't know. We'll see. Okay. All right, any of the others? We have lots of pictures of Guess a lot of jewelry got stolen, maybe?
Yeah.
Your Honor, I don't know. Obviously, the state has to present their case as they see fit with respect to all of these photographs. However, I do think a proper foundation would need to be laid for several of these photographs. So there may be some real-time objections as it relates to them, Judge.
Okay. Understood.
Okay.
All right, other than that, then I guess we can move to the next folder. Mr. Jenkins, that's also empty. Okay, Officer Suk.
Yes.
So he's a crime scene check?
He was the responding officer, Your Honor.
Responding
So we,
officer.
in order to cut down witnesses, we're going to bring in the crime
Alright.
scene photos from him.
All right, any objection on any of that?
Subject to foundation.
All right. Then we've got Officer Francis. And what have we got there? Any objection on any of that?
It just appears to be more photographs of the same that were contained in another folder.
Yes, Your Honor. We put the items in places where either of those witnesses could introduce the
All
evidence.
right. All right, and then we've got Officer Greer.
Your Honor, I believe that this particular piece of evidence pertained to the motion in limine that we dealt with on yesterday that I believe was excluded, if I have that correct.
No.
No?
So Mr. Huey was arrested in 2020
Okay.
for this incident initially. And when he was arrested along with his girlfriend at the time, Miss Justice Woodard, and he gave a false name back when he was initially arrested on the armed robbery warrants. And so this folder deals with the officer who arrested him on those warrants in Fairburn, Georgia.
1 second, Judge.
All right, sure.
I wonder why they're zooming in on them now. They ain't been zooming in on them.
Mr. Huey has 2 armed robberies. This is the 2019 armed robbery. He was arrested in Fairburn and gave a false name on the 2019 armed robbery. I'm sorry.
Judge,
Yes.
I do have a question for the state concerning the video that is in this particular folder. I don't believe this video pertains to Mr. Huey's arrest.
All right.
Says female search.
There's 2
That's the-
videos, Your Honor. I think
Go ahead.
on the 9th, they both were searched. So I think this is the body cam for both of.
Are you planning to show the search of the girlfriend?
No, Your Honor.
Okay. Is that the only one you had objection to?
This is not the girlfriend of Mr. Huey, according to this particular piece of evidence. That, in other words, this person that's being arrested is not associated with the arrest of Mr. Huey. That's our position.
The one that says female search or the other one?
That is correct, Judge.
Which one?
Oh. The one that says one
Okay.
that says female search.
All right, well, they don't plan to use it anyway.
Correct.
Okay.
Okay, so that's excluded.
All right.
Okay, thank you.
That's the problem. That's the problem. If we had not gone through this, they would have brought that up. They would have brought it up. Now they're not going to conveniently use it, but it's in the folder. If they had just dumped the folder onto the jury, they would have used it. This is craziness, man. This is so unprofessional. Actually, I don't think any defendant needs to take the stand personally. Oh, it's going to show up. We know it's going to show up. And they're going to be like, oh, my bad. Yeah, I don't see any reason why they need to. Now, granted, I think Brian Steele has alluded that Young Thug would, but I don't think they have to, personally. I don't know why they would need to. Because they're innocent? Right. Why do they need to? That's what they hired lawyers for. Why do they need to get up there and get discombobulated and say something ridiculous? Why? This is why I was saying before that the defense can't trust the transcripts. No.
All right. So then we've got the AT&T records custodian. There gonna be any issues?
I mean, Al Capone, he was a naughty, naughty boy.
Just subject to the foundation, Judge.
All right. And then we have Miss Latner's again, and within her folder, we've got, I guess these are
There you
new
go.
things that we didn't look at in that first time around earlier today.
Yes, Your Honor.
Okay.
In order to try to reduce the amount of time Ms. Landers comes back, when she comes up at this particular time, we're going to try to enter in a few different CADs.
Okay.
911 calls.
All right. And has everybody looked at those? So if you've got any kind of objections like we had this morning, you can raise them. Although I've got to say, pretty much all of those things we went over this morning are kind of evidence 101 that you'll ought to be able to agree to.
Wow.
Not saying you have to, but any chance y'all might take this next group and see if there are actually some legitimate objections to those? Because we know it's all hearsay, but if we also know it's clearly covered by an exception, maybe we should not make those objections.
Your Honor, the state's more than happy to meet with any defense counsel, or we can talk after court, or they can email me and we can, before tomorrow, at least speak with one another and hopefully come to some agreement.
I mean, that would be great if y'all could at least try. And certainly there were a couple where, okay, this is not sure. Is this something based on the CAD that an officer's saying, or is this what the caller's saying? Those are legitimate. But I mean, a caller calling 20 seconds after a shooting saying, here I am, and I just woke up to hear all these shots. That's coming in, because there is a clear hearsay exception to that. So just see what y'all can do on that. And if you feel the need to go ahead and put forth the objection to each of them, then that's fine. We'll go through it. But, I know everybody's talking about how long this case has taken, and we could cut it a little bit shorter if we didn't do things like that. So I will let y'all talk about those over the evening. And we will circle back on Miss Latner. So does that cover everything that was in the counts 3 through 7 folder?
Yes, Your Honor.
All right. All right, where should we move to next?
We can go through counts 14 through 23.
Okay. All right, does everybody have that one open? Okay, we'll just go in order.
One second.
Okay, no problem.
Just waiting for it to it's
Sure.
buffering.
It's always hearsay, yeah. I'm not really certain at this point. I'm feeling Doug Weinstein. I'm feeling him. Hand on his head, like, what in the world's going on?
Okay, Judge, we're ready.
Okay,
The first folder doesn't have anything in there, Your Honor.
All right. Are y'all ready, Ms. Westmoreland? Are you still? Okay, so we are now looking at the counts 14 through 23 folder. All right, and we're moving to item 45 in there, or the one labeled 45. Okay. And that is an audio call between certain people.
Yes, Your Honor. So this is a jail call that we litigated last 45 Tiana Stanley. 45 Tiana, Tianna Stanley, Stanley.
Okay.
Your Honor, this is a jail call between the victim in this case, Gary Holloman, who is now deceased, a co-conspirator, Tanquarius Mender, and Tanquarius Mender's mother, Tiana Stanley. We did litigate this, I believe, in October of last year, and it was admitted based upon that litigation.
Okay. Anything else on that?
Your Honor, it was just for the record, the court admitted it under 807 residual hearsay exception.
Interesting.
And it was admitted over our objection, my objection. This was a jail call, and the deceased was having a came on to the call at the behest of the inmate and the inmate's mother, Ms. Stanley. And that person came onto the call, had a conversation on a recorded jail call, and our position was that there was no establishment that the deceased, Mr. Holloman, had a very close relationship with either Tiana Stanley or with the inmate, and we objected on that basis. We did not believe that a jail call was a trusted conversation, that it was done on a public recording that was subject to a public airing, and that there was no establishment by the government that there was this trusted, close relationship that is typically required in an 807 setting, and that and for those reasons, as the court is aware, 807 residual hearsay is like the Hail Mary of letting evidence in when there's no other recourse, no other way that it can come in, so forth and so on.
And it happens sometimes when people die. All right, is there an order that I can look at?
Yes, Your Honor.
So this has not come in to the trial itself at all yet, is that right?
It has not, and there is an order, Your Honor, and we can forward that to you.
And also, Your Honor, just from the standpoint of Mender, who's on this indictment as well.
Okay.
So we would argue that, well, it was admitted under the 807 exception to the hearsay. We obviously don't believe that it would be anything that would come in under any type of co-conspirator theory or anything of that nature as it relates to Mender, who is on the indictment. It's not furthering any conspiracy or anything of that nature. If we were looking to, if the state were saying, hey, it should come in because Mender's a co-conspirator or something of that nature. So it only came in under the 807 basis.
All right, was that an argument that was made and addressed?
No, Your Honor, we addressed it solely under residual hearsay.
Okay, well, if y'all can, I mean, if you want to just like let me know the date of the order, y'all gave me that binder full of motions and orders, so I can find it not during court time. I can do that this evening and let y'all know.
And I'll tell you, Your Honor, the order, because there were several things we argued during that hearing. There was a 911 call, there was a body cam video, and it was this jail call, Your Honor. And the court excluded the body cam video. And I believe the order primarily addresses the body cam video and not necessarily the 911 and this jail call.
Do I then need to look at the transcript from
Yes.
that? Okay. Do you know what date that was?
It was November, I think it was November 3rd, but I'll pull it up just so.
Okay. All right, well, we'll come back to that one. November 3rd of 23. Okay.
Your Honor, the order was filed on November 16th
Okay.
of 2023.
All right. And do you know whether that transcript's been filed? I can always check with Miss, I'm blanking on her last name, Christina Weaver. Okay, it's fine. I'll just check with her. All right, so let's just move to the next folder, I guess. So Officer Kornbacher or Kornbacher?
Yes, Your Honor, there's nothing.
Nothing, okay. Sergeant Henderson?
Your Honor, Sergeant Henderson was the detective on this particular case with
Okay.
respect to these acts. And the court has excluded his participation with respect. He had two primary roles with respect to these particular acts. One was to do the photographic lineup. And
Right,
the
and
other was to
that's-
conduct
can't
the
be in,
interviews.
yeah.
So I think that subject to that ruling are in this particular folder are basically
All right,
photographs.
let me just ask the state, what all do you intend to use from this folder?
They don't know. They don't know.
It would be the, again, some of these pictures. are
Can't hear you.
Some of the pictures are duplicative, Your Honor.
Okay.
We've put in here Mr. Huey's statement. I don't think at this time we're going to use it, but we did just place it in here as an abundance if we decide to. I don't think we're going to be using his statement. And the MP4 is, and it should not come up, but the MP4 is I guess on iPhones, I'm not an iPhone user. They have, you can scroll the text messages and see all the text messages. And so the last MP4 were text messages between our victim in the case and the detective, because our victim lived out of town. And so he was communicating with the detective about the robbery and providing information to him via this chat.
Yeah.
So potentially can come in as impeachment depending on what happens with my victim. If my victim says something inconsistent.
Chad is in
This
trouble.
not
Watch
the
out.
dead victim. This is
No,
a different
sorry.
victim.
Sorry, totally different victim. I apologize.
This is not Mr. Holloman. This is
Mr. Maynard. No, this is Mr. Maynard. So this
Maynard.
shouldn't be in this folder. This actually should have been in another folder.
Mm.
All right.
Another
So,
mistake.
okay.
This video is from the 2019 armed robbery.
Okay, it's
I
just in
thought
the
so.
wrong folder, but that victim is going to come testify and you might need to use the text as impeachment. Okay.
And I should also be clear, Sergeant Henderson ironically was the lead detective on both the 2019 armed robbery and the 2020 armed robbery.
All right. So is there anything in this folder that y'all intend to use? I mean, obviously that is just accidentally in there and you'll use it as to a different topic, but how about with regard to the, I guess, armed robbery of Holloman?
No, there's nothing in this folder that we intend to use.
All right. Thank you. All right, so then we've got Investigator Belknap. That folder's empty.
Yes, Your Honor, and I just realized when Mr. Huey was arrested for the October armed robbery initially, there were items found at Mr. Huey's apartment that belonged to an individual by the name of Chandler Durham. I do not see those photos in here, so I need to add them, but they're in discovery.
Might be in a different folder.
They have been served. I see the videos in some other folders, but I'll make sure that what we intend to bring in through Investigator Belknap is placed in this folder.
And that was a search that was not, I mean, that
It was a search.
items can come in.
Yes, and Your Honor, it becomes relevant because in one of our acts, which is act number 102, we have alleged as an overact a text message between
Overt
Mr.
acts
Williams
coming
and
in.
Mr. Huey, where Mr. Williams demands Mr. Huey to take his shit back, and his that he is talking about is Chandler Durham, and so all of that becomes relevant.
Okay.
So we'll make I'm sure the court will anticipate certain objections at that time. Again, there are a lot of assumptions that are being made with respect to what it meant in the context of it, which I don't believe a detective is going to be able to, other than speculate, be able to know precisely. So we'll deal with it.
Okay.
And I don't believe Mr. Chandler Durham is on the state's witness list, I don't believe.
He was on our original witness list, but in an effort to cut down on witnesses, he's not on the reduced witness list. He is not.
Okay. So I assume there'll be something that establishes that these were his items?
Yes, Your Honor. Yes, we have pictures of items similar to what was found. We have pictures of Chandler Durham with items that were found. Yes, and we also have the 911 call from the Chandler Durham armed robbery.
Where he says, these are the items that just got stolen from me.
Nope.
He talks about being robbed. I don't know if he says it on the 911
Well,
call.
y'all, I mean, I don't know if you might need to put him back on your list, because think about, what they're gonna hold you to your proof on everything. So
Yes.
there's gonna be an objection if you don't have a way to establish that the
Great job
items
coaching.
found in the search of Mr. Huey's home are in fact the items that were stolen from Mr. Durham.
Yes, we're working.
Good job
I think we had
cooking.
worked through it that we could get around it, but
Well, we'll see.
we're working through it.
Okay. I don't know. All right. Investigator Flores.
Your Honor, based on your ruling, the next two folders, based on your ruling yesterday regarding the fleeing and attempting to elude, 49 and 50, we don't have to look into.
Okay. And then Bernie, is this anything that's different from what we looked at before?
Yes, Your Honor, we had Mr.
This is his second, more recent work he did? Okay.
No. So Agent Bernie, for several of the cases, analyzed phone records.
Okay.
So he just analyzed Mr. Huey's phone records relating to the October 1st, 2020 armed robbery.
Okay. Any issues about anything in that folder? Mr. Matthews?
We're good. No objection.
Okay. Thank you.
Yes.
All right, so that takes us to the end of the 31 through 60 folder.
No, I think.
No, I'm sorry. Sorry. Looking at the wrong thing. What was that?
So the next one we have, Your Honor, is counts 27 through 29.
Right. That was within the 31 through 60. That was 14 through 23. Okay. So now counts. What'd you say was
27 through 29.
okay? All right, we've got several items in the Smith folder. Anybody want to voice objection to any of those items?
Your Honor,
Yes, sir.
I'm having a tough time seeing which video I'm talking about, but I do know from my review of the discovery regarding this act, there is a FaceTime live or some sort of live stream of Mr. Beebe smoking marijuana, talking, saying absurd things, and I don't believe Mr. Beebe's going to testify. So I would object to I don't know what the relevance is of that. I know what the relevance is if he was on trial. He's wearing a chain that allegedly belonged to quote unquote trap commander, whose government name escapes me for the moment, but he was the alleged victim of this armed robbery, and he was the person with the chain. But I think a still shot from that
Okay.
live stream could serve the state's needs in that respect.
All right.
Robbery, we've alleged that two of the co-conspirators, Durante Beebe and Christian Eppinger, armed rob Mr.
I'm sorry. Say those names again.
Durante, Derontae, last name Beebe, Bebe, and Christian Eppinger.
Okay.
I
just didn't hear who you said next.
They
ahead.
they robbed Darius Smith in broad daylight at Cleveland Avenue Park, and some of the videos that we have are of Mr. Beebe and also sometimes Mr. Eppinger holding one of the items that they stole. And so these are some of the videos. We will go through and narrow down which
Okay.
of the videos that we will intend to use for
Okay.
that.
All right. Well, let's if y'all can do that tonight, and then we'll circle back on that tomorrow.
Your Honor, there is another video, and I know I've heard it, I've seen it, but when I was going back through this folder, I don't see it in here, where Mr. Eppinger is essentially bragging about the armed robbery. I'm going to look for it again, and then I will make sure everyone gets that video as well.
All right, and then next in this folder is the folder that is Adrian Ansart.
He's the custodian records for Instagram, and so it's just the Instagram return to his folder.
And then we've got Sergeant Pierre or Jean-Pierre.
Yes, Your Honor, he is the lead detective.
Okay, assume that. So there, I see photographs. Would those be like crime scene-ish things?
Yes, Your Honor.
And then social media, is there anything we need to look at within that? Anything objectionable?
That will be some of the stuff we're going to reduce down tonight.
Okay, all right, we'll come back to that also.
Okay, so the question is, why is
All right,
it?
and then the lineup ID. That I guess is there going to be a victim to testify to that, or?
Yes, the victim will be
So the
present.
question was,
Then
why is it, basically, why is the defense is kind of letting this happen? This is basically pre-trial work. This is what usually happens before the jury even is seated. But because Glanville ran such a poor court and had such just out of control, look at Weinstein. Weinstein's exhausted. Look at him. He is like done. But anyway, so my understanding is they really don't have a lot of this stuff in order. So they're literally taking this time to get it in order so that they can be effective once the jury comes back and the jury's in the box and the defendants are in court. So I hate it like this. So this is just such a, I call it horse trading, but it's just such a boring back and forth. But that's why this is happening. It really is the court's fault and the state's fault. It's not the defense, it's not the defendants. It is the young lady here in blue and Judge Whitaker or Judge Glanville, whoever you want to point finger at. All right, let's finish up.
Mender,
Mender, all right. Any objections? All right. And then Vivarito.
Yes, Your Honor, that should primarily be the phone dumps or cell phone extractions for Mr. Huey.
Okay.
And then there is also a video visit with Mr. Huey, Mr. Williams, and Mr. Mender. And I just want to make sure that there are three, there should be 3 cell phone extractions.
Yeah.
So I just want to make sure there are 3. I see 2 of them, Your Honor, so I want to make sure there is a third one that was, no, I think all 3 are there. So there's the 1 of
Looks
2,
like it.
2 of 2, and then there's the third one.
Okay.
And then we have some screenshots, but there might be more screenshots that we'll provide.
All right, and then there appears to be another PowerPoint. Y'all don't intend to use that, do you?
No, Your Honor, this was a PowerPoint that was used for grand jury, but it's something that we serve.
All right. And then I don't know what that last thing is in there. It's not a folder. It says iPhone 11 Pro Max.
I believe, Your Honor, that is the cell phone dump just in 2 places.
Okay.
I just want to confirm.
All right. So does that carry us through that whole, through witness number 60, or do I need to go back and?
It does, Your
Okay.
Honor. Some of our numbers are a little off just because we had a few different lists, but this is all the 60.
Okay.
And then we intend to provide the last group of individuals to the end, the last witnesses to the end on Monday. Your Honor.
Was that the deadline I gave you? Or did I give you a deadline?
I don't know if you gave us a deadline for
Man,
the last group.
who
but we
cares?
were
You
doing
ain't
it
gonna
on
hold them
Monday,
to
so
it.
We just figured.
Okay.
It's time for.
That's
another
fine.
Monday.
All right, so that'll be 61-ish through the
Yeah, that's
end
more true than
of
false. Yeah.
Yes.
your witness list.
Yes, Your Honor.
All right, so then that would leave us tomorrow looking at
Thanks,
a
James.
couple of things we set aside for today. And then, I mean, at some point we need to get to the wiretap stuff. So tomorrow then would be the day to do that because we have a free day tomorrow. We need to utilize it. Okay? So we'll break early today, but with the understanding that everybody needs to be ready to tackle the whatever is within that wiretap evidence tomorrow, as well as we'll circle back on the CAD reports after y'all have gotten a chance to get together, and then on the couple of things from that we just discussed that you might be able to narrow down. All right, anything anybody needs to bring up, put on the record before we adjourn for the day?
Oh, here we go. Let's see what happens.
Okay.
Let's see, 11th hour.
All right. Yes, there is.
And I don't know if Mr. Adams can do this or we need to wait for Mr. Steele. Mr. Steele did provide to us the Dropbox link with some reciprocal discovery.
Mm-hmm.
We know that there's some jail calls. There are a number of jail calls that Mr. Steele gave to us. If he could just narrow down which jail calls he intends to use. I believe this is with Mr. Copeland so we can just know if we have any objections to it. Objections to it, but just
Look at Harvey Weinstein. Look at Doug Weinstein.
Still was working on that today.
Look at him.
Well, great. Hopefully he can get that to the state by the end of the day.
I'll relay that. Yes.
Okay. Because obviously Copeland's cross is hopefully coming up before too much longer.
See, she didn't say Monday.
So
She doesn't say Monday.
That may be the first thing we need to take up tomorrow.
Can I inquire, Ms. Hilton? I know when we left off with Mr. Copeland last week, we were almost done, I think.
I mean, yeah, sounds like we've got a little bit more of that
I told you.
video still to get through since we didn't really get anything done Friday afternoon because of tech issues, but.
A jail call, I think, if I remember correctly, Ms. Hilton.
yes, the goal
Mm-hmm.
will be to pass Mr. Copeland, if not early afternoon. That is the goal, by early afternoon to pass Mr. Copeland.
Understood. Thank you.
All right.
The goal.
All right. Doesn't sound like there's anything else. So I'll see y'all at 9 tomorrow.
Oh my gosh.
Thank you.
All right, we're gonna I'm gonna leave it up there just in case they come back. So they're calling it a game at 4:00, a little bit early. Tomorrow they got phone calls and establish what they're gonna do with Woody. Oh my gosh, what's happening with the camera? What is going on? And then tackle the cameraman. Cameraman's in trouble. All right, so anyway, they are doing some more horse trading tomorrow. They're going to determine what they're going to do with Woody. But then they still got Friday. So they got a lot of stuff that they can get done. Hopefully, they will iron out the state. Apparently, they got one more call, I thought it was, or the last bit of witnesses or something of that nature. I was kind of like phasing out. But anyway, what we do know is that the goal is to be able to pass Woody to the defense Monday afternoon. I think that's going to be translated as Tuesday because there's no way they're going to do it on Monday. They're just not going to. They've drugged this out this long. They're just going to keep dragging it. But I appreciate it. It looks like they're done. I'm gonna leave it up just in case they come back or something else. I don't know what happened with the camera though. That's wild. But I thank y'all so much. It's been a lot of fun. This has been an interesting one. I'm glad they're done with those videos. But the problem is they're gonna have to do those videos again when the jury's there. That's gonna be wild. So I think they really did cut the feed this time. They're done. Okay, cool. But I thank y'all so much. Tomorrow we're gonna be doing 9 to about 11, and then come back 3 to 6. So just take a break in the middle because it's just been long, and a lot of this horse trading. Yeah, I think all of us are starting to get frazzled with the horse trading. So we're gonna cut out some of the horse trading and allow you to go do your life and be alive and that kind of stuff. And plus, I got a recording at the studio tomorrow, so got to help do that. But I appreciate y'all so much. Thank you so much for commenting down below. Thank you to all of the moderators who've just been keeping this thing going, keeping it wonderful. My goal and intention is to finish up with tomorrow and see how Friday is going to go. We'll probably do the exact same thing, 9 to 11, then 3 to 6, and, give a little break in there, all that kind of good jazz. But keep an eye. You'll see the thumbnail. The thumbnail should be populating now or soon thereafter, but it'll be soon, if not already. And everybody, thank you so much. I appreciate y'all. Everybody new, everybody old, day ones or first days, it doesn't matter. I thank you all so much for hanging out with us, and hopefully we'll start seeing some progress on this trial, because I agree with Bitter Lily right here. They need to find Christ. So prayerfully they do. In fact, they will. In fact, I'm sorry. I'm laughing because you said the cameraman fell asleep, and I can kind of believe that would probably happen. Like, I'd be so bored it's fall over. But y'all, thank you again. I really do appreciate each and every one of you. Thank you for filling up the chat with all those good comments and all that kind of stuff. We'll do it again tomorrow. Everybody take care. Grace and peace.